The hearing will please come to order. Mr. Attorney General, we apologize for the short delay. The chair recognizes the Vice Chairman of the Senate Select Committee, Mr. Rudman, and I've been advised that he will share part of his time with Senator Cohen.
Thank you very much, Mr. Chairman. Good afternoon, Mr. Attorney General.
Good afternoon, Mr. Rudman. Senator, I wonder if I might just advise the chair. As I mentioned yesterday, I am prepared to remain with the committee or the committees as long as you may wish to be in session today. I do have commitments tomorrow that I previously advised the committee of, and will be willing to stay as late as necessary in order to finish today.
I appreciate your spirit of cooperation. We have been checking with the members of the panel, and it appears that we should be able to be out of here before 6 o'clock.
Thank you, Mr. Chairman.
Senator Rudman.
Well, I don't like to start off the day disagreeing with my chairman, but I hope we can be, and I will contribute to that, Mr. Attorney General, by attempting to go through some issues that I'm concerned about and try to ask the questions in a way that we can elicit some direct answers, as you've been giving yesterday, and hopefully not use all of my time. Let me start out by saying that I have had dealings with you for some time as chair of the State Justice Commerce Subcommittee of the Appropriations Committee. And I want to say at the outset, as I have said publicly, that although I have a great deal of trouble with some aspects of your investigation and the Justice Department's investigation, I think it is grossly unfair for anyone to infer or suggest that the Attorney General of the United States and the Justice Department was involved in some effort to cover up or obstruct the discovery of the true facts in this matter. I just want to start this examination by making it clear that is not my view. I've expressed it in strong terms to the contrary. Having said that, I want to go through a number of issues that I believe your answers will be very important for this record. I would start out by observing that you are, of course, the Chief Legal Advisor to the President of the United States.
That's correct.
And when you were brought into the Arms Initiative in January '86, you were brought in to give legal advice on the initiative as it was requested. Is that correct?
Yes, sir.
And you gave advice, I believe, on two legal issues that were raised by the arms sale. Am I correct?
Yes, Senator.
And one issue was whether or not Congress could be delayed under the timely notice of the Hughes-Ryan, and the other was whether arms sales could be done under the National Security Act rather than the Arms Export Control Act. Am I correct?
That's correct.
When you gave those opinions, according to your testimony, you didn't ask anyone at the Department of Justice to do any additional legal research for you on those issues. Am I correct?
That is correct.
And your reason, as stated yesterday, was that you did not ask anyone to do that research because you thought the matter was too sensitive to share with anyone in the department. Is that correct?
What I said was that it was so sensitive that it was my understanding that that knowledge of this was to be limited to those people essentially who were in the group advising the President at the time and those that were absolutely necessary in order to carry out the initiative in other departments.
Was that some limiting factor that was given to you by someone at the White House?
I'm not sure whether it was explicitly stated. It was certainly implicit in the fact that even in the group that met with the President, not all the members of the National Security Council were included.
Well, I understand that, but knowing your department fairly well and knowing of the people in it and the high degree of professionalism of those people and some of the people, in fact, you have an intelligence section, if you will, within the department, I just don't understand why there were not at least one or two of your bright young people, professional or political, it would make no difference, who you could have consulted to give you some basic research on the issues that you had to look at, which unfortunately were not researched.
Well, Senator, they were researched. I personally looked into them, and it's quite interesting to note that after this matter came to public attention in November of 1986, I did have them separately researched at that point by the Office of Legal Counsel in the Department of Justice, and the conclusions they reached after several days of research coincided exactly with the conclusions that I presented during that period in January of 1986. And I might say their research was independent of anything I suggested that they do.
Well, wouldn't you agree with me, Mr. Attorney General, that there are people in the Justice Department, professional people, that no matter how extraordinary the circumstances, can be consulted even on matters of utmost sensitivity to give an underlying research basis for whatever opinions the Attorney General of the United States gives the President?
Yes, sir, and if I felt that they had been needed in this instance, I would have brought them in.
I want to turn to the matter of the DEA agents. I believe in May or June, and I might say, I wonder, have you seen Mr. Lawn's interview given to this committee?
No, sir, I have not.
You're aware of the interview?
I'm aware that he had an interview with the committee. I have not had a chance to read the transcript of that interview.
Was it furnished to you, do you know?
I don't believe it's been furnished to me. No, I've seen it in Mr. Lawn's hand. I've never had a chance to actually read it.
But the department does have a copy of it.
I think the DEA has a copy. No, I'm not sure, Senator. Actually, what I saw were notes that were taken. What I saw in someone's hands as they were discussing this with me were notes taken by someone who was with Mr. Lawn. I have never seen a transcript of Mr. Lawn's interview, and I don't know whether the department has one.
I would simply observe that there are no major inconsistencies between his interview and your statement. And the reason I want to say that, if you haven't seen it, is I understand your natural caution in making statements, not having seen other people's recollections, but there are no basic inconsistencies. But I just want to go through that because obviously what this committee was told is somewhat different from, I think, from the circumstances that they were related to you. Now, my understanding is that in May or June of 1985, you approved a request from the National Security Council to detail 2 DEA agents to NSC for a mission relating to the hostages. Is that correct?
What was the year?
May or June of '85, I believe. Am I wrong? Do I have a date wrong here? Oh, I think that's right. That's '85.
I don't recall. I recall Mr. Lawn talking to me in the latter part of 1985 and early '86 about DEA agents assisting with providing information to those who were involved in trying to obtain the release of the hostages. I don't have any particular basis to fix a date earlier than that.
Well, do you have a recollection of a discussion with either Mr. McFarland while he was National Security Advisor or Oliver North regarding this issue?
I do remember. I'm not sure about the date. That's what's troubling me. But I do remember very vaguely that there was a discussion at one time with, I believe, Colonel North relating to his desire to have DEA agents who were working in the Middle East provide what assistance they might to the group that was interested in trying to obtain the release of the hostages.
Well, did you get the impression from that briefing that, as I believe, if I understand your previous statements, that this was an intelligence matter that they were dealing with as opposed to an operational matter?
It was primarily intelligence and support utilizing assets which DEA agents had in the Middle East.
Were you informed at the time of your briefing on this, either by Colonel North or Mr. McFarland, that in fact there would be extensive operational aspects of this and there would be private funds involved in the implementation of the plan?
I don't believe that I was ever informed that the DEA agents would be involved in what I would describe as operations. It was my understanding they would be involved in intelligence and support functions rather than operational functions.
I believe that is consistent with Mr. Lawn's statements to the committee. Now, in light of that, we would have to conclude that the information that you were furnished concerning their activities did not accurately or fully describe what in fact they were going to do and in fact did. Is that not correct?
Well, I am not acquainted with what precisely they did. And I might also say that this gets into a very sensitive area even at the present time. There are still activities ongoing in regard to our hostages. And yesterday morning, as a precaution, I talked with the Assistant to the President for National Security Affairs to verify that fact. So anything that would relate to details of operations that were previously conducted which may be still continuing or which may be comparable to things still continuing, I believe should be taken up in executive session. I'd be happy to do that.
I had no intention of discussing the operations whatsoever. I just was asking whether or not you were aware that these were operational in nature, and I think your answer is no.
Not what I would define as operational.
There was an executive order in existence at that time, 12333, and Directive 159 under 12333. They were issued by the President, both of them. I assume you would agree that if in fact this was operational, as this committee has evidence that it was, that someone, certainly not you, were not in a position to have the facts from our evidence, but someone should have sought a presidential finding or an approval from the President. Am I correct?
That is correct. There should have been a finding, and indeed there may have been one. I'm not sure.
We have no evidence that there was. Did you ever give any instructions to Mr. Long of the DEA or the agents pertaining to the use of appropriated or non-appropriated funds? Were you present at any time when that might have been discussed?
I don't recall any occasion in which the subject of appropriated or non-appropriated funds was discussed. It could have been discussed in my presence, although I don't recall it at this time, or it could have been discussed perhaps in documents I saw, but in any event, I don't have any recollection of that becoming an issue at any time or being presented to me as an issue.
Well, I think what we could observe, since the committee is largely involved in process, that's what the hearings are truly about, is there are some lessons to be learned in terms of the kind of information that the nation's chief law enforcement officer was receiving from people in the National Security Council, and that the head of the DEA was receiving from the head and one of the deputy at the National Security Council, referring to Colonel North, as to things that they wished you to do that you were not fully briefed on.
I agree, Senator. As a matter of fact, when the committee makes its recommendations, I have a number of thoughts along these lines that I would be happy to share with the committee at an appropriate time, because I think one of the things that would contribute a great deal to what I talked about in my opening statement as far as improving the cooperation between the branches and improving generally the way in which sensitive projects are carried out is if there were a more rigorous set of procedures which would provide for Department of Justice participation in the formulation as well as in the approval of any covert activity, and particularly one, of course, as you suggest, in which DEA, a branch of the Department of Justice, might be involved. I also think that there are other techniques, including a clear provision, in case there's anybody is in doubt, that findings should be in writing, and that findings should be circulated to the necessary members of the NSC, obviously in a way in which would protect their classified nature, so that these can be reviewed with the kind of research you discussed earlier prior to a meeting in which a person is going to be required to give an opinion on that.
Well, you testified yesterday that you totally reject the notion that you told anybody that there was such a thing as a mental finding, and I assume you affirm that today.
Well, I assume there can be a mental finding, but it's not something that I believe is either, should be, certainly, the basis for proceeding as though it were a finding within the meaning of the statutes you're talking about.
In other words, what you're saying is that a president may decide that something ought to be done and advise people, but it's got to be formalized if the statute's to have any chance of working.
I agree with that, and I think that is the view also of our president.
I want to turn to another subject, the whole question of the money and the diversion. Although there is an independent counsel now investigating the criminal aspects of this case, there is some amount of money in some Swiss bank accounts. We estimate 8 million, maybe slightly more, that will be a matter of some contention, and I assume eventually will be a civil matter for the Department of Justice. I want to just take you through some of Admiral Poindexter's testimony, General Meese, and I'm going to summarize it, but I think I'll summarize it very accurately because I've got the transcript here if you'd like to look at it.
I wonder, Senator, if I might just interject one point,
Sure.
Because you raised the 8 million in Swiss bank accounts. There's been a lot of contention about this in the press, and that's why I appreciate this opportunity to make one point, and that is that during that phase of this matter, when prior to the appointment of an independent counsel, the Justice Department did take steps to freeze whatever assets might be in Swiss bank accounts, and we are continuing to work with the cooperation of the independent counsel, portions of our department that are working directly with the independent counsel to maintain that situation so that those assets presumably would be available at such time as a civil suit would be appropriate in a way that would not jeopardize but would complement what is being done by the independent counsel.
And I assume you agree with me that that is a matter which is truly within the department's jurisdiction, not within the scope of the IC in terms of recovering those funds if they in fact should be recovered. That is a civil matter, I assume.
It's a civil matter. We're prepared to do whatever is necessary. We don't want to interfere with what the independent counsel is doing. The independent counsel is authorized under the statute to become involved in civil as well as criminal matters, and this is a matter in which our people are carefully coordinating with the independent counsel.
Let me just run through, because as the nation's chief law enforcement officer, I think it's important with some of the testimony we've had here, some of it rather bizarre in my opinion. I would just like to...
I trust that refers to testimony prior to yesterday,
it
Senator.
Does. So far. Admiral Poindexter testified that government officials approved each arms transaction with the Iranians in advance, that the government officials approved all non-price conditions of the arms sale, that government officials knew of the price being paid to General Secord for the arms before each sale, and the General Secord was expected to sell the weapons only to the Iranians. He further agreed that General Secord was, in effect, although he is not a lawyer, but in general parlance, an agent of the United States. That is his testimony, the highest-ranking official of this government who was involved in this transaction. Do you believe that all the money paid to General Secord, less appropriate expenses that now remains, belongs to the people of the United States and should be returned to the Treasury?
Well, Senator, without, again, having all of the facts other than what you have said, and taking what you have proposed to me as a hypothetical situation based upon the testimony you've received, I would say that as a general matter, it is highly probable that those funds should be, on a constructive trust theory or agency theory, property of the United States.
Do you have any current thoughts as to whether any other laws or laws, period, were violated by the diversion? I would suggest two possibilities. The Anti-Deficiency Act, which I'm sure you're very familiar with, and the Miscellaneous Receipt of Money Statute, which is 31 United States Code 3302B.
Senator, I think it is possible that those laws may be applicable. I'm reluctant to make a statement for two reasons. One is to say that a crime has been committed without full possession of the facts and the ability to relate those facts to the statute is something we generally don't do in the Department of Justice. And number two, this whole matter is under investigation by the independent counsel, and I would not want to have my viewpoint prejudice what he is doing. I'm sure they will be ultimately answered by the investigation that he's conducting.
I assume you'd agree at the very minimum, and I understand your position, and it's a proper one for the Attorney General, that at the very least, that probable cause exists to look closely at those two statutes in light of the events that this committee and others have uncovered.
It does, and as a matter of fact, that was uncovered in our own inquiry, because on Monday, the 24th of November, I asked our lawyers who were familiar with the facts to look into the same subject that you just raised to see if there were applicable statutes. They raised some of those same statutes, and that was the reason why this was turned over to the Criminal Division for a criminal investigation to commence on the 25th of November.
Thank you. I'm going to turn now to the Evans case, a case that you referred to in your opening statement. You're familiar, I assume, with the case generally, although maybe not all the specifics.
I'm familiar with the case generally, Senator. I also am somewhat precluded from commenting on an ongoing litigation that is now taking place in the courts. But as to the general perimeters that you may want to ask about, I will cooperate as much as I can.
I want to talk about the public record on it, that's all, and there is a public record. You referred to the Evans case in your statement. You didn't name it, but that, of course, is a case involving the sale of arms by, the alleged sale of arms by individuals to the Iranians. Am I correct?
That is my understanding of the case.
And I want to just preface the next few questions with the remark that I guess you would agree with, that just because the United States had a policy supported by findings to sell arms to Iran for whatever reason, that does not exculpatory of individuals selling it for profit. We can agree on that, I assume.
Yes, sir. As a matter of fact, there are wholly different sections of the laws relating to private activities and those activities engaged in lawfully by agents of the government.
Yeah. I have a problem with this matter in terms of the administration of this case, which I think is illustrative of what happens with this, and I'd like to read something to you and see if you can explain it to us. You were asked by one of the defense counsel, the Justice Department, questions about whether or not arms sales had been authorized to Iran. That was a defense motion. The U.S. Attorney in New York asked the department, because Mr. Giuliani had to make pleadings. Mr. Giuliani, one of the most outstanding United States attorneys in this country, I'm sure you'd agree. When you found out that that particular sale had not been authorized, it was passed on to the U.S. Attorney in New York that they could make a declaration to that effect. Now, the thing that I'm troubled with is that in the pleading in the United States court up in New York, this statement appears. This is an answer filed by the United States in response to a defendant's motion. I want to read to you one paragraph. It says, obviously, we intend to produce any documents indicating that the proposed transactions, those that are a matter of that lawsuit up there, that the proposed transactions were in fact sanctioned, or that the foreign policy of the United States during the period of the conspiracies as charged in the indictment was to permit the shipment of U.S. arms to Iran. So far, so good. Then this sentence. At this time, we are aware of none. Now, at the time that this was filed in the United States District Court up in New York, September 16th, 1986, or slightly thereafter, obviously the arms initiative to Iran was known. So essentially, we had a statement here that the United States Attorney in New York, relying on information from Maine Justice, was filing that was false. Would you comment on that?
I have not seen that document, Senator, and it would have to look at, I would have to look at all of the aspects of it, but it's certainly the proposed transactions were not authorized, and I would have to know the context in which that was filed in order to say that it was in fact false. Certainly nothing that was said by the department, to my knowledge, would have given the U.S. Attorney's Office in New York a basis to make a statement such as that, inasmuch as the only information that was provided that I know of by the department, certainly by my office to the criminal division, was that this specific transaction was not authorized.
Well, I'm not going to spend a lot of time on it, General Meese, but let me simply say that when you look at this, and I'll make sure you get a copy, and I would like to have you comment for the record, because I think it's a serious matter, although not directly involved here. There is no question when you read it and read the pleadings, you will agree with me that that statement stands on its own four legs. And it says, at this time we are aware of none. I get very concerned about United States attorneys being put in the position of making affirmative misrepresentations to courts.
Well,
and I'm sure you are too.
I suspect I'm even more concerned about it than you are, Senator.
I hope so.
And this is the kind of thing that may well be an error in language was made by an assistant U.S. attorney, but I'd have to look at it in order to make that judgment, and I will appreciate receiving a copy.
Let me move on to the Casey meeting. I want to start out by just making an observation based on some of your comments yesterday. Now, I think it's important for this record to say something about the evidence on Mr. Casey. You testified that Colonel North advised you that only 3 people in the United States government were aware of the diversion: Colonel North, Admiral Poindexter, and Bud McFarland, who learned it pretty far along into the transaction. Is that correct?
That is correct.
Mr. Admiral Poindexter testified that he did not know that Casey knew about the diversion. You're aware of that testimony, I'm sure.
I am now that you've told me. I did not see that myself.
As a matter of fact, he's expressed some surprise because he had told Colonel North not to share that information with anyone. Both of those events took place while Mr. Casey was still alive. I'm talking about the Admiral's knowledge in his mind that Casey didn't know, and Colonel North's discussions with you in November of 1986. The only evidence that this committee has before it that Mr. Casey knew about the diversion was Colonel North's testimony here, which was several months after Mr. Casey died. Mr. Casey, it is my understanding from your testimony, denied to you that he had knowledge of the diversion before it was disclosed. Am I correct?
Yes, sir. He told me, and in my presence, he told then Congressman Wright and a group of people gathered at the White House the same thing.
Well, I just wanted to clear that record. I mean...
Well, I'm glad you did, Senator, because Mr. Casey, in my opinion, was one of the most honorable men that ever served the government and served the people of the United States. And I think that the fact that he is not able to defend himself means that the record should not contain an assumption, necessarily, that at any time he was not telling the truth or lying when he made the statements that were made in various fora that I've discussed. Mr. Casey was, as I said, a person that I would believe without question, and I think that under the circumstances I appreciate very much your bringing this up.
I think it's important because it will be a matter which will be in dispute in our report, I am sure, but I just find it curious that the only time we have this statement made is after Mr. Casey is no longer around to discuss it. Now, we know that Mr. Casey had numerous meetings with Colonel North, 35 at Langley by count of our staff and others that we're aware of. But I think that it's important that the state of that evidence be known. I want to ask just a few questions about that meeting that was covered yesterday. It's my understanding that just a few hours before your meeting with Casey, you learned about the diversion, what we call the diversion memo. Is that correct?
I learned about it, yes, sir.
And I think it's fair to say that you were shocked when Brad Reynolds told you about the existence of it.
Yes, sir, I was.
Matter of fact, your very able assistant, Mr. Cooper, described your comments with some politeness and said that you exclaimed something like, oh gosh, or something like that. Oh darn, I think he said.
I think that's close enough.
You thought it was pretty significant.
Yes, sir, I did.
I mean, it raised a whole line of new issues in your mind.
It certainly did.
When you got to his house that night, he told you, of course, about the Furmark conversations, which indicated that there might have been some Israeli involvement, some U.S. involvement. Am I correct?
Well, he told me really the bulk of that conversation was really about the Canadians and these money lenders and what they were griping about to Mr. Furmark, and that they were threatening to go public with this thing and even commence a lawsuit. That was the principal subject, and he also indicated to me, I believe at that time, that he had some documents relating to that he would send me.
Well, he also, I believe, told you that the Canadians were claiming that money from this transaction had been diverted to other U.S. and Israeli projects. Is that correct?
Well, not in as many words. What he said was that Mr. Furmark had told them that as a means of pressing their claim, they would even say that monies had been used for other U.S. and Israeli projects. And it was clear to me that what Mr. Furmark had said to Mr. Casey, as he related it, was not that Mr. Furmark believed that had happened or that Mr. Casey believed that had happened, but that they were going to use that as leverage to try to get the United States to pick up the difference in what they felt they were owed.
I think that's precisely right. I think that is exactly what occurred, and here's my question that flows from that. Didn't you draw a connection at that point between this memo, which had really shocked you and your associates just a few hours before, and here now you're hearing a story about other uses or diversions, if you will, of U.S. funds? Did you make a connection in your own mind at that point?
I didn't make a connection in the sense of saying this must be connected, but rather I put in my own mind, I said this was going to deserve further investigation after we find out what the so-called diversion memo was all about itself and whether, in fact, that had happened.
But you chose, for reasons you explained yesterday, not to ask Casey about the specific diversion that you were aware of.
Yes, sir. I chose not to talk to anyone about that, actually, until we learned more about it, found out what we had, and then went into it in a systematic way rather than in a casual way.
Well, let me just give you a problem with that, and I'd like you to respond. It's
Sure.
a problem that others have. Seems to me there's a fundamental conflict in that, and it may be a conflict because we don't understand your state of mind at that point. Hindsight is 20/20, but even giving it that, you claim that, and I believe you, that you had not thought of this as a criminal investigation, even at that point, I take it. Is that correct?
That's right. It was not a criminal investigation at that point, and at that point we didn't even know whether this memo accurately portrayed anything that had happened.
If it wasn't criminal then, it was something else. It was political. It was just a problem with a capital P, but it wasn't criminal.
I would call it a fact-finding inquiry to determine what in fact had happened in the implementation of a governmental policy.
Well, all right.
Administrative in nature rather than criminal.
I'll accept that, and if it was not criminal, and it was administrative, and you were trying to find facts, the thing that some of us have difficulty with is, since you weren't worried about anybody involved in a crime, why didn't you ask your close and trusted friend, Bill Casey, that, listen, you've heard this story about Canadian investors, let me tell you about something that actually happened, we think. Why didn't you do that? And ask him right then and there. That, of course, is very puzzling to many people.
Well, I'm glad you gave me the chance to answer that, Senator, because it certainly isn't puzzling to me. I have gone into complex fact-finding inquiries before. I've spent a good portion of my life as a lawyer doing those kinds of things. And one of the things you do is that you follow particular leads and get the information on those leads before you start asking people who are not otherwise involved about them. And that was what I was doing on that occasion. Even, as I mentioned yesterday, even as close a friend as Mr. Casey, I felt it was better to find out all that we could know with the person who, to our knowledge, would probably have the most information about it, in this case, Colonel North, before I started talking with Mr. Casey about it, or Secretary Weinberger, or any of the other people who might possibly have information.
Yes.
To announce that a vote is now pending in the House of Representatives. This will explain the absence. They did not run away from you.
Thank you, Mr. Chairman.
Mr. Attorney General, I have a couple of more areas to go into. I want to talk about the North interview. At the end of that interview, you showed Colonel North the memoranda, and you asked him several questions about, or you and your associates did, am I correct?
That's correct. Actually, it was in the middle of the interview, roughly. It was after about an hour of discussion.
And one of the questions that was asked is whether or not there was a cover memo that indicated some approval of some kind. Am I correct?
Well, that came up in the course of the question that was asked as to whether the President knew about this or whether this had been shown to the President. And he said, is there a cover memo? And I understood what he was talking about, because the memorandum that we had at that time was not the kind of thing you would give directly to the President. It was the kind of thing that might be attached as an addendum to a decision memo to the President. And of course, we said that no such cover memo had been found.
And of course, at that point, you asked him whether there were any other files that might contain
Yes.
those memos. Is that correct?
That's correct.
Do you remember what his response was?
I believe that he said he didn't know, but he would check, or words to that effect. But that was really in regard not to files that were of the type we had seen. I was asking him whether there was a separate file kept by the National Security Council staff of approved policy documents where the President had approved them. I thought that there might possibly be a file of presidential memoranda where, once the President signed off on it, it was kept separate in a more secure environment than, say, normal routine memoranda such as the ones we saw. And I say routine meaning the process, not in terms of its content.
I want to get to that point right there, because at that point in time, there were several things that existed that, in the minds of some at least, were major alarm bells that were going off, that maybe this wasn't just the matter that you thought it was. Number one, you certainly had enough evidence in the few days before this that some strange things were going on in terms of statements that people are going to be making to the Congress, people in the State Department saying that statement is not right, people telling you things which subsequently, and Mr. Cooper, which subsequently turned out to be, I will say, if not true, certainly misleading. So that you certainly had some concerns at that point that some things were going on down there that didn't make much sense. Is that a fair observation?
I would say, as I did yesterday, that we had concerns that there were differences in recollection that should be resolved. Yes.
There were some major differences in recollection. We're now talking about something where obviously you've either got a cover story or you've got somebody with a terrible memory who's confusing oil drilling equipment with missiles.
Actually, what we had, Senator, was a situation in which different people who were in different parts of the world had differing recollections, which were easily explainable in terms of the fact that the people who couldn't remember particular things or remembered them differently were occupied in probably the biggest event in the history of the presidency, namely President Reagan's meeting with the General Secretary of the Soviet Union. And to me, it was entirely understandable that they didn't have pinpoint recollection or even general recollection. I have been in similar situations with the President, and quite frankly, the big event shuts almost everything else out of your memory.
Well, that may be.
So those were the reasons why it didn't seem particularly strange to me, but it certainly did raise issues in which there were differences of recollection that I felt ought to be resolved.
Well, if that didn't set off a loud alarm bell, certainly the diversion must have set off sirens.
No question at all that it did.
Now, at this point, you've got Colonel North, who's a can-do fellow who is carrying out orders. He's sitting in your office, and he tells you that he will try to find some things for you. I just asked
No. I asked him the question. I didn't ask him to find anything.
Well,
I asked him the question, is there a separate file of presidential documents? He said, I don't know, I will check. We didn't leave it at that. I sent my people over to talk with Admiral Poindexter the next day to see if there was such a separate file.
That, but he obviously indicated he would check on it. You didn't ask him to do that, but he said
he would. That's what he said, I will check.
Right, I understand that.
But we certainly didn't leave it at that. We went ahead and found out for ourselves whether there was any such separate file.
My question's a simple one. In light of what we now all know, even if the conflicts in memory were just that, they weren't, of course, but they might have appeared to be, and then you found the diversion memo. Didn't you have any concerns at all to let the fellow who was in the center of this back to where all those records were in terms of your fact-finding investigation, even assuming it was not yet a criminal matter?
Well, Senator, none of the people who were there had any such concerns, including myself, and one of the reasons we didn't is we had already been showed all the records. Our people had completed their search and their review of all the records that had been given to us by Admiral Poindexter and his people.
Of course, you know what happened thereafter from testimony. I believe you know.
Well, I understand that there was some shredding, although I do understand that most of the shredding had been done prior to our people even getting on the premises, and most of it had been done certainly prior to the meeting with Colonel North.
Well, there was some left, evidently, because we have White House records supplied to us by the Secret Service that show that Colonel North went back to his office that night sometime after his meeting and was there until roughly 4 in the morning. And that when one of the secretaries came in the next morning, the shredder bag was full. So I dare say there might have been something there that you might have found interesting.
It may be that there were, I don't know. Did the committee, when they talked to Colonel North, ask him what documents he did in fact shred?
I don't think Colonel North had a clear recollection of what documents were shredded. I think there were so many that were shredded over a period of time that some of them were, I'm sure, legitimately part of the national security files, and others, of course, we'll never know, and that, of course, is one of the major problems. I guess I'll get to this question, then reserve the balance of my time and yield to my friend from Maine. I want to ask you what I think is probably the single most important question that we can ask you, which is one that none of us understand, and if you can explain it to us, we'd be very grateful. By the morning that it was decided that Colonel North and Admiral Poindexter would be relieved of their posts, although you had major portions of the story, to your credit, there were many things that you didn't have. You didn't know how much money was involved from the people who were involved with it. You didn't know who the agents were. You didn't know who else in government knew. I could go on. One thing came through loud and clear from both Admiral Poindexter and Colonel North, no matter what else you might want to say about their testimony. It was clear, at least to me, that they were very loyal to this president, and they were very loyal institutionally to the office of Commander-in-Chief and the president. And what we have a hard time in understanding is, I understand the pressure, but we're talking about maybe 1 or 2 more days. How is it that the president, through his Attorney General, or the president directly on your recommendation, did not get these 2 people into an office at the White House before they left, before an independent prosecutor, before you even thought it was a criminal matter, and asked to write not a chronology, but a report on who did what to whom and when and how it was paid for? Why didn't you get the whole story? That would have foreshortened our job, Mr. Attorney General, by a matter of months. And obviously, there might have been facts disclosed at that time that we still don't know. That's my question.
Well, Senator, first of all, we did know much of the things you've mentioned. We did know how much money was involved. Colonel North had told us that he thought that there was about that there had been in this one particular situation about $12 million involved, and he felt that that had happened 2 or 3 times. That was the basis for my estimate during the news conference, that it was somewhere between $10 and $30 million that was involved. So we did have the word from Colonel North already at that time as to how much money was involved. Secondly, as to who the agents were, Colonel North, in his description of what he had told us, and we had no reason he would change that on further questioning, indicated how this had happened. I related that yesterday, and indicated that he was the one who had worked with the Democratic resistance forces in setting up of bank accounts and who was doing the different actions. And thirdly, he had already told us, had Admiral Poindexter, who in the government knew, so we knew exactly what their story was on those points. So I think those are all reasons why we knew a great deal at that time. But to go on, at that point there was no doubt in my mind that it was in fact a criminal investigation that wouldn't be needed to ensue, and therefore we did bring the criminal division, or the criminal attorneys and the FBI into it immediately, and they would have been the ones to question both Admiral Poindexter and Colonel North, and by the time they were prepared to do that, of course, they had gotten attorneys.
Well, that may be, Mr. Attorney General, but I would submit to you, having great respect for the criminal justice system, as I know that you do, that under these extraordinary circumstances, that 2 members of the armed forces, a Rear Admiral and a Lieutenant Colonel, both with distinguished military careers, with all that you have said being so, would have been able to tell their Commander-in-Chief anything he asked them. And I'm just surprised that someone didn't put them into that situation and thus avoid the country much of the agony. For instance, had we had a statement from Admiral Poindexter in writing, signed and witnessed, as to what he told this committee, dated the 25th of November, I dare say that we wouldn't have any lights in here at all.
Well, the interesting thing, Senator, is that what he told this committee when he was here was exactly what he had told me in terms of the President's knowledge or anyone else in the White House.
But of course, by the time he left the White House, that statement was unavailable to this committee.
No.
Oh, yes.
I'm saying that he told me exactly what he told the committee. So suppose he had said to anyone else 2 days later what he told me on Monday the 24th, how would that have made any difference?
I think a great difference would have been if we had from Admiral Poindexter before he left the White House and Colonel North a written description of what they did and what authority they had, and I think that there was an obligation to do that to the President. Let me just wind up.
Senator, let me also say that the President could not have ordered them to do that without reading them their rights under section, I believe it's 31 or 32 of the Uniform Code of Military Justice. A whole different set of circumstances had come into play by that time than what we had when I talked with Colonel North and when I talked with Admiral Poindexter on the 23rd and 24th.
Well, I agree.
People have even made the statement that I should have read him his Miranda rights. Well, obviously there was no reason to read him his Miranda rights at that time, but by the 25th there certainly was reason to read him his Article 32 rights, or Article 31, as the case may be, under the Uniform Code of Military Justice.
I think all things being equal, and taking Colonel North's testimony that he would, quote, literally stand on his head if ordered by the Commander-in-Chief, that it would have been a good time to have a little history made and have them read their Article 31 and 32 rights. I think that this matter was so important that the President of the United States was entitled to all of the facts from his two subordinates before they left the White House, criminal charges notwithstanding.
Well, and Senator,
that is my view.
Well, in my view, Senator, is that we had all of that information before they left the White House, and that not one thing that has been said since that time by Admiral Poindexter, and only in the case of Mr. Casey, has it varied from what we were told on that Sunday and Monday.
Well, you would agree, I expect, with Secretary of State Schultz, who said that at the time that all of this was happening, the people that were advising the President, he was not speaking of the Attorney General, he was speaking of the people in the NSC, had a kind of a built-in conflict of interest, that they were hoping that the great communicator would bail them out. You would agree that the President was not well served by his people when he was trying to make a forthright statement to the American people. Not only wasn't the President dealt with very accurately, but you were not dealt with, it seems to me, in an open and direct way. Would you agree with that?
I think there were instances where that occurred, yes.
Thank you, Mr. Attorney General. I will reserve the balance of my time.
Senator Cohen is recognized for 30 minutes.
I think the record should show that the equal division of time by the chairman and the vice chairman of the committee is really on New Hampshire mean time. I appreciate Senator Rudman for accommodating me. Mr. Attorney General, yesterday I was a bit confused initially with Mr. Van Cleves asked you several questions calling the investigation a fact-finding inquiry, and on a couple of occasions I think you indicated one time you were asked to assemble facts, and then you in the same paragraph said a factual overview. I assume that you associate this with a fact-finding inquiry, your investigation from the 21st of November through the 25th.
I consider my activities a fact-finding inquiry,
Okay.
Also a factual overview, and also a review
They're
of facts.
all the same thing.
All the same thing.
Okay. I was curious, on January 7th of 1986, you apparently were brought into the meeting that occurred in the White House pretty cold.
Yes,
I think
sir.
you've indicated that you may have had a meeting the day before. You've been apprised of that, but have no recollection of that. But as of January 7th, you were brought in and asked to give an opinion as to the wisdom of going forward with this so-called Iranian initiative. Is that correct?
Well, I wasn't asked to give an opinion in that sense. I was asked to participate in the discussion, and I was asked to concur in some legal views.
Did you not indicate that you favored the initiative going forward?
Yes. I was asked what my opinion was, as were others there.
Isn't that an opinion?
Well, yes, but not in the sense of being a sole
No, I
person to give
understand.
an opinion. But as one of a group in a discussion, yes, my opinion was asked
Right.
during the discussion.
All I'm getting at is that you were brought in, and this is the first time that you had any information concerning this. You were not aware, for example, of the conversations that Bud McFarlane had back in July of '85 and August of '85. You were not aware of the decisions in September or October pertaining to the shipment of Hawk spare parts. You were not aware of the December 7th meeting, even though your record, you thought you were there. You were not, in fact.
No, I never thought I was there.
Someone apparently thought you were at that meeting, and
Well, only people who didn't know what was
Right.
going on,
So
because
you
I knew very clearly I was in Vienna on the day of that meeting.
So you were not there at that time. So you had no basic background in this entire initiative prior to January 7th.
That's correct.
Okay. And you're called upon to, as a member of the NSC as such, to give an opinion as to your judgment as to whether we should go forward at that time, correct?
That is correct.
You were aware of Operation Staunch that Secretary of State was very much concerned about in terms of trying to persuade our European allies and others not to sell weapons to the Iranians?
Yes, sir, I was generally aware of it.
And the Department of Justice also, I think, had a fairly active anti-terrorist program that it was promoting.
Very definitely.
What was it that led you to decide in favor of going forward under those circumstances where the Secretary of State and the Secretary of Defense were vehemently opposed to the sale of weapons to the Iranians as part of this package?
Well, there were several things, Senator Cohen. I've described it since that time as a 51-49% type of judgment, which could have gone either way. The principal things that were involved were, first of all, the statements that had been made to us, I believe by Admiral Poindexter, that the Israelis had talked to them about the fact that there were elements within the factions in the Iranian government that were willing to develop a channel of communication with the United States. I had been very much concerned as a member of the National Security Council studying that whole region about the Soviet threat to that region and about the high probability that any continuation of the Iran-Iraq war could create a vulnerable situation in which the Soviets would be able to capitalize on what was happening in that region. Secondly, we were very much concerned about the way in which events had turned since 1979, that what had been a rather staunch ally of the United States in that area was now an implacable foe, and it was a great desire on my part, as it was on many there, to develop a means of establishing an improved rapport for the future with the government that either might follow the Khomeini, which someday that will have to happen, or any other change in the government that might take place.
You had no prior discussions about the need to change the relationship with Iran and the United States? Oh, you had?
Well, this had happened on many occasions going back to 1981, when we had overviews of the geopolitical situation in the world.
But all of those came back negative in terms of trying to establish a relationship based upon any transfer of arms.
Well, I don't think the subject of transfer of arms had ever been brought up. I think it was a matter, rather, of the desire to have an improved geopolitical situation. I think that also we were all concerned about the Iran-Iraq war and what that was doing, and indeed, had that initiative been successful, we might not have some of the problems that we're having today. There was also the aspect of terrorism, and there was representations made to us at that meeting that this particular element within the government was trying to lead Iran away from support of or participation in terrorism. And finally, and this was certainly a factor, there was an indication that these elements did have some influence upon the Hezbollah or other forces in Lebanon that were holding our hostages, and that as a means of obtaining their assistance in trying to get the release of those hostages, this would be one aspect of the total initiative. It also
that was a consequence then? It was a
No, that was a part of the initiative. Right. That was one of the signs of good faith, but also one of the possible results, or anticipated results, actually. And furthermore, it was described to us that we would be involved only with small quantities of defensive weapons, which would not alter the balance or contribute particularly to increased terrorism or to affecting the war through the weapons, as opposed to affecting the war through the activities that this particular element would engage in. Those were the factors that I had in mind when I agreed with the Assistant to the President for National Security Affairs and the Director of Central Intelligence that on a close call, I thought it was worth trying.
And I believe at that time you indicated that you recalled the William French Smith opinion in terms of...
Well, as to the means, yes.
Right.
That the question was asked to me, would it be, Bill Casey, I believe, said to me, as you know, this can be done through the National Security Act rather than the Arms Export Control Act, as Bill Smith's opinion indicated, and I remember very clearly because there had been quite an NSC discussion of that whole matter in relation to another situation in 1981.
Okay, so Director Casey raised the William French Smith opinion?
Yes, sir, he did.
And then you recalled that?
I recalled that very clearly,
You didn't
yes.
have to look at the opinion to
No, I recalled
it.
the opinion very well because I had studied it very extensively back in 1981 when it was first issued.
Didn't the opinion also contain the following language? In order to satisfy the congressional reporting requirements imposed on the Secretary of Defense under DoD Appropriation Authorization Acts and on you by the Intelligence Oversight Act of 1980, the House and Senate Intelligence Committees should be informed of this proposal and the President's determinations?
Yes, sir, it did.
That wasn't applied in this particular case,
Well,
though.
that was a separate issue. Then the issue was raised at that meeting on the 7th. Can the President, or it was, I think everybody there was in agreement that the President should delay notification of Congress, and I was asked, is this legal? And I said, I believed it was under the provisions of the National Security Act, but I would want to check that by reading the statute. And in fact, I did.
Yesterday, you indicated that in your judgment, at least the way in which it was portrayed at that time, that you contemplated and everyone else contemplated a period of roughly 30 to 60 days during which time the hostages would be back. As soon as they were on board a ship in the Mediterranean, Congress would be notified.
Well, yes, sir.
Right.
Actually, aboard a plane was what I had understood it to be, but and that it would be a relatively short period. Although, while that was not definitive in terms of this, it certainly made it easier to come to the conclusion that timely notification could be delayed.
How would that further the relationship with the Iranian moderates if we were to, within that 30 to 60-day period, get all of our hostages, assuming that we could, put them on board either a plane or a ship, notify Congress, run the risk, as everyone was concerned about this leaking, and consider having a long-term relationship with the Iranians? Wouldn't that totally wipe out the so-called first channel or later the second channel if, in fact, once we get our hostages back, now's the time to notify Congress and run the same risk of leaks that we were unwilling to run before?
Well, I think two things. First, it certainly would not have posed a risk to the hostages, and that was one of the risks. And secondly, I think that having had that successful aspect of it, that it was less likely that we would run those risks. Certainly the Iranians could be much more removed from the situation than to be directly involved in sensitive negotiations with the Hezbollah.
Mr. Attorney General, I just want to make the point again that I think that the administration has overstated the case in trying to hold out the fear of a leak coming from one of the leadership, either the House or Senate, on this issue, that it would jeopardize the lives of hostages. I think it's clear from the record that we are entrusted with many, many covert actions that certainly involve the risk of lives. It involves many more millions of dollars that were involved in this particular case, and yet the Congress has been trusted. And I would venture to say that I think the reason that we were not to be entrusted with this operation, number one, because it was an express contradiction to the public policy adopted by the administration, namely trading weapons with the Iranians, and number two, that the administration was so deeply divided. But I am struck by the notion that somehow Congress could not have been trusted with this information about the transfer of weapons to Iran. When I look down the list of those who knew, we have Gorba, the Iranian, who has been described as a professional or pathological liar. We have Adnan Khashoggi, who's an international financier. We have Mr. Furmark, and we can talk about him in a moment. We had two Canadian businessmen. We have Rafael Quintero, Mr. Neer, Mr. Nimrodi, Mr. Schwimmer, Mr. Ledeen, Mr. Kleins, Mr. Secord, Mr. Hakim, but not Bob Dole or Robert Byrd, and not Lee Hamilton or Dick Cheney, or not Speaker O'Neill or Bob Michael. And that really troubles me.
Well, Senator, I can only say as an observer, because I can share your concern, and quite frankly, the one thing I am convinced is that in the President's mind, and certainly in my mind as well, this was the delay in complying with the timely notification requirement was solely out of concern for the jeopardy of the hostages and the elements in Iran. The other aspects, whether there was a divided administration or whether there was some policy differences that might have come from this, certainly was not a consideration in my mind, and I'm sure it was not in the President's mind. I also would say that I think personally that there should be few, if ever, instances, and this was one of the very rare instances, where this administration has not immediately or provided prior notification. I've been present, for example, in the Grenada rescue effort, where those same officials you mentioned were brought down in my presence, and I think it is a very rare thing that would happen. And that's why that's why I'm convinced that in the mind of the President, rightfully so, in the mind of others there, this was such a rare situation that also key people within the administration were not even notified. So it was not in any way a slight, I don't think, a deliberate slight of Congress as opposed to the administration. I think most of us Most of us are as much concerned or more concerned with leaks in the executive branch than we are with the intelligence committees or the leadership of the Congress. And I assure you that it is my own view that notification of Congress is not only important from the standpoint of complying with the provisions of the law, but also is the best way to have support for these kinds of initiatives, whatever they might be. I might say that this administration, of course, was not alone. The previous administration, on I think 3 different instances, used the same technique of delaying timely notification.
Not 14 months delay that I'm aware of.
I don't know what the delays were. I just know there were those instances.
When did you first learn about the off-the-shelf self-sustaining fund that was designed for the use of other covert activities?
I'm sorry, I don't
The
understand.
off-the-shelf self-sustaining fund that was to be set up by the sale of American weapons to the Iranians through the so-called agents or middlemen, inflate the price and use a portion of the price to go to the Contras and other operations. When did you first learn about that?
I would think that you're talking now about the diversion scheme as we've
Well, beyond the
come to know it
diversion
here.
scheme, I'm talking about that fund that was sitting over there in a Swiss account, which had funds for other projects that Bill Casey mentioned to you about the allegation coming from Furmark and Canadian businessmen dealing with other American-Israeli projects. When did you first learn about that?
Bill Casey never talked to me about any fund. All Bill Casey told me on the evening of the 22nd of November was that these people were threatening to say that money had been used for other projects. As far as a fund in terms of what you talk about off-the-shelf funding and all that sort of thing, I don't believe I learned any of those details to the extent I know them until these hearings commenced and a great deal of that information was portrayed here.
Fair to say that if such a fund were set up, that it would require notice certainly to the President and to the Congress of the United States if covert activities were to be carried out using those or any other funds?
Yes, sir.
Now, according to the testimony, Director Casey, Colonel North, Admiral Poindexter, and even members of this committee, some members of this committee, thought the diversion was a fairly neat idea. And it struck me that, after all, this is the ultimate covert hat trick. We tricked the Ayatollah, we tricked the Sandinistas, and we tricked the Congress itself because we ended up using funds for a program which it thought it had prohibited. And I was wondering, what's wrong with that particular arrangement? What is basically wrong with it?
Well, I think for one thing, using funds in a way, if it were illegal, to deceive the Congress. First of all, I think deceiving the Congress in any way is not a good idea.
I agree with you.
And I think that that's one of the aspects. I think that, again, there are some things that have to be done in a covert manner, but again, the processes of notifying Congress and obtaining congressional support of the leadership for these things is very important.
But you knew intuitively that the moment the question of diversion arose, that there was something wrong with that.
Absolutely. I knew that it was unauthorized, and I knew that it was a violation of the implementation of the President's policy. I also knew that it had a tremendously adverse impact, or potentially an adverse impact, on the very thing that was trying to be helped, namely assistance to the freedom fighters in Nicaragua.
Would you agree that the Economy Act was never designed to allow a transfer from a U.S. government to a third party, but rather the Economy Act was designed to allow transfers from the Department of Defense to the CIA? We don't want to have one department making a profit at the expense of the other, but there was never any intent to allow U.S. taxpayer-owned property to be sold under the Economy Act at an inflated price so that the profits could be used for something else.
I'm satisfied that that's consistent with the intent of the Act, yes, sir.
Could I inquire, Mr. Attorney General, why did you advise Colonel North to get an attorney as of Friday, which would have been, I think, November 21st?
I did not advise him to get an attorney.
You did not?
No, sir.
Okay.
I have no recollection of ever talking to Colonel North about getting an attorney.
All right, because at that point there was no reason for him to get an attorney, was there?
Not that I knew of.
As far as you were concerned, everything had been authorized. As far as the sale of weapons to the Iranians, the President had signed off on that. And as far as the covert activity or secret activity with the Contras, that was expressly or implicitly adopted by the President. So there's no wrongdoing there.
So far as I knew, there was no reason for him to get an attorney, and indeed, I never, as I say, I don't recall ever having any conversation with him whatsoever about getting an attorney.
I was curious in response to Senator Rubman's inquiry about the diversion situation. About the only consistent testimony we have is the nature of the expletive you used. Everybody recalls exactly what you said when you were finally confronted with that diversion. It's very clear, all of the people involved know what you said. But something obviously changed in your mind from that point on. It was no longer simply a sort of a fact-finding inquiry on a civil matter. Something went off in your head. I think you used the word a siren. Senator Rubman said sirens must have been going off, and you agreed.
Well, I agreed that it was a wholly different situation than when we started with at noon on the 21st of November.
And it became so on Saturday after you talked with Director Casey, more so, because then you learned about the so-called Canadian businessmen seeking to perhaps extort money out of the United States.
No, I honestly didn't think that that had any particular relation. I didn't think that that necessarily had any connection.
Right.
There was nothing that Mr. Casey told me that would indicate that it did, although it was worthy of coming back to and looking at later on to see if there might be a connection. And quite frankly, when I got the documents the following Wednesday that related in much more detail, again, there was no connection.
You certainly found a connection as of Sunday afternoon after you talked to Colonel
Yes, sir.
North. Now, at that point in time, hadn't, in your vast experience as a prosecutor in California and elsewhere on the part of this government, at that point in time, once you learned from Colonel North himself that indeed a diversion had taken place, didn't that click in your mind that now we had the potential for the violation of criminal statutes?
We had the possibility of criminal statutes being violated, or at least the potential for that, and that's why I indeed had people look in to see if there were criminal statutes.
But basically, though, it's no longer just a sort of fact-finding inquiry or oversight. Something went off in your mind to say, wait a minute, we've got a serious problem, not only about the diversion memo, but now we have it from Colonel North himself that funds were in fact diverted. So in your mind, at least, it's no longer just a sort of civil inquiry. You're leading up now, at this point, in your mind as a former prosecutor, that there is a very real possibility of a violation of an existing law.
Well, I didn't know of the violation of any existing law at that time. What my mindset at that time was that we had a continuing civil inquiry, but that there was a potential in the future for determining that it might have criminal implications, which in fact had occurred, or at least suspicions along that line, had occurred by the following evening, sufficient that we were able the next day to refer it to the criminal division.
I found it somewhat curious, Mr. Attorney General, that all of the evidence involving the presidential knowledge and approval of the Israeli transfers was either altered or shredded. Do you have any idea why such an effort was made to either alter the evidence or destroy it with respect to that transaction?
Well, obviously the presidential finding that was signed on the 17th of January is still in existence, and I believe the committee has copies of that.
Talking about prior to January 17th.
The prior, apparently, I don't know.
I mean, what is the problem? Is it because there was no finding? We know that the President believed he had an oral finding. Is it because it was retroactive in application?
I don't know. We found numerous documents relating to that. There were numerous memoranda
but they were
in
all
the
altered.
NSC.
They were all altered.
And why they were altered, I don't know.
To reflect that it was not a U.S. Either authorization or indeed almost no acquiescence. I don't understand what the effort was to portray this as somebody else's idea, and the U.S. had no connection at that time.
Well, I'm not sure that's correct, Senator. As the story was told to me in November by various people, including Colonel North, at that time, there was no hesitancy to acknowledge the United States involvement, and as has been pointed out here, Mr. McFarland even went to great lengths to indicate presidential involvement earlier rather than later at a particular point in his testimony. So I don't really know the answer to your question.
Yesterday, I interrupted Congressman Rodino on the Evans case, and I'd just like to clarify it for the record. My understanding is, and Senator Rubman raised this issue with you again this afternoon, that on Friday, November 21st, a staff meeting was held at the Department of Justice, during which time you were not present, that Mr. Weld argued that the criminal division should be involved because they were involved in the handling of the Evans case. That basically was the argument he presented to his associates.
No, I don't believe that's correct.
Well,
I think
let me finish now, and I'll show you.
Okay.
Then on Monday, apparently you placed a call to him to indicate, apparently the information had sort of percolated up to your level at that point, that Mr. Weld thought that it should be a criminal division investigation. And
No,
so,
that's not correct either.
all right. But you called him on Monday, is that correct?
That is correct.
All right. And you indicated to him at that time it was not an inadvertent oversight or error as to why the criminal division was not involved, right?
Actually, these are two separate incidents. Let me take Monday first. What I did on Monday was call him so that if he heard about an inquiry taking place in the department, he wouldn't wonder why the criminal division was not involved. And I indicated to him, as a matter of indicating to him, that we had in mind the criminal division. They hadn't been forgotten. And I may have even said, I don't know, I don't recall the specific conversation, but in talking with Mr. Weld about it and trying to reconstruct, I believe that I was assuring him that the criminal division might well become involved.
My time is running out, Mr. Attorney General. I just want to make a couple of statements and observations about this entire affair. It's obvious to many of us on the committee that General Secord and Admiral Poindexter and Colonel North are all rather bitter and angry toward you over the decision to go forward with the special prosecutor. And I think that they indicated they felt betrayed. And the question is why? Obviously because they felt they had authority. And according to their analysis, or at least recollection, there was an oral finding in August of '85, a December finding in '85, a January 6 finding, a January 17 finding, all of which authorized the sale of weapons. There was a secret supply of the Contras, had been long underway, and a couple of these key individuals were involved in helping to keep that particular freedom fighter movement alive. There was also a creative financing scheme that was utilized by the Israelis, and it was approved apparently by either Director Casey, but certainly Colonel North and Admiral Poindexter. And Admiral Poindexter believed that he in turn could read the telepathic wavelengths of the President. If the President had known, he certainly would have approved this. And then we had the disclosure in Beirut, Beirut newspaper on November 3rd, and that set off a series of activities that have become the subject of this investigation. And Colonel North, then under Admiral Poindexter, either direction or acquiescence, sort of stoked up the shredder. Actually, it choked up the shredder is the way it turned out, but the documents were altered. We had chronologies being constructed to so-called gild the President's record. And then on November 25th, you disclosed the revelation about the diversion, and that the fact-finding inquiry suddenly had a shift to a potentially prosecutorial one. And Admiral Poindexter and Colonel North and General Secord expected you to stand behind them because they thought the President was standing behind them, and that either you squeezed the sort of hair trigger under public pressure, or then you threw them overboard to save the captain of the ship. And so I find it somewhat ironic that the members of the President's action team are critical of you for making haste, and that members up here or elsewhere are critical of you for making haste too slowly. That's one of the many ironies involved in this. There's another one that I want to mention briefly. These hearings that we're conducting have been associated with another event that occurred back in the early 70s. I think Congressman Cheney has spoken on many occasions as to why this particular comparison is odious. But there's one superficial parallel that continues to taunt me a little bit. 15 years ago, there was a night watchman. His name was Frank Wills. I'm not sure many people remember his name. But he discovered a piece of tape on an office door, and that led to the disclosure and the unraveling of a surreptitious plan of political vindictiveness and even an abuse of presidential power. And in this case, we don't have a night watchman and we don't have tape, but we had an assistant attorney general and a small paragraph in a diversion memo. And had that paragraph not been either observed or preserved, then at least I think one could argue that we would not be here today. All reference to the authorization of the shipment of weapons by the Israelis in 1985 had been altered. The December finding with its retroactive provisions had been destroyed. The January 17 finding made no reference to prior actions, and only one draft memo survived Colonel North's shredding machine. Now, if there was no diversion memo, there was no evidence of wrongdoing. There'd be no money trail, no USS Enterprise, no firings, no need for an independent counsel, no tower board, no joint committee. Just a straightforward foreign policy decision by the President to open up a dialogue with the so-called Iranian moderates and get the hostages back in the process. So we could then be in the position of challenging the wisdom of the President's decision, but not his power to decide. Now, I'm overstating this just a little bit because I think the controversy would have continued to boil, and that the vigorous American press that is out there would have demanded and eventually discovered more facts and answers. But nevertheless, we have this situation. Some are always going to speculate that everyone who had approved the Iranian initiative had hoped that Colonel North would have had enough time to complete his search and destroy mission, and that Secretary Shultz would stand in what I would call a false phalanx that some tried to construct around the president in the name of loyalty. And when that didn't happen, the center could no longer hold, and the story couldn't be contained, not without compromising at least 2 additional members of the Justice Department. And what I want to say, Mr. Attorney General, is that whatever criticism any of us might have concerning the investigation, I prefer to believe that men and women who are regarded as, quote, ideologues do not allow their political views or values to obscure their personal honor. And Bradford Reynolds is someone who comes to mind. It took intelligence, I think, to recognize the significance of that diversion paragraph, and honor to preserve it, and I think honor for you and the President to report it. And one final point, I think perhaps a final irony, if I can. You sit before us today as not as an NSC member, not as a presidential advisor, but as the chief law enforcement officer of this country. And you hold this position, in my judgment, by virtue of the existence of a so-called special prosecutor law that a number of us on this committee had a great deal to do with writing back in 1978, rewriting in 1982, and rewriting again in 1987. And you took advantage of that law when criticism was leveled at you, and you looked to the special prosecutor to clear your name, and it did, and he did. And as a result of that, I think you're sitting here today as Attorney General. And I find it ironic because your assistant, Mr. Bolton, who sits behind you, has now vigorously criticized that law as being unconstitutional. I think it's clear that you and the attorneys general who have preceded you wear too many hats. Presidential advisor, personal friend, NSC member, chief law enforcement officer, and it's not clear to everybody else which hat you're wearing at any given time. And I think that's the reason why Congress felt it was important to write a law allowing for the appointment of special prosecutors, because we believe that the American people would not perceive or believe that our laws were being fairly and impartially administered when it came to passing judgment on high-level officials, including the President himself. Now, if we want to do away with the special prosecutor or independent counsel laws and restore the mantle of impartiality to the Justice Department, which it deserves, then I think it's time to stop the time-honored practice of appointing personal friends or indeed even relatives, and I'm thinking of Robert Kennedy, as attorneys general. Let the President appoint his close friends as White House counselors, but let him pick a person recognized not only for his ability but impartiality as the chief law enforcement officer of this country, and then we can abolish all of the independent counsel laws. Because if we insist that the FBI director be a person of high and independent caliber, then I find it indeed ironic that we would have tolerated over the years the practice of his superior being viewed as a political figure and a personal friend of the President rather than the institutional protector of justice in America. And frankly, I have no illusions that this recommendation will be warmly embraced, but I don't believe that we'll ever restore the people's belief in the impartial administration of justice until we pick impartial people. Thank you very much.
Thank you, Senator. If I may just make 3 comments on your very eloquent statement. First of all, I am appreciative on behalf of myself and the other members of the Justice Department for your comments on the honor and integrity that was displayed in the investigation. Secondly, I want to make it clear that our department has not opposed the independent counsel law, but only is sought to work with the Congress to remove whatever constitutional infirmities there might be in the law so that it can go forward and withstand attack by those who are attacking it on constitutional grounds. And thirdly, I think that in regard to your suggestion as to the Attorney General, what you have said about the way in which we conducted the investigation, and without regard to the President, to people that we worked with in the White House or anything else, we did present the facts as we knew them, even to, as you point out, proceeding with seeking an independent counsel and initiating a criminal investigation, because that was the right thing to do, even at the risk of what you call the resentment of those who feel we should have done otherwise, quote, to protect the President, unquote. So I think that in itself is an explanation, if not a refutation, as to the position that I at least hold the job of Attorney General in, and the fact that, as Attorney General, as I said the day in which I was sworn in, regardless of who is involved, from the President on down, I'm going to enforce the law with integrity, firmness, and impartiality, and I think, as you have pointed out in your remarks, that in fact was done in this case. I thank you for what you said.
The chair is pleased to recognize the Deputy President pro tempore of the United States Senate, Senator George Mitchell.
Thank you, Mr. Chairman. I understand that I have 45 minutes, Mr. Chairman?
45 minutes, sir.
Right. Good afternoon, General.
Good afternoon, Mr. Mitchell.
When these hearings end next week, the committee will begin to prepare a report. And one of the problems we face is the conflict of evidence on several key points. How, if at all, can we determine credibility? You're in a unique position to help us. You knew most of the people involved, and you personally interviewed them in the course of your fact-finding inquiry. So I'd like to begin with a few questions about credibility. You said yesterday that former CIA Director Casey told you he knew nothing about the diversion. Your words were, and I quote you, "It was Mr. Casey himself who told me on Tuesday morning that he had known nothing about it." As you know, Colonel North told this committee that he had told Mr. Casey of the diversion, that he showed Mr. Casey a written memorandum describing the diversion, and that Mr. Casey knew in advance of the diversion and, in Colonel North's words, was enthusiastic about it. Now, those statements are in direct conflict as to Mr. Casey's knowledge. They cannot both be true. My question to you is, which of those statements do you believe? Mr. Casey's statement to you that he knew nothing of the diversion, or Colonel North's statement to this committee that Mr. Casey did know of the diversion?
Well, Senator, it's always hard to judge credibility when you've not had the opportunity to observe the witnesses yourself. And in the case of Colonel North, I was not here and did not see him testify. I saw an occasional glimpse of his testimony, but I could not really have the same vantage point that you had at that time. But let me say this, in judging,
well, if I may just interject, yes. You interviewed Colonel North at some length.
I'm coming to that.
And he specifically responded to that question.
I'm coming to that. I said, rather than judging the credibility of the individuals, but rather as to which statement is true, it seems to me that we would have to look at the statement that was given to me at the time that this matter first came out, when there was no jeopardy to the individuals involved, and at a time when Mr. Casey was still available to refute any statement that might have been true or untrue. And at that time, Colonel North said to me, without any question, that there were only 3 people in the government who knew anything about this: himself, Admiral Poindexter, and Mr. McFarland. And so it would seem to me, if I had to judge, that the statement given at that time probably has the most value as an accurate statement.
You're saying then that you believe Mr. Casey's statement to you?
I do believe Mr. Casey's statement to me, based upon that kind of a rationale, yes.
And you disbelieve the statement made later by Colonel North?
As I say, I'm not in a position to evaluate that, but it seems to be at odds with what he told me on the 23rd of November.
Right. Well, on the subject of credibility and statements to you, you interviewed Colonel North at some considerable length in your office.
Yes, I interviewed him for 2 hours. I was present during the 2 hours of the interview, and then others in my office interviewed him for about an hour and 45 minutes beyond that.
And Exhibit 47 represents notes taken by one of your assistants of that meeting.
Yes, sir,
now,
that is correct.
Colonel North told you in that meeting that an Israeli official, Mr. Rabin, had told him that Israel was shipping oil drilling equipment to Iran in November of 1985, and that he, Colonel North, later learned about the Hawks from General Secord. Are you aware that Colonel North testified here, contrary to what he told you, that he knew all along that the 1985 shipment to Iran contained Hawk missiles?
I did not know that until I've heard it addressed briefly yesterday and now in more detail by your statement.
Right. Colonel North told you, according to your recollection in the notes of the meeting, that Admiral Poindexter was totally innocent until after the fact with respect to the November 1985 shipment. Are you aware that Colonel North testified here, contrary to what he told you, that Poindexter was involved before the fact in coordinating the 1985 shipment?
I'm aware of it now that you've said
You're
that.
not
I was not aware of that
previously aware of
before.
that
No,
until
sir.
I've raised that with
That's
you.
right.
Right. Colonel North told you that Israel decided how much money would be diverted to the Contras and that U.S. involvement was none. Are you aware that Colonel North testified here, contrary to what he told you, that General Secord had control over the funds set aside for the Contras and other projects?
I'm aware of what he said here now.
You are learning of this for the first time?
General Secord, yes.
You're learning here for the first time what Colonel North said about General Secord's control over the funds?
Yes, that was not mentioned to us at all in November.
Have you become aware of it since then, or are you learning of it now for the first time?
I'm learning of it now from
For the
what you
first
said.
time? Right. Colonel North told you that the diversion of funds to the Contras was Mr. Neer's idea. Are you aware that Colonel North testified here, contrary to what he told you, that the diversion was Mr. Gabanifar's idea? Are you learning of that for the first time now? As I
Yes,
tell you
sir.
that?
I had not known that.
You'd not been aware that of Colonel North's testimony?
No, I did not follow Colonel North's testimony
That's
in
apparent.
detail, and
Right. Colonel North told you that the CIA had no knowledge of the diversion. As you know now,
yes,
since
he said very definitely.
Yes, you testified, as you know, Colonel North testified that, contrary to what he told you, that Mr. Casey knew about the diversion. You were aware of that prior to today?
Yes, sir.
Colonel North told you that Mr. Calero opened 3 Swiss bank accounts and that he, Colonel North, gave the account numbers to the Israelis so the Israelis could deposit arms sales funds into those accounts. You recall that statement to you by Colonel North?
Yes, sir.
No. Are you aware that Colonel North testified here, contrary to what he told you, that the funds to be diverted were placed in Swiss bank accounts under General Secord's control?
I'm aware of it now that you've told me, yes.
You had not previously been aware?
I had seen reference to this in the newspaper, I believe, in general terms, not in as much detail as you've explained it.
Well, when Colonel North made those statements to you, did you find him to be credible and did you believe him?
Yes, sir, I found him to be credible, and I did believe him.
Are you learning today for the first time that Colonel North's testimony to this committee was contrary to what he told you in several respects?
I have heard of this during the time that he was testifying from things that were told to me by people who had watched the testimony, by some of the news accounts, and but not in as much detail as you've explained them today, as to the fact that different statements were made before this committee, apparently, than were made at the time that Colonel North talked to me on the 23rd of November, 1986.
How do you feel about that? Does it bother you?
It does bother me that there is a discrepancy, and I can appreciate the problem of the committee in trying to determine which is correct and which is not correct. There is one aspect of it, and that is that when he made the statements before the committee, there were 2 things that were different. One is he was under oath, and secondly, he was under a grant of immunity. That may be something that will be of help to the committee in determining which statements are credible and which are not.
Well, of course, just a few moments ago, you argued that his statement to you regarding Mr. Casey should be believed over his statement to the committee because he was not in jeopardy at that time.
Yes, I'm just saying that there are different considerations. The other major difference is that Mr. Casey is not available to rebut his statement,
Well,
which I think is probably more profound than even immunity and oath.
Apart from what you call discrepancies, you're the Attorney General of the United States.
Yes, sir.
You're conducting a fact-finding inquiry at the explicit request of the President of the United States. Does it bother you that apparently you were told things that were not true, and therefore you yourself made public statements to the American people which turned out to be incorrect on the basis of statements made to you?
It certainly bothers me if statements were made to me that were untrue. Fortunately, the basic outlines that I revealed to the American people were essentially true and remain essentially true. The details as to what you indicate here, most of which I did not really talk to the American people about, remain the same as I talked about them on the 25th of November. But the fact that the more profound question you raised, that untrue statements were made to me by anyone, I absolutely find it a matter of great concern to me. I don't condone under any circumstances anyone lying under any circumstances whatsoever, including whether it's a fact-finding investigation, testimony before a congressional committee, statements to the President, or statements to me as Attorney General. And I think there's no reason, justification, or excuse for it whatsoever.
May we take it that you condemn such actions?
I do indeed.
Right. Thank you, General. Now, in your testimony yesterday and today, you've referred frequently to your notes that formed a significant basis of your recollection of the interviews that you conducted. Now, on Friday, Saturday, and Sunday, November 21st, 22nd, and 23rd, you interviewed Mr. McFarland, Secretary Schultz, Judge Sporkin, and Colonel North. On each of those occasions, a member of your staff was present, and that person took notes, and it is on those notes that you have frequently relied in your testimony here.
Yes, sir.
In your meeting with Colonel North on Sunday, he confirmed that a diversion had taken place, and he told you that Mr. McFarland and Admiral Poindexter were the only other persons in the administration who knew about the diversion. Now, I'm struck by the fact that on the following day, Monday, November 24th, you met briefly with Mr. McFarland and interviewed him again, and at that meeting, you were alone and you took no notes. Is that correct?
That's correct.
You next spoke with Donald Reagan, the President's Chief of Staff, interviewed him, and you were again alone and took no notes.
That wasn't next. Actually, I talked with Mr. Reagan late in the day on Monday the 24th.
When you did talk with him,
I talked with him and the President. I met with he and the President and did not take notes at that time.
I think Mr. Reagan's recollection is contrary to yours, but in any event, when you did talk with him and the President, it was you and them, and you took no notes again.
That's correct.
On Monday afternoon, you spoke with the Vice President, and you were alone with him and took no notes.
That's correct.
And later on Monday afternoon again, you interviewed Admiral Poindexter, and again, you were alone with him and you took no notes. Is that correct?
That's correct.
On the following morning...
Actually, the sequence is different. The Vice President was, I think, the last person I talked with on that evening.
Right. But in each of the meetings that I've described with Mr. McFarland, with Admiral Poindexter, with the Vice President, with the Chief of Staff, and the President, you alone were present and took no notes.
Well, when I was with the President and the Chief of Staff, there were three of us.
Yes, three of you, right. And the next morning, you visited Mr. Casey at his home on your way to the office. Is that correct?
Yes, sir.
And one of the note takers for you at the meetings Friday, Saturday, and Sunday was one of your assistants, Mr. Richardson. Is that correct?
Yes, sir.
Was Mr. Richardson with you in the car at the time you drove to Mr. Casey's home?
He was with me. He was riding into the office with me that morning, yes.
And when you went in to see Mr. Casey, you left Mr. Richardson in the car?
Yes.
And your meeting with Mr. Casey was again alone, and you took no notes of that meeting?
It wasn't a meeting. It was a quick conversation, yes.
In your conversation?
Right.
Yeah. Well, the result of that, of course, is that as to the interviews that you conducted on Friday, Saturday, and Sunday, your recollection has been supported and you have relied extensively on notes taken of those meetings. As to the critical events of Monday and Tuesday, there is only your undocumented recollection, and it does raise a question which I want to ask you. Is there a reason why at each interview you had up to and including the meeting with Colonel North, there was always another member of your staff present who took notes, but that with respect to every interview thereafter, you were alone and no notes were taken, or is that pure accident?
It's not totally pure accident. It's pure accident in a general sense, but they were totally different types of conversations. In the meetings that I had with Secretary Schultz, the meeting with Mr. Sporkin, the meeting with Mr. McFarland, the meeting with Mr. North, All of these are what you might call interviews where we were seeking to elicit a great deal of information and in which notes were important in order to record that information, which we were hearing in each case for the first time. The other conversations that took place were not for the purpose of eliciting great amounts of information. They were either casual conversations, conversations in which I was the only person present, for example, with the President and Don Reagan, in which I don't usually take notes in those quick meetings, or they were meetings in which I was seeing people like Mr. McFarland simply to confirm information we already had in the long interviews that had already taken place, and where just by happenstance, in that case it was accident that nobody was there because Mr. McFarland came in just as I was leaving for the White House. In the case of Admiral Poindexter, all I was trying to do was to confirm what we already knew, and he did in fact confirm it. Had he not confirmed it, for example, I'm sure we would have gone through the usual interview process with him and taken a detailed statement from him. Obviously, with the Vice President, the President, it's not normal in those conversations to take notes, and the same was true with Don Reagan, who I talked with, to my recollection, I think my recollection is accurate, after I had met with he and the President at 4:30, I went into some detail with him before going to the Vice President, detail in terms of what we were going to do the next day. And I think it was at that time that he again said to me that he had known nothing about this.
Well, giving you every benefit of the doubt, I think it's difficult to understand that you did not regard Admiral Poindexter, one of the 3 people in the government who is alleged to have had information about it, the President's National Security Advisor, as a person not sufficiently important enough to have an interview with, but rather a casual conversation.
Well, the reason that that there was no interview was that what he said essentially confirmed.
But you couldn't know beforehand what he was going to say, could you?
No, I was just trying to find out, because I had a very little time between the National Security Planning Group meeting and my meeting with the President. I thought it was important to confirm with Admiral Poindexter, the idea being that there would have been ample opportunity to go into a formal interview situation had that been necessary.
Well, I'll leave it at that and say it's really very difficult to accept. I'd like to
I don't understand why it's difficult to accept.
Well, Admiral Poindexter was a central figure.
Well,
and to say that
but everything
you didn't interview him,
everything that he told me was totally consistent.
But you could not have known before you talked to him what he was going to say. That's the very purpose of having someone there to record the meeting.
Well, that's right. But had he said anything differently than that, we would have had a more formal interview to get that information. I explained the circumstances of that I was literally rushed into his office to try to verify this before I was due in the President's office. And it may be strange to you, it may strike you that truth being stranger than fiction, but I take offense at the idea that it's hard to accept, because what I have told you is the absolute truth of what happened. And so if there's any question in your mind, I want to get that settled right now.
Well, no, I just said it's hard to accept.
Right.
I mean, that's
maybe
the way
hard
I feel.
to, as long as there's no question as to that being the truth, then, then I will accept your statement.
It's just very hard to accept. I mean, you didn't, for example, well, I won't go into there. There's so many questions that could have been asked. We can leave it at that. I'd like to turn to another question. That's the securing of documents. Now, you began your fact-finding inquiry on the morning of Friday, November 21st.
Actually, it was the afternoon of Friday, the 21st.
You met with the President late morning, I think, and began in the afternoon.
The inquiry itself started that afternoon.
Yeah. Almost immediately thereafter, sometime Friday, you made the decision to examine certain documents.
We made the decision to review the NSC documents to provide a basic documentary background for our fact-finding inquiry, right.
But the decision to secure documents was not made until the following Tuesday afternoon, as you testified here previously.
Well, actually, Senator, we followed the same procedure that you do in your committees. We made a request for the documents, and we expected that that request would be fulfilled, and indeed it was fulfilled the next day.
You in fact were acting in good faith, and you expected those with whom you were dealing to act in good faith.
That's absolutely correct.
Statement?
Yes, sir.
But unfortunately, as we now know, on Friday afternoon and late Sunday night, Colonel North shredded large numbers of documents.
We know that now some months later, yes.
Right. You met with Colonel North in your office on Sunday afternoon.
Yes.
You confronted him with the memorandum which made reference to the diversion.
Right.
You testified that he acted surprised. Mr. Cooper testified that Colonel North then asked if you'd found a cover memo.
No, he asked that in a different sequence. The way in which that occurred, we showed him the memorandum. We showed him the portion of it that pertained to the diversion scheme. We then, at some point during the conversation after that, he was asked, was this ever shown to the President, or does the President know about this? It was at that time he asked if there was a cover memo. And as I mentioned, I believe, in answer to either Senator Rudman or Senator Cohen's question, I understood what he was talking about, because a document such as the so-called diversion memo would not have been presented to the President as it was, but if it had been presented to the President, it would have had a decision memorandum or cover memo with it. And I understood him to be talking about that.
Right. I'll get back to that in a moment. I have some more questions about it, but I just wanted to go on. Later that evening, as we now know, and of course you could not have known then, at about 11 o'clock, Colonel North returned to his office. He was there until 4:15 the following morning, and according to his testimony and other evidence, he shredded many documents that night. He also shredded many documents on Friday afternoon after learning that lawyers from your office were going to be coming over there to review documents. None of us probably ever know exactly how many documents or what they were. Now, you said yesterday that looking back with hindsight is easy, that things look different now than they did 8 months ago, and of course you're right. But there really isn't any alternative, because a fundamental principle in our democracy is public officials must be accountable for their actions. And accountability necessarily involves review and evaluation of past actions. Every member of this panel goes through it whenever we meet constituents and are called upon to defend and explain past votes, past decisions, past statements. And so I'd like to ask you some questions on that, recognizing that there is hindsight involved and you could not have known all of these things at the time. The first involves a testimony by Colonel Earl, who was an associate of Colonel North, and I have his deposition, and I'd like to have somebody, member of the staff, take it down to you, because I want to read a portion of it and then ask you whether the conversation alleged in this testimony did occur. This is Colonel Earl's deposition, and that at page 65, which is the first page you have there, beginning at line 15, Colonel Earl is describing a meeting he had and a discussion he had with Colonel North on that Friday afternoon, November 21st. And this is Colonel Earl speaking. He says he, meaning Colonel North, mentioned that he had said to the Attorney General, or asked the Attorney General, can I have or will I have 24 or 48 hours? He didn't say both, he said one or the other. I can't recall whether he said 24 or 48, but he asked for that. And he told me that the Attorney General had said something like that he didn't know whether he could have that much time, something like that. Again, I'm not quoting. And then it goes on to describe further the meeting. My question to you is, did you talk with Colonel North on the afternoon of Friday, November 21st?
I do not believe that I did. To the best of my recollection, I did not.
You can recall no such conversation?
I can recall no such conversation, no, sir.
Right. Either in a meeting at the White House or anyplace else, or a telephone conversation?
I don't believe I attended any meeting at the White House on the afternoon of the 21st. I also do not believe I had a telephone conversation with Colonel North, and I am sure that I never had any conversation such as that, which is depicted here.
You would remember it if he'd asked you something like this.
I believe I certainly would, yes.
Right. And so you did not have any such meeting. Now, on the securing of the documents, it is with hindsight, but a reasonable case can be made that the time at which preservation of documents should occur is the time when inspection of documents occurs. That is, if it's important enough to look at documents, it ought to be important enough to think about preserving them. I gather from what you're saying is that you're acting in good faith. It simply didn't occur to you at that point on Friday that any steps should be taken to preserve documents from destruction.
So that's correct. It did not occur to me or to anyone else, and we followed the same process, as I mentioned, that you do and your investigating committees here.
Right. When did you first think about the possibility of criminal investigation?
The first real thought that I gave to the possibility of criminal investigation was probably on Monday afternoon. Investigation was probably Tuesday the 25th.
Well, but before you go any further, recall what you just said in response to Senator Cohen. Now,
I said the possibility that criminal laws might possibly have been violated.
Criminal implications, I think.
Criminal implications, right.
Was on Sunday.
On Sunday.
When you talked to Colonel North.
That's correct.
Right. So would that have been the first time that it entered your mind?
Criminal implications, yes,
Yeah.
I'm sure.
But you still did not think about securing documents at that point?
Well, Senator, we already had examined all the documents, and we already had, in fact, had the key document, the evidentiary document that was known as the diversion memo, which was the significant document, a copy of that in our possession.
Well, when you say we had examined all the documents, you had examined all the documents that you had seen until then. But in fact, there were a great many documents that you never did see, nor anybody else.
We don't know whether those were relevant documents, irrelevant documents, or what they were.
Do you think Colonel North spent from 11 o'clock in the evening till 4:15 the next morning destroying irrelevant documents?
I think he probably did. I think there were a lot of documents that he destroyed that had no relationship to the Iranian initiative or had any relationship to the Contra diversion of funds. There were probably a lot of other things that he may well have destroyed, documents that he didn't want anyone to see.
On what do you base that opinion?
That's just a guess, as much speculation as yours, that there were relevant documents.
In the notes taken of the meeting with Colonel North, there's one part of it that raises questions in my mind, particularly in light of your response to Senator Cohen's question, that when you brought the diversion memo to Colonel North's attention, you at that point thought of the potential criminal implications. It's page 15 of the notes, Exhibit 47. You may wish to refer to those. On the last 6 lines, or actually the last 8 lines, notes read, if President okays something into working files of, next line reads, AG, if RR approved it, you'd have it, yes, don't think it was. Other files there it could be in, to verify it didn't go forward, and then there's a star circled, OLN will check.
Right.
Do I gather that that represented a conversation between you and Colonel North in which you asked him if the President had okayed something, into which working files it would go, and then you asked him if RR, meaning President Reagan, approved it, you'd have it, meaning Colonel North, and he said yes, but he didn't think it was approved. And then you asked him, are there other files it could be in, to verify it didn't go forward, and then you asked Colonel North to go back and check his files to see if there were any memorandum which included approval by the President. Is that a summary?
No, that's not what this says.
Okay, would you go ahead and tell us what it says?
What it says is, my statement, I asked if the President okays something, does it go into the working files of the NSC, or, and I don't, it doesn't indicate what his response was. I assume he said something like yes. I said, if he approved it, you'd have it, in other words. And he said, yes, I don't think it was approved, or words to that effect. Right. Then I said, are there other files that it could be in? And there, that's a shorthand for me asking, and I do recall this independent of the notes, would there be another file that was kept, say, by Admiral Poindexter, of approved presidential findings or approved presidential documents? And I said, I'd like to find out about that to verify that it didn't go forward. And he said, as I recall, that he would check into that. As I mentioned, I believe, in answer to Senator Cohen's question, we didn't leave it to Colonel North to check into whether there was another file. We had our own people go over and check into it independently.
What does the star mean next to?
I don't know. That's Mr. Richardson apparently put a star there.
Yeah.
He put stars on various things.
Yeah.
Put star on the previous page.
Well, I'll represent to you that Mr. Richardson has said that the star designated an action item, something that was to be done by someone after the meeting. Do you know in fact, who went to check the records other than Colonel North?
I believe Mr. Richardson went back, Mr. Richardson or Mr. Reynolds, or I think it was Mr. Richardson went back to check with Colonel Thompson as to whether there was a separate file of approved presidential decision memoranda.
So your testimony is that this was not Colonel North going back to check, but rather someone from your staff was going to go back and check?
No. I think Colonel North said he would check and let us know about that, but I also say that in parallel, we also check separately.
Oh, I see. All right, thank you. I'd like to go now to the question that was raised regarding the testimony for Mr. Casey and the briefing for Admiral Poindexter. As you recall, you said that on November 20th, you participated in a meeting in Admiral Poindexter's office to prepare testimony for Mr. Casey to give to Congress the following day, and for Admiral Poindexter to use for briefing members of Congress. Now, at the meeting, the proposed testimony was changed to say that no one in the U.S. government knew about the shipment of Hawk missiles to Iran in the fall of 1985. You recall that aspect?
I recall that,
yes. Now, Colonel North testified here, and he told us that he proposed the change, and that when he did so, he knew the statement was false. He further said that Admiral Poindexter and Mr. Casey knew it was false. In his first statement, he included you as knowing it was false, but later under questioning, he said he had no basis for that. And you and Mr. Cooper both testified that you did not know it was false because you had no factual basis on which to make a judgment one way or the other on it. Now, it was only later that day that Secretary Schultz, who knew the statement was false, protested, and that was brought to Mr. Cooper's attention, who brought it to your attention. You testified at some length about that yesterday, that you had the phone call up in West Point and you returned. Now, you've said repeatedly in describing those events that it was a matter of confusion, different recollections, but it seems clear, at least to those of us who heard Colonel North's testimony, that it was a problem of a deliberately false statement being proposed to be made, that some of the persons there knew was false, others did not, you being among those who did not know. And it was not until later that Secretary Schultz, who had an independent recollection based again on notes, that Mr. McFarland had told him while at Geneva that they knew it was Hawk missiles, that this was raised. And so my question is, when did you become aware that the problem was one of a deliberately false statement proposed to be given by Mr. Casey and Admiral Poindexter, rather than one merely of confusion arising from different recollections?
I would say that I probably did not become aware of that until at least the time that I had the chance to talk with Colonel North, and I'm not even sure then. And it may have been even later, it may have been after the course of these hearings here.
Deposition, you indicated that Mr. McFarland seemed concerned and somewhat hesitant about this aspect of the interview. Do you recall that? It's page...
Well, actually, he seemed somewhat concerned and hesitant about a number of about the TOW missiles, the missiles that had previously been transferred by the Israelis. And when I say concerned and hesitant, this was a feeling that I got that he might be hesitant. He seemed hesitant in answering the questions. I didn't know whether it was faulty memory or those being at that time more than a year and a half or 2 years earlier, a year to a year and a half earlier. But in any event, I did indicate that I thought he was somewhat hesitant about that, yes.
Did you discuss your reaction with Mr. Cooper? Because he testified, and I quote him now, "I did not leave the interview, nor did I take it during the interview, that Mr. McFarland was being entirely straightforward and entirely forthcoming." Did you discuss after that with Mr. Cooper your
I don't think so.
individual reactions to
I don't
Mr.
believe
McFarland's testimony?
I don't believe I discussed it with him, but I thought at the time that he was trying to, as I think not distort his testimony, but certainly shade his testimony because he had some idea that this was protecting the President if the President was not involved.
That's right. In fact, you said that after the meeting, you talked separately with him, outside of Mr. Cooper's presence.
Well, that was incidental. I would have said the same thing if Mr. Cooper had been there.
Yeah. He wanted you, McFarland wanted to make the point to you that the President really was generally behind this whole thing,
right.
and that led you to tell him the importance of telling the truth.
Yes, sir.
And the best way to help the President is to tell the truth. Now, the next morning, you interviewed Secretary Schultz, and he described to you in some detail his version of the events of the November '85 shipment, which is in direct contradiction to the version of events given by Mr. McFarland. Isn't that correct?
That's correct.
Right. And a few hours after you interviewed Mr. Schultz, you learned of the diversion memorandum.
Yes,
And
about 5 hours or so, yes.
all right, sometime early afternoon, I guess.
Right.
Well, again, this is hindsight, and we all understand how difficult it is when you're in the middle of events, but it seems that you had Mr. McFarland telling you a story that was directly contradicted by Mr. Schultz. Mr. McFarland making a point of speaking privately with you about the President and you wanting him to tell the truth. You had the diversion memorandum, at least that you knew of at that time. You're an experienced criminal investigator, and people think of criminal investigators as being, if not cynical, at least skeptical about things. Did anything register in your mind then that there might be here an effort by those involved in this initiative in the diversion to prevent the facts from becoming public?
Well, Senator, first of all, the diversion aspect was totally separate from what had occurred in November of 1985. So there was nothing there that would have aroused suspicion as to those two events. Secondly, now I was dealing with people who had been entrusted by the President with some of the most important tasks as well as the important secrets of the country. People I knew all to be honorable and reputable individuals. And in each case, in the case of the difference in recollection of Mr. McFarland and Secretary Schultz, Mr. McFarland said that he couldn't remember that conversation with Mr. Schultz, or a conversation about Hawks with Mr. Schultz. He couldn't remember even a conversation with Mr. Schultz on this general subject at Geneva, but he didn't doubt that he had such a conversation. And as I think I testified earlier, I chalked up that lack of recollection to the fact that he was
on that point, you talked to Mr. McFarland on that Friday, that same day. And you and Mr. Cooper interviewed him, and Mr. McFarland told you that he had not known until after the fact that the November 1985 shipment contained Hawk missiles.
He told me that's what he recalled at that time,
right.
yes.
And you recall at your deposition, you indicated that Mr. McFarland seemed concerned and somewhat hesitant about this aspect of the interview. Do you recall that? It's page...
Well, actually, he seemed somewhat concerned and hesitant about a number of about the TOW missiles, the missiles that had previously been transferred by the Israelis. And when I say concerned and hesitant, this was a feeling that I got that he might be hesitant. He seemed hesitant in answering the questions. I didn't know whether it was faulty memory or those being at that time more than a year and a half or 2 years earlier, a year to a year and a half earlier. But in any event, I did indicate that I thought he was somewhat hesitant about that, yes.
Did you discuss your reaction with Mr. Cooper? Because he testified, and I quote him now, "I did not leave the interview, nor did I take it during the interview, that Mr. McFarland was being entirely straightforward and entirely forthcoming." Did you discuss after that with Mr. Cooper your
I don't think
individual
so.
reactions to
I
Mr.
don't believe
McFarland's testimony?
I don't believe I discussed it with him, but I thought at the time that he was trying to, as I think not distort his testimony, but certainly shade his testimony because he had some idea that this was protecting the President if the President was not involved.
That's right. In fact, you said that after the meeting, you talked separately with him, outside of Mr. Cooper's presence.
Well, that was incidental. I would have said the same thing if Mr. Cooper had been there.
Yeah. He wanted you, McFarland wanted to make the point to you that the President really was generally behind this whole thing,
right.
and that led you to tell him the importance of telling the truth.
Yes, sir.
And the best way to help the President is to tell the truth. Now, the next morning, you interviewed Secretary Shultz, and he described to you in some detail his version of the events of the November '85 shipment, which is in direct contradiction to the version of events given by Mr. McFarland. Isn't that correct?
That's correct.
Right. And a few hours after you interviewed Mr. Schultz, you learned of the diversion memorandum.
Yes,
And
about 5 hours or so, yes.
all right, sometime early afternoon, I guess.
Right.
Well, again, this is hindsight, and we all understand how difficult it is when you're in the middle of events, but it seems that you had Mr. McFarland telling you a story that was directly contradicted by Mr. Schultz. Mr. McFarland making a point of speaking privately with you about the President and you wanting him to tell the truth. You had the diversion memorandum, at least that you knew of at that time. You're an experienced criminal investigator, and people think of criminal investigators as being, if not cynical, at least skeptical about things. Did anything register in your mind then that there might be here an effort by those involved in this initiative in the diversion to prevent the facts from becoming public?
Well, Senator, first of all, the diversion aspect was totally separate from what had occurred in November of 1985. So there was nothing there that would have aroused suspicion as to those two events. Secondly, now I was dealing with people who had been entrusted by the President with some of the most important tasks as well as the important secrets of the country. People I knew all to be honorable and reputable individuals. And in each case, in the case of the difference in recollection of Mr. McFarland and Secretary Shultz, Mr. McFarland said that he couldn't remember that conversation with Mr. Schultz, or a conversation about Hawks with Mr. Schultz. He couldn't remember even a conversation with Mr. Schultz on this general subject at Geneva, but he didn't doubt that he had such a conversation. And as I think I testified earlier, I chalked up that lack of recollection to the fact that he was almost totally preoccupied with the main purpose of his being in Geneva, which was the summit. So those were the reasons why it didn't flag anything that anyone was being deceptive. Furthermore, I had no reason to believe there was any reason for anyone to be deceptive about these particular events.
One final area of questioning. You testified that finally, early the next week, you contacted representatives of the Criminal Division and asked for some analysis of the statutes. And within hours, Mr. Weld came back to you with what you referred to as the constructive trust theory.
Well, actually, I think I had told him that there may be a constructive trust theory. I think
You
I
had
may
thought
have
of it
suggested
before he said it
I had
to you.
thought of it as an abstract theory as we were discussing it.
Basically, That's legal talk. What it was the view that government property was sold, a profit was made, and if the funds were government funds, then it belonged to the government and could not be used for other purposes without authorization. Is that a fair layman's description of what the legal implications were?
That was my discussion in general with Mr. Weld, and he, with his people, after several hours, verified that and came back to me. He said that he thought there was enough that we could legitimately open a criminal investigation.
Well, my question is it too much hindsight to wonder why you and Mr. Reynolds and Mr. Cooper and Mr. Richardson, all these lawyers, didn't think of that when you saw the diversion memo? It seems a rather obvious thing that here was government property sold, a substantial profit made, the funds used for another purpose, leave aside the question of the legality of aiding the Contras for any other purpose, without any authorization. I gather that did not occur to you when you saw the diversion memo or when you confirmed the diversion on Sunday.
Actually, at that time, we were thinking, we were proceeding, first of all, to make sure to find out if it was authorized. I think Mr. North, in his statement, said that he did think it was authorized, or words to that effect. In any event, that he mentioned that Admiral Poindexter had known about it. I wanted to find out from Admiral Poindexter whether, in fact, it had been authorized, and he indicated it had not been authorized by anyone who had the ability to authorize it. It was in the course...
Would you say that again? Admiral Poindexter told you it had not been authorized?
I say he indicated to me, he said that no one else had known it. The President had not authorized it, obviously. He said he had allowed it to go forward, but that was not sufficient. So our concentration was on that whole transaction. It wasn't at that point, but it was following that conversation with Admiral Poindexter, or at about that time, that I asked Mr. Cooper to look into this, and it was at that time that the ideas of constructive trust and things like that started to develop.
Would you repeat for me, please, what it was you said Admiral Poindexter said to you?
Admiral Poindexter, as I testified yesterday, said that he knew about it generally, but that Ollie had given him enough hints so that he knew about it generally, and that he had allowed it to go forward. He hadn't followed up on it.
Yeah. So
that as far as I was concerned, that was clear to me then. It had not been authorized by anybody in authority.
Right. So your use of the words authorizing and authority are your characterization of Admiral Poindexter's words, not what he said to you.
That's correct.
Yeah. Well, I thank you, Mr. Attorney General. I want to commend you for your condemnation of lying to the Attorney General and lying to Congress, and you see if in closing I can't get one more condemnation from you. In your opening statement you said, and I quote, obviously the destruction of documents and any breakdown of communications within and outside the administration deserves serious review and reflection. You are, of course, the Attorney General of the United States, the chief law enforcement officer of this country, and for many Americans, a symbol of justice. Surely it's not the most you can say about the destruction of documents by government officials that it deserves serious review and reflection. Can I ask you if you would not also condemn the destruction of documents by government officials?
Senator, I have no hesitation at all condemning anything that is used to deceive or to otherwise withhold from proper authorities information they should receive, and that includes lying. It includes the withholding of information that should properly be reported to the President, for example, or to the Congress, and it also includes the destruction of any official documents in an effort to deceive those who are in authority who should have access to that information. I have no hesitation whatsoever in condemning all of those things.
Right. Thank you very much, Mr. Attorney General. Thank you, Mr. Chairman.
The Senator has 2 minutes remaining.
I'll reserve that in case I want to make a
The hearing will stand in recess for 10 minutes. May we come back into order?
Chairman, I think we can dispose of this. May I just renew that motion that I made yesterday, that is to make the deposition of Assistant Attorney General Weld part of the record as an exhibit. I referred to this yesterday during my questioning of Attorney General North, there was some argument on the part of some of the members, and there was an objection. I believe that since then I've discussed this with Mr. Cheney, who made the objection, and I would hope that this would be entered into the record as an exhibit.
Mr. Cheney?
Reserving the right to object, Mr. Chairman. It is not my intention to object, but I want to make it clear what my concerns were yesterday. Mr. Rodino suggested in reviewing the transcript focused on only 2 pages, and I would urge those who look at this, especially in the press, to take into account pages 13 through page 20 of the deposition, because I think it shows fairly clearly that Mr. Wells' comments support those made by the Attorney General, that he did not call for the involvement of the Criminal Division in this investigation on the grounds that there was some kind of ethical problem at all, that his reference was to the Evans case in New York. I would also point out that my concerns yesterday, Mr. Chairman, were raised in part to the fact that the Attorney General had never had the opportunity to review the deposition. It's over 65 pages long. I think it's important that the committee conduct itself in a way that is fair to its witnesses, and for that reason I was constrained to object when a unique procedure was requested. Having made that statement, Mr. Chairman, I would be happy at this point to withdraw my reservation of objection.
Mr. Chairman, let me add that I'm not going to argue the deposition. I will let the deposition speak for itself. That's what I had hoped might have been the case yesterday afternoon, and I think that what will be reflected will not be just on those pages, but wherever there is this reference to how this investigation might have been conducted, and those, I think, are the reflections that I referred to of Mr. Weld. And with that, I think the deposition should speak for itself.
With such clarification and without objection, so ordered, we will stand in recess for 10 minutes. The hearing will please come to order. General Meese, I think we should remind ourselves that this panel here is not convened to determine the guilt or innocence of anyone. This is not a court of law, and we're not here to determine the culpability, criminal culpability of anyone involved. However, if we are to file a final report to the people of the United States, we would have to have available to us the best factual chronology of what did occur. And the problem we have is that the testimony to date has been confusing and contradictory, and I believe that's an understatement. And so I wish to call upon you and your 8 years of experience as Deputy District Attorney in Alameda County, over 2 years as Attorney General. And some of the questions I would ask may be redundant and repetitive, but all of us here are eager to get to the truth. Now, there's no question here that Colonel North was not honest with you. Admiral Poindexter lied to you. And yet you have indicated to us that you were convinced at that time that they were truthful. You depended upon their friendship and long association. Although you've indicated that it might make a difference, since these two officers appeared before us under oath that they may be a bit more truthful here, but isn't it true that under Section 1001, it makes no difference whether you're under oath or not, that if you lie to the Attorney General or lie to the Congress, it's still a felony? Isn't that true?
Mr. Chairman, that is correct if it's in an official statement and so on. There are certain requisites as to the provisions of Section 1001, but in general, the statement you have made is correct.
When you were on your fact-finding mission, wasn't that an official function?
Yes, sir, it was.
That being the case, and based upon your experience with the Colonel and with the Admiral and with the Director of the Central Intelligence Agency, do you have any advice to us as to how we may determine who's lying and who's not lying?
Well, Mr. Chairman, I recognize, as you've stated, that this is a very difficult and a very important responsibility of the committee. I think that, in a sense, what the committee, I'm sure, wants to come out with are some recommendations and some suggestions as to processes that will assist in more fundamental areas of cooperation between the executive and legislative branches. And it may well be that as to the narrative account, the factual account, which is, of course, subsidiary to the legislative function, that the committee may have to put almost in parallel the various accounts that have been revealed here, both in terms of what was told to me on the weekend of the 21st through the 24th of November, and what was told to the committee. As far as whether any person will be prosecuted, as you mentioned, that is something for other sources to develop, particularly the independent counsel. I would only say that in many aspects, the different statements that have been made do have a certain consistency, so that I think there are a number of things in which the committee can draw conclusions because, as I mentioned in my opening statement, much of the basic outline of what happened, the essential facts, remain the same today. I think there's no question that there was, in fact, a diversion of funds. I think we're all agreed to that. I think there's no question that certain people were involved in that. There is some questions about to what extent they may have been involved, but as far as their basic involvement, I think that's pretty well established. There are certain other aspects which are more murky. The committee itself has the testimony about the involvement of some of the players such as Mr. Secord and Mr. Hakim and others that have been mentioned here, about which I had no information because that was not revealed to me over the weekend that we were looking at. So I would think that the most important thing is to develop the factual outline, as I did, where all of the information seems to be relatively consistent, and then perhaps to highlight those areas in which there is an inconsistency, but which I don't think will affect the basic responsibilities of the committee in terms of whatever recommendations come out of their several weeks now of investigation.
I was one of the junior members of a prosecutor's office about 35 years ago in Honolulu, and at that time I was told that whenever interviewing witnesses or a fact-finding assignment, I was required to take notes and to submit a memo at the end of my fact-finding mission or after the interview. Is this the standard procedure in your office where your assistants are required to take notes and submit a memo?
Yes, sir, generally they are, Mr. Chairman.
Why didn't you, as Attorney General of the United States, carry out the directive that you've issued to all of your assistants and take notes? I noticed that according to the exchange you had with Senator Mitchell, notes were not taken.
Well, Mr. Chairman, as I think you'll remember from my discussion with Senator Mitchell, most of the time in the interviews, the notes were taken. And in fact, those notes have been relied on here for much of the information about which I've testified. And there were only in a very few instances that notes were not taken.
But these were the important interviews after you began to get suspicious that something was wrong.
Well, the only interview, I would say, I wouldn't even call them interviews, they were conversations. I would say the only conversation even in which probably notes would be valuable, and had I had the time on the occasion, I would have jotted them down, although I must say I have a very good recollection of them, would be the discussion with Admiral Poindexter.
After you made your expletives deleted and were convinced that something was dreadfully wrong, don't you think that at that moment you got very concerned that notes should have been taken?
I think at that time notes were taken in the ensuing interviews.
Can I now touch upon the diversion memo? Was it apparent from the face of this memo that it was a draft and not an original?
I wonder if I might have the chair's indulgence to give me the exhibit number of that memo so that I can look at
I
it.
have none, but this is the one that Mr. Reynolds located.
Yes. Was it obvious that it was a draft?
Yes.
I can't recall, again, whether it was obvious or not. It appeared to be a draft. I believe there's been testimony or notes to that effect.
Did you ask Colonel North what happened to the original of the memo?
Well, the memo itself, again, we asked about the memo, and my recollection is that he indicated finally that it had been a memorandum prepared either by him or under his direction. And I don't remember any conversation, and again, I'd have to look at the memorandum to see whether it was clearly a draft, whether he mentioned it was a draft or just exactly what it was.
Did you ask Colonel whether he had sent this memorandum to Admiral Poindexter?
I believe, again, I'd have to refer to my notes. I believe that there was some discussion on this.
I believe you did not ask him.
Let me look at my notes, if I may, and see whether we asked him
Fine,
about
sir.
that, or at least Mr. Richardson's notes. We asked whether it was something that he prepared, and ultimately we found out it was. First he said he didn't, I think at first he hesitated as to whether or not he had prepared it, but ultimately acknowledged that it had been prepared by him or under his direction. And I'm looking now to see whether what was asked about it.
What I'd like to know is that you ask him whether he had sent that memo on to the Admiral.
Yes, that's what I'm trying to find now, Mr. Chairman. I don't believe that there was any discussion as to this particular memorandum. There was a discussion whether Admiral Poindexter knew about this, but not as to the scheme. But I don't find any particular reference, and I can't recall at this time, Mr. Chairman, whether we specifically asked him whether he had passed it on to Admiral Poindexter.
I'm certain you were aware that he was a subordinate to the Admiral.
Yes, sir.
Wasn't it important to know whether the head man got the memo, or whether he knew or approved of the diversion?
Well, there was no question in what Colonel North told us that Admiral Poindexter did know about it, and did know about this. He said that he was one of the 3 people in the government who did know about it.
Did you also ask him whether he approved the diversion?
I don't recall that question specifically being asked.
When you were first advised of this diversion, you were startled to a point where you said things that you would not ordinarily utter. And so it was very important to you, wasn't it?
Yes, sir.
Did you ask Colonel North who authorized the diversion?
I don't recall whether it was asked specifically in those words. It was, and again, I think we asked whether this had been discussed with the President, and Colonel North said not as far as he was concerned. And then it was asked or he said that Admiral Poindexter was the point of contact with the President, and that Mr. Fortier might be involved too because he was the principal deputy. And I think that was the discussion that was had on that subject. Let me just see if there's anything else that would shed a light on that. I think there is, it definitely told us that Mr. Poindexter was knowledgeable about this. I don't know whether the question was asked in the form of did he authorize it.
When a decision of this magnitude is made, I'm certain, as in your office, as in other offices, there are other drafts and memos. Did you ask the Colonel whether there were other memos relating to the diversion?
I don't recall whether that was asked. It may have been asked after I left the meeting.
On your 10-minute casual conversation that you had with the late director of the Central Intelligence Agency, can you tell us again why you did not think it was important enough to discuss the most important matter that was pending in the administration at that moment, the diversion?
Which conversation are we now talking about?
This is
Chairman?
the one you stopped off at his house for 10 minutes, the conversation that you had with Mr. Casey?
Is this the one on Saturday evening?
Yes.
That was more than 10 minutes. That was about, I think I testified anywhere from 45 minutes to an hour. But during that conversation, I did not bring this particular matter up, the diversion memo, because at that time I had not seen the diversion memo myself. I didn't know very much about it. We had not verified what that memo meant, whether there ever had been a diversion scheme. I knew we were going to talk with Lieutenant Colonel North about it the following day, and I made the decision not to talk with anyone about that, including Mr. Casey, until such time as I knew more about it.
But you knew enough and suspected enough, didn't you?
I didn't have any basis to suspect anything. We didn't know whether that memo was just somebody's pipe dream, some idea, or whether there was actually some substance that had been implemented. At that time, we had no knowledge whatsoever of what this particular document meant. But as I mentioned, I had not even seen the document itself.
Although you weren't quite certain as to the full import of the document, you were startled and a bit shaken by that.
I was startled even by the possibility that somebody was thinking in those terms.
Now, when you dealt with Mr. Casey, you were dealing with someone who was one of your closest friends. You had worked together with him in campaigns, raised funds together. You had enjoyed victories and some defeats. You had gone through turmoil of politics. You weren't dealing with a stranger, were you?
Well, Mr. Chairman, I had dealt with Mr. Casey in one campaign, and fortunately we had had only victories, no defeats, and that was the campaign of 1980, but he was a good friend.
So you're dealing with someone friendly,
Yes, sir.
not a stranger.
No, sir.
Why were you so shy in asking him the $64,000 question?
Because of the importance of this particular situation, and because I didn't know what that information that had been discovered meant yet, and so I made the decision instinctively, I think, as any lawyer would, not to talk with anyone about something that important until such time as I knew what I was talking about. I think, Mr. Chairman, I've always thought since that time, if I had talked with Mr. Casey on that Saturday evening, then this committee would now be asking me, why did you tip off Mr. Casey and let him cover the ground before you talked with Lieutenant Colonel North?
But weren't Colonel North and the Admiral tipped off already?
Not at all. They didn't know I had that we had that memorandum. As a matter of fact, that's why Colonel North, the next day when I talked to him, showed considerable surprise that we had it.
In dealing with Mr. Casey, he did bring up the diversion with you, didn't he?
No, sir.
He talked about Mr. Fermack.
He talked about Mr. Fermark, but I did not view that as part of, certainly not part of this diversion or part of any diversion at that point.
Did that tip you off that this may have been related?
No, sir. The way he talked to me about the Fermark matter had nothing to do with this kind of a diversion or anything to do with the Contras, and it was more a threat to go public with a lawsuit, which was something quite apart and was still part of the whole aspect of the Iranian initiative and had no relationship whatsoever with what was going on in Central America.
Did you discuss the diversion with the Vice President of the United States?
I did on Monday the 24th, yes, sir.
Who was present at this meeting?
I was present with the Vice President, the two of us.
No one else?
No, sir.
Did you take notes on this meeting?
No, sir, I didn't. It was a brief conversation and was more of informing him of what was going on, but in the course of that, I did ask him if he knew, or he said he didn't know, one of the two.
You're trying to recall now whether he said?
I don't remember whether he volunteered. Well, I certainly never knew anything about that, or whether I asked him whether he knew. I can't recall.
I believe, if my recollection is correct, that you indicated that this finding was such that it would be resolved in 30 to 60 days.
I testified, Mr. Chairman, and it's still my recollection that at the time we were briefed on this on the 7th of January, 1986, it was my impression that this would be accomplished within a period of 30 to 60 days. It was an imminent type of thing. It was described in the conversations there, and I think there's been testimony to that effect, that this would be something that would go forward rather quickly.
That was your basic reason for acceding to the suggestion that the Congress not be notified immediately?
That was not the basic reason. The basic reason had to do with the jeopardy of the hostages and the jeopardy of the people that we had hoped to develop a relationship with in Iran, but it certainly was a part of the overall framework and assumptions that I was proceeding under at that time.
That 30 to 60 days would have been sufficiently timely.
Well, I really, the timeliness related to when the risk was no longer present, but 30 to 60 days was a part of my consideration, yes.
When was the Congress notified?
My recollection is that the project was still ongoing when this became public in November of 1986. And so it was at that time that the notification came to Congress.
Not through official channels?
Not through official channels, that's correct.
So the waiting period was beyond 60 days?
Yes, sir.
Did you or the administration have any intention to notify the Congress?
Yes, sir. Everything that I had been told at the time of the briefing was a very definite intention to notify the Congress, and that, as a matter of fact, I think there were great pains taken to identify the point at which Congress should be notified, and that was as soon as the hostages were received and were back safe in United States custody. And as I think I testified earlier, even before the plane on which they were arriving landed at the Air Force Hospital in Wiesbaden, Germany.
I have many other questions I'd like to ask, but I'd like to now call upon my colleagues here. So I would like to reserve the balance of my time. May I now call upon my co-chairman?
Chair recognizes Mr. Cheney under the 15-minute rule.
Thank you, Mr. Chairman. General, I'd like to follow up on the questioning touched upon by the chairman of the Senate Select Committee with respect to this question of notifying Congress. One of the things I note about this whole set of developments is that oftentimes, while I find I disagree with a decision that was made by the administration, that when we dig into it, we find that there was at least understandable justification why the President was concerned about the lives of the hostages or Mr. Buckley or some other aspect of it. And I'd like to look at the question of notifying Congress on that basis. It's my recollection you testified that you believed, based on your review of the statutes and the legislative history, that the President had the authority, clearly, to withhold notification from the Congress. Is that correct?
That was my belief at that time, and still is, that that timely notification indicated that there could be a delay under certain circumstances.
There was some flexibility. Did you consider at all the possibility of notifying just the so-called Big Eight, the chairman and ranking member of the House and Senate Intelligence Committees, Speaker and Republican leader of the House, and their counterparts in the Senate?
Mr. Cheney, I was not really consulted on the process of notification. It was rather on the legal aspects of a delay in notification. So really, I was not present at any time when there was a discussion of who to notify. It was a question of, can notification be delayed?
Mm-hmm. Well, I bring that up because I notice you can't help but be aware of stories that ran in the morning newspapers this morning. I've got one in front of me from the Washington Times, the headline of which is, "Leahy confesses leak led him to step down." I read briefly from it as follows. Senator Patrick J. Leahy, former Vice Chairman of the Senate Intelligence Committee, admitted yesterday that he resigned from the oversight panel earlier this year because he had leaked details of the panel's Iran-Contra investigation to a television news reporter. The Vermont Democrat issued a statement last night admitting he had been careless in violating committee rules in November when he allowed a news reporter to view an unclassified document listing a chronology of events in the Reagan administration Iran arms sale. It goes on, the same story, to cite farther down Mr. Durenberger, a Republican from Minnesota, then the chairman of the Senate Intelligence Committee, currently is being investigated by the Senate Ethics Committee over allegations he leaked details about a U.S. intelligence source in Israel. My point in raising this is that even had the President been prepared to deal with the so-called Big Eight in this particular case, he would have found himself dealing with two members of Congress, one of whom has admitted he made an unauthorized disclosure of a document the committee had voted not to disclose, and the other of whom, according to press reports, is currently under investigation on allegations that he leaked details about U.S. intelligence sources in Israel. I think that's an important point to make, and that viewed in that context, it's a little more understandable why the administration has, over the months and years, been concerned about dealing with Congress on sensitive intelligence matters. I must say, General, that I don't find the decision not to notify Congress acceptable. It seems to me both of us have to find some way to overcome the distrust that is currently rampant between the two bodies with respect to these matters. But it's clear that there was, or at least it would appear from these reports and accounts, there was legitimate cause for concern that Congress could not keep a secret, and a lot of evidence that, in fact, at various times in the past, various members of Congress had, in fact, been responsible for sensitive leaks. Certainly, I'd be happy to yield to the chairman.
I think the record should show that Senator Leahy released unclassified information.
Well, if I may reclaim my time, Mr. Chairman, I don't dispute that it was not classified, but I note that the Senate Intelligence Committee last night issued a statement saying a member of the panel violated committee rules by making an unauthorized disclosure and resigned effective January 13th, and that the committee had in fact voted against releasing the report when the vice chairman of the committee unilaterally decided to go ahead and do it himself, and I think that the record ought to reflect that. I'll be very brief, General. I don't have a long list of questions. I think you've covered a lot of territory. I think it's important for us as a committee, though, to avoid trying to force the evidence to fit some preconceived conclusions or notions about what transpired here. We have investigated for months the question or the charge that somehow the President had knowledge of the allegation that there had been a diversion of funds, and of course the fact of the matter is we found absolutely no evidence to support that. I'm somewhat suspicious now that in light of the fact that no smoking gun was found in connection with the diversion matter, that the focus has now shifted to a suggestion that somehow there was a cover-up of some kind, that at the direction of the President and with your active involvement, the administration undertook to obscure the facts in this particular case. Again, I find absolutely no evidence to support that allegation. We had the story this weekend in the Washington Post on Sunday that implied that the President presided over a meeting on November 10th where there had been an initiation of an effort to cover up these events, and of course we find when we analyze the basis for that story that while that may have been the implication, the story simply doesn't support it, that the President clearly was concerned on November 10th, as your notes and the notes of others clearly demonstrate, with trying to obtain the release of 2 additional hostages, that his basic message to his officials was not to discuss the subject at all. I have a vivid recollection in that period of time of David Jacobson, one of the hostages recently released from Lebanon, standing on the steps of the Rose Garden in the White House, pleading with the White House press corps not to dig too deeply in this matter because lives were at stake. And I think it's clear that the allegation that somehow the November 10th meeting involved a cover-up simply doesn't hold up. The allegations, obviously, with respect to your involvement, focus on that weekend of November 21st through 25th. And again, while the committee has an obligation to ask difficult questions and to probe these matters, I also think we have to resist the tendency to be Monday morning quarterbacks and to put ourselves in your position and judge your actions now with the benefit of hindsight. I think it's very clear to me that based on the evidence we've seen that any allegation that there's a cover-up simply is untrue, that it's not supported by the facts, just as there was no evidence to support the allegation that somehow the President had knowledge of the diversion, there is absolutely no evidence to support the allegation that somehow there was a cover-up. I think the members of these committees need to keep a few basic facts in mind. We often operate as if we were the ones to uncover the events being investigated here, that the committees took action to stop the sale of arms to Iran, etc. And of course that's not true. The facts are that the President is the one who, together with the Attorney General and other officials in his administration, made the decision to stop the policy, that he changed the policy when it became clear that it was a mistake, that he undertook the factual inquiry, or had you undertake the factual inquiry that led to the discovery of the diversion memo, that he directed you to make the diversion memo public, that he's the one who set up the Tower Commission and subjected his administration to the somewhat excruciating scrutiny that that entailed, that you called for the appointment of the independent counsel, that the President replaced the NSC advisor, the deputy, many key staff members on the NSC staff, hired a new chief of staff for the White House and a new CIA director, and that all of that happened before this committee held a single day of public hearings this spring. Finally, I think it's important for everyone to remember that the President's gone all out to cooperate with the committees, that he has directed that all administration officials come forward and cooperate with the committee, that not one single claim of executive privilege has ever been imposed, although it certainly was justified in many instances, The committee has had access to the most sensitive minutes of NSC and NSPG meetings. We've had access to the detailed notes of the President's subordinates, yours and others. And of course, finally, the President gave us access to his own personal diary to review these events. So we're here today having had a full and complete airing of these matters and nearing the end of our investigation in large part because of the actions of the President and yourself and other members of the administration. I think this committee and the press need to recall these facts in order to keep these events in perspective and in order to avoid misleading the American people about the events that we have under review. Thank you very much for your testimony.
Thank you, Mr. Cheney.
The chair recognizes Senator Cohen for 2 minutes.
Thank you, Mr. Chairman. I'd just like to respond for a moment about the statement concerning Senator Leahy. I don't think that it should be taken out of context. Number one, I voted last January to oppose the release of the Intelligence Committee's first draft of its investigation. I believe I was the only Republican to do so and took considerable heat for doing so. And I did so because at that time the administration was putting pressure on the membership to come out with a report so the President would know what in fact had happened in his own administration. I was not opposed to releasing the non-classified document, but I was concerned that it was incomplete, that the members hadn't read it, and so I opposed it. Ironically, this report was the one the administration wanted out, so Patrick Leahy, in essence, unwittingly was doing the administration's work in that regard, but it should be pointed out consistently. It did not involve classified information, and if there's any evidence that Senator Leahy or Senator Durenberger have ever released classified information, any member who has that information should bring it forward. I just want to say that if the President was concerned that either Senator Leahy or Senator Durenberger were untrustworthy, then he could have gone to the big four, and that is the leadership of the House and the Senate. And if the President does not feel that the two leaders of the House and the two leaders of the Senate were trustworthy, I think we're in big trouble as a country. So I think that disclosure on the part of Senator Leahy ought to be placed in context. We were opposed to the release of that document. It was, in fact, inadvertently or wittingly leaked. However, nonetheless, I think that Senator Leahy's departure from the committee was a very strong signal that we on the Senate Intelligence Committee are not going to tolerate it, and that indeed the administration can have faith and confidence in the committee of the House and the committee in the Senate.
Thank you very much. The chair recognizes Senator Heflin for 15 minutes.
Mr. Meese, I would like to get into the question a little bit concerning the legality of the decision that was made by which the profits from the arms sales were diverted or given to the Contras, not from the viewpoint of the Boland Amendment, but from the authority of the official who made the decision. It appears that it was Admiral Poindexter, but from a viewpoint of leaving that possibly open, if Mr. Fontier or somebody else possibly could. But from a viewpoint of the person who made the decision, and assuming that it was an official of the National Security Council or in that office, there's no question in your mind that other than the President, there would be no one who would have the authority, if it was otherwise legal, to have made the decision, is there?
No, sir. There is no doubt in my mind that the authority would have to come from the President.
So we really have what is basically a decision that was made that was an illegal act. Now, if you had had a written document and the name of Ronald Reagan had been forged to it, it would have been an illegal document, would it not have been?
Yes, sir.
So we have what is in the effect of close to being the moral equivalent of a forgery that occurred, forgery usually meaning the signature, but the act itself was unauthorized, illegal, and in an effect, technically, because of that, creates a nullity relative to its authority, power, and its scope. Would you not agree?
Yes, sir. I think I would generally agree with that statement that there's no question that there was no authority for the actions that took place.
All right, so now, do we have on the statute books criminal statutes relative to unauthorized acts by officials who do not have the authority?
It would depend, Senator, on the particular circumstances. In this case, it is conceivable that because funds were involved, that the statutes relating to misappropriation of funds would be applicable under a variety of circumstances that may be present here.
Now, do we, well, I'll ask this, do you feel that our laws are adequate to prevent the unauthorized sale or the misuse of government property or government money?
To the best of my knowledge, Senator, the current laws that we have are adequate, and we really wouldn't know the answer to that in this case until we see the results of the independent counsel's investigation. But based upon the preliminary review that was done by the Department of Justice in the Criminal Division and in our Office of Legal Counsel, I would say that adequate laws do exist on the books for coverage of the kind of situation here.
All right, so now you mentioned relative to the ownership of the money in the bank accounts, you mentioned the constructive trust. A lot of lay people probably don't understand what a constructive trust. Could you give us sort of a capsule definition of a constructive trust?
Well, basically, the theory would go, Senator, as you probably know better than I from your experience as a judge, but it would be based upon the agency idea, and that is that a person who is an agent of the United States government and who sells United States government property and makes a profit on that sale, that is not entitled to keep that profit for himself or herself or to divert it to some other use of that person's choice, but rather that those profits also become the property of the United States, and that anyone who then misappropriates those funds may themselves be guilty of a crime.
Would you agree, this is, I'm quoting from Black's Law Dictionary, not always a good source of law, but it sort of succinctly now puts, and it quotes a constructive trust as being a trust created by the operation of law against one who by actual or constructive fraud, by duress, or by abuse of confidence, or by commission of wrong, or by any form of unconscionable conduct or other questionable means, has obtained or holds legal right to property, which he should not in equity and good conscience hold and enjoy. Now that's the definition. It would appear that your constructive trust concept here may go back to the, also further, to the illegality of the authorization to go forward with the diversion as it would apply to the properties that were acquired pursuant to the diversion, such as airplanes, other properties which might be there. Would you agree with that?
It's possible, Senator, and these are facts, of course, that I don't have, so it's difficult to comment. Let me say, however, we've been talking about essentially abstract theories, and I want to make it clear that I am not saying that anyone is guilty of any crimes. This is a matter for the independent counsel. And also I say this particularly because I have a very high regard for the individuals involved. And I think it's important to recognize that there may be a lot of equitable reasons and other matters that are involved that would have to be judged by someone who is weighing the entire situation. So what I have said is really talking to you in the abstract rather than either saying that anyone is guilty of any crime or anyone should be accused of any crime.
Well, I agree with you, and I'm certainly not, do not want to be construed as having put forth that idea that anybody is guilty, because I think that's the determination that has to be made through the criminal process that we're going through. But these are matters I think that will bear in mind, because really the question, and one of the probably areas that we ought to look at, is the question if an illegal act did occur, and it is the cause for many of the problems that we are confronted with today as to whether or not the laws are adequate to take care of illegal acts in the future. Now, while we're speaking on legal basis, I would wonder if you might recall at the time that you made the decision to seek the appointment of an independent counsel in this case, what criminal laws did you consider might have been violated, which would have therefore caused you to move into the area of requesting an independent counsel?
Senator, it's my recollection that the kinds of laws that might be involved, might possibly have been involved, went to misappropriation of government funds or defrauding of the government, the kinds of things that we've just been discussing. And I say might be involved because that's exactly what it was. We were not able, under the independent counsel statute, to use some of the procedures that you would normally use, grand jury testimony, granting of immunity and the like, in the Justice Department, in our opinion, because of the fact that officials involved were high-level persons in the White House or in the National Security Council staff. And it was that reason that we felt the spirit of the Independent Counsel Act clearly mandated our seeking the appointment of an independent counsel through the district, through the special division of the court for the Circuit Court for the District of Columbia.
Now let me leave legal matters and ask you, in your press conference that you had on the 25th of November, at which you announced the resignation of Admiral Poindexter and the dismissal of Colonel North, you used then that there could have been from $10 to $30 million diverted from profits of the arms sale to the Contra use. How did you calculate that bracket of from 10 to 30 million?
Well, as I mentioned at that news conference, we didn't have all the facts at that time, and so we had to do some rough calculations. And I said, I believe, on some 40 occasions that there was more to come, more information to come, and that we didn't have total information on which to base the different items of information that were being revealed. But in that particular matter, I believe Colonel North had told us that in the one transaction that he remembered clearly, that he thought that there were about $12 million that had resulted from that transaction, which had gone to the freedom fighters in Nicaragua. He said he thought it was either that there was either one or two additional situations. And so trying to get some kind of a bracket, as you say, I indicated in the news conference that the amount was probably somewhere between $10 and $30 million, just getting a rough approximation based upon what we had been told on the previous Sunday.
I'm led to believe that, and it may be erroneous, but this is my understanding, that relative to the decision to terminate Colonel North rather than allow him to resign, that this decision was made largely between you and Mr. Ronald Reagan, perhaps with the President. Whose idea was it that Colonel North be fired rather than being allowed to resign his position?
Senator, I can't remember for sure. It was not a matter of firing him per se. It was a matter of transferring him back to the Marine Corps where he was on detail.
Well, it comes out to the public that he's fired.
It comes out the same way. I agree with you. I think there was no question in anybody's mind that his continued service on the National Security Council staff was probably not advisable at that point. And therefore, it was a matter that his situation was different than that of Admiral Poindexter, who was an appointed, or as in terms of the White House parlance, had a commission from the President, which he would have to resign. Colonel North was in a different category. He was assigned to the White House or to the National Security Council staff by the Marine Corps, so it was simply a matter of having that detail be removed and he be transferred back, so that there were two different types of personnel actions. As far as who it was decided, it was discussed among the three of us at least. There may have been others there, the three of us being the President, Mr. Reagan, and myself. I can't recall exactly who said what, but I think that it's obvious that Mr. Reagan, as the Chief of Staff of the White House, had a major role in it.
Mr. Chairman, I have no further question.
Mr. Fasell is recognized.
Thank you, Mr. Chairman. General, on December 10th of last year, the Director of CI had testified before the Foreign Affairs Committee. He'd previously testified, I believe, for the Senate, House Intelligence Committees. And without characterizing the testimony in any way, it's not my purpose here. I noticed that your Assistant Attorney General for Legislative Affairs was there during the whole hearing, took copious notes. The question I have is, and I think that's standard, we see that all the time. Did he report to you as to what had transpired in that hearing?
Mr. Fasell, I don't have any recollection that he did. This was on the 10th of December, 1986. I don't have any recollection. It's entirely possible that he might have reported to me on the hearing, but I just don't recall it at this time.
Well, I know he's a good note taker, and I'm sure that if he had detected in anything at all that should be flagged, as well as just what the general trend of the testimony was, I know that he would report that to you. I just assume that. I'll take judicial notice of that. And I'm just wondering if you have any independent recollection as to whether or not he told you at that time that the testimony given by the director at that meeting was totally in conflict with something that you already knew to the contrary.
No, sir, I don't recall anything like that, and I don't recall any of the subject matter that you're referring to.
Right. Now, the chances are that if that had occurred, it would certainly be noted in his notes, and it would come to your attention if he thought it was important. I'm just surmising that. You don't have to agree or disagree. In other hearings and also in depositions taken for this hearing, there have been representatives of your office in attendance, and they have taken many notes, and I suppose John Bolton was the chief among them. And I assume that they reported to you, since he works for you, as to what the contents of those notes were, or he had some reason for taking them.
Yes, from time to time there may have been reports. Part of it was just to, I'm sure, record the information so as to have that information available if testimony was prepared or if for other reasons, including meetings such as this.
Well, now, as a matter of fact, on November, or whenever it was, when the president said, I got to have somebody look at this, review this whole thing, you were that person. So you were in charge
Yes, sir.
of looking at this entire matter. You talked to the principals who were involved, and you conducted your review. I want to stay away from the formality of the matter. You conducted your review, and at or about the same time frame, and from then on, there were hearings and all kinds of things were happening. But the real part of this didn't start, as far as these committees are concerned, until after we were organized, January, February, or whenever it was. And then we started taking a lot of depositions. And I assume, as a normal function of the Attorney General's office, you would have to keep up with everything that was going on. You're still the President's chief legal officer. Now, the same thing was happening in State Department and CIA. All the depositions and the hearings, they had note takers from State and from CIA. Now, did those offices, that is, the general counsels or whoever they are, did they report back to the Attorney General as to what they had observed or heard, or
At the various hearings?
various
And
hearings or
deposition?
depositions or whatever?
I don't believe they did. They may have in particular instances, but as far as I know, in general, they probably would not have.
But as far as anything that came within your general interest area as the Attorney General, you would do the normal thing, have your note takers present, and that information would be correlated, consolidated, reviewed, or whatever.
Well, ideally, that's true. Sometimes there's so many things going on that the correlation, consolidation, and review is not as complete as we'd like to have it. But in any event, the note takers would probably be there.
Well, I tell you, it would help this committee, it seems to me, if we had the benefit of that, because I'm sure the note takers were very sensitive to any differences or even intonation that might possibly shed some light as to what was actually going on. And if we haven't done that, Mr. Chairman, I think it would be very essential for us to get John Bolton's notes and anybody else that had some responsibility dealing with this Iran affair, particularly from the time that the Attorney General was put in charge of the review. Now, and again, I'm not ascribing that anything's wrong, but it just seems to me that we have so much information, and yet we have so much information that we don't have, that it would be useful to get the information that we don't have.
Mr. Purcell, I believe that in the case of the Justice Department, almost every piece of information we have has been presented to the committee. I know that, as I mentioned, I believe yesterday, some 36,000 pages of materials have been provided. In the case of Mr. Bolton's notes that you described, most of the time Mr. Bolton only takes notes for immediate purposes of reporting if there is any reason to report, and when transcripts of hearings become available, he routinely then discards his notes because the transcript is a more accurate way of depicting what went on than the notes themselves.
Well, I don't know that I agree with that, General. I don't want to argue about it. The transcript will not reveal what Mr. Bolton said or wrote. And if we don't have those notes, I'd be a little bit unhappy and surprised that they are not available, since they would make a tremendous contribution to this committee. I have not seen any. Maybe somebody on the committee staff knows that they're here. Now let me just switch gears a minute, because you see, it would be very important for you to know as Attorney General if the testimony given in the hearing was in direct conflict with the facts as early as possible. I just can't, you know, for some reason I have a hard time with that. And it would have to be relayed to the question of, do you turn it over to the criminal division? Do you go to independent counsel? Now, all of that may have been in your mind. At some point in time, you may have decided, well, there's so much here, I just can't take a chance. There's potential criminal liability. It's a possibility, and we got to avoid the conflict, and we just have no choice. We've got to go for the independent counsel. But I must say, my recollection is, when it started out, there wasn't very much enthusiasm for an independent counsel. That's the way I recall it. Whether that's fair or not, I don't know. Now, you had a press conference with the President, and I think I know part of the answer, but why did you have that press conference with the President?
Mr. Fussell, the reason was that the President, as I mentioned, I believe, in my opening statement and a couple of times since, the President was adamant that the information that we had at that time be presented to the Congress and to the American people. And as I believe I indicated in my opening statement, the purpose was to make it clear that there would be no withholding of information from the American public and from the Congress, and that there would be absolutely no basis for any charge of any cover-up. And I think that was a wise decision of the President, which has been validated in effect by a number of the comments that were made during the course of this hearing.
I think it was a wise thing to do also, Mr. Meese. I have no argument with that. But what got me is something that we've dwelled on a long time here, about North's surprise when he found out what was happening. He was a little bit stronger than that when he was testifying. So was Secord, and Poindexter a little less so. But, you know, basically, and I'm paraphrasing here, the record will speak for itself, but as I remember Colonel North's position on this, based on a direct question and an answer there, too, he said, man, they just threw us over the side. Now, what I've been struggling with this whole time is why he would have that feeling. In fact, I got a total feeling of animosity as far as the AG was concerned. One would be led to conclude that he was literally shocked out of his boots that, one, the information would be made public. You have testified you have no reason to understand why he would take that attitude.
Oh, no, Mr. Fussell, I can understand why he would take that attitude, because Colonel North, as you know from his testimony here, believed deeply in what he was doing. And I have a very great respect for Colonel North. I have a great respect for his exemplary military record and for him as a person. And I can fully understand why he would have that view. At the same time, I hope he and others would understand the position that the President and I were placed in, and that is that neither of us could carry out our responsibilities with the possibility that someone would claim that we were withholding information from the public, from the Congress, or that we were trying to engage in some kind of a cover-up. And that in the long run, the interests of the United States would be harmed more by a failure to reveal this information promptly, as we did.
Well, General, I thoroughly agree with you, and it would be unreasonable, it seems to me, except in the heat of passion or, as you say, enthusiasm, to assume that the diversion could remain secret forever. Now, that was a judgment you had to make, wasn't it?
Yes, sir, and also there was a matter of the integrity of the administration and of the government in terms of something that had been unauthorized and something that had major policy implications as far as both the administration and the Congress.
Now, you also had to make another decision in that press conference, and that was you had to say that with disclaimers, you were right in doing it that way, that there was a diversion of funds, and that and this was a preliminary decision with disclaimers, but this money did not belong to the United States government, as I recall your statement at the time. And I know that you've allowed yourself plenty of room to deal with the fact that it might be U.S. government money through constructive trust or conspiracy or otherwise. I know that, so I'm not. But what gets me is, why did you have to make that statement at that time? What was your judgment in saying, we've discovered a diversion of funds, it's X number of dollars, and we believe to start with that it's not public money?
The distinction I was trying to make, Mr. Fussell, and perhaps did not make it sufficiently accurately at the time, was that this was not taxpayers' money in the sense that somebody had taken money out of appropriated funds.
In other words, it wasn't appropriated funds.
I wanted to make it clear that this was not appropriated funds which were being diverted, but rather that it was from the profits of the arms transactions which were over and above and beyond anything in the nature of appropriated funds.
I must confess, General, that when I first read that, the impact on me was, well, folks, we've done our job. Now, we want to tell you that arms went there and there was extra money, but don't worry, because it really doesn't belong to the United States. I mean, that's the impression I got.
Perhaps the phraseology, in retrospect, obviously with the time that we've had now to discuss this matter, we might have changed the phraseology. I think the important thing is what I mentioned.
Get it out.
Was to, number one, at that time to get it out, but as I mentioned earlier in my testimony today, we also immediately took steps to safeguard whatever money was still available so that it could be recovered for the benefit of the United States based upon the appropriate legal theories.
Now, were you consulted or involved in a decision as to when the President would appear? For example, at the press conference, a decision was made to have the President with you to demonstrate a follow-on, I gather, that of the President's request and order, and that here you were, the Chief Legal Officer, responding to the American people. Did you participate in that decision?
The President said that he wanted personally to present this to the American people, and really I was along as a supporting player, if you will, because I had the factual information on the basis of what had happened that weekend, and that was the reason that he asked me to lay out the facts for the people. I might also say, if I could, Mr. Fussell, just so that there's no misunderstanding, I did not consider what we were doing was tossing anyone over the side. As I mentioned, I have great respect for the individuals involved, and I think in that news conference I was very careful not to attach any blame or charge of illegality against any of the people who were involved, but merely to report what we had found. And I think that was important to me at that time, and it's still important to me today.
Well, I appreciate that. But the decision then for either presidential statements or other statements coming out of the administration after you took charge of this operation, were you involved in those decisions? Did you participate in that on the basis of your fact-finding, your legal background, et cetera?
I participated in the decision to bring this to the attention of the American public on Tuesday, the 25th of November, but it was hardly even a decision. There was no one who voiced a contrary opinion that I know of in the circle around the President. Also, I participated briefly in some other subsequent decisions about public information, but it was only a very tangential participation.
So as far as, if you want to call it the spin or the presentation to the American people was concerned, once you'd made your report, you were basically out of it.
That's correct.
You didn't write speeches or worry about timing or?
No, sir, I did not.
Yeah, well, the reason I asked is because I was curious. Colonel North testified he even wrote speeches for the President, and that meant, you know, that they're really close in trying to decide what to say and how to say it and what to do. It just occurred to me that the Chief Legal Officer of the United States would be involved in those decisions, or should be. I'm a little bit surprised that you weren't. I mean, we're talking about a lot of legal questions here.
Well, on legal questions, I was involved. Of course, there is also a White House counsel that gives day-to-day legal advice, but I was involved on some legal matters that took place after that. For example, the decision to announce that we were seeking an independent counsel. That was the kind of decision where I would be involved in the legal aspects of it. The timing of when it was announced or who announced and that sort of thing would be within the province of others.
Thank you, General.
Mr. Broomfield.
Thank you, Mr. Chairman. Mr. Attorney General, welcome.
Thank you.
Well, I'm happy to see you here, and I want to compliment you on your appearance. I think you've been very direct and candid with the committee, and I think it's been obviously very useful. Listening to you over the last couple of days, I think, frankly, you've been somewhat maligned by statements made by people before you made your appearance before this committee. I think statements that your investigation attempted to cover up or somehow inappropriate before you testified to this committee, in my judgment, has been regrettable. Characterizing your testimony prior to your appearance prejudges the public perception of your participation in these matters. Mr. Attorney General, I think it's extremely important that your involvement in gathering the facts be placed in context. You discovered the diversion memorandum on November the 22nd, as I recall. Within 3 days after your discovery, the President disclosed the Contra connection and made it public to the American people. A lot has been said about the destruction of evidence, but if your fact-finding mission had not discovered the diversion memo, it may have been possible for Colonel North and others, obviously, to eliminate all documentation of the Contra fund diversion. I say, some may say that you did your job too well. Your testimony before the committee has been very useful, and you've been very cooperative and responsive to the committee requests for information. I have just 3 or 4 questions that I'd like to ask you regarding the decision-making process. I think would be helpful for our committee. My first question is, should the Attorney General always be a participant in the review of presidential covert action findings?
Yes, Mr. Broomfield, I believe that the Attorney General should. I think that the opportunity for the Department of Justice to review such findings in advance of a meeting, to be sure that their form is sufficient as to satisfy the requirements of the law and to provide advice to the President on the finding should be and is a very valuable bit of information that can be provided to the President. It's also my understanding that this is a procedure which the Assistant to the President for National Security Affairs is currently developing, and we look forward to participating in such a process, and I believe it would be a very valuable addition to make that a standard operating procedure.
Should the Attorney General be a participant in presidential findings which authorize activities contrary to explicit U.S. policies adopted through law or executive order?
I think absolutely an Attorney General should be involved in the consideration of such matters. I would expect that there would be very few, if any, such findings or such projects contemplated by an administration, but there may be exigent circumstances where it is necessary, and I think to have sound legal advice is very important in those situations.
Should the Attorney General participate in covert activities which the transfer of U.S. military equipment or the employment of U.S. personnel overseas is involved?
I believe that the Attorney General should participate in the decision-making process as to such covert activities, yes.
What about covert activities that could be in conflict with specific international legal obligations of the United States?
I think it's important that the Attorney General and the Justice Department be involved in the consideration of such measures, particularly so that they can provide complete, adequate, and thorough advice to the President in regard to what international law or international legal matters might indicate, so that he will have the benefit of that advice in making his decision on the matter.
Thank you, Mr. Attorney General. Mr. Chairman, I will reserve the balance of my time.
Senator Tribble.
Thank you, Mr. Chairman. Mr. Attorney General, good afternoon. The legal and factual questions that I had planned on pursuing have been more than adequately covered. So what I'd like to do is turn to a couple institutional matters, if I might, Mr. Attorney General. As you know, the committee's attention is now turning to its report and to the legislative recommendations that we will make to the Congress. To that end, I want to pursue some of your earlier and very brief comments, Senator Rudman, about the procedures that apply in the presidential finding process. In the early years of the Reagan administration, all presidential findings for covert activities were seen by the Department of Justice. Your predecessor, William French Smith, insisted on that. Then, because of the opposition, it seems, of the CIA and the national security staff, a decision was made to discontinue that practice. I would say parenthetically, that was before you became the Attorney General of the United States. To date, there have been 33 findings during the Reagan years. 17 findings were reviewed by the Justice Department, and 16 were not. Now, let me ask you, if I might, a couple quick questions about that procedure. Is there an established procedure in the administration in regard to who should review findings? For example, why is it that in some instances the Attorney General is consulted, sometimes not? Often the Secretary of State will be consulted, sometimes not.
Senator, it's my understanding that there has been a difference in the way findings have been handled in the past, and that there has been not necessarily been a procedure that has been routinely followed in the handling of findings. It is also my understanding from conversations with Mr. Carlucci, the current Assistant to the President for National Security Affairs, that a change is being made to develop a specific process, and that this will include, with a high degree of definiteness, which officials are consulted in the case of findings, and that would include the Attorney General as well as the Secretary of State. So I think the thrust of my answer to your question is that while there has been some difference in the way these things have been handled in the past, I think that a standard procedure, as I mentioned to Mr. Broomfield, is being developed at the present time and will guide the handling of these findings in the future.
Heretofore, then, there really was no one that was directing or monitoring that process.
Well, the process was directed and monitored, if you will, by the National Security Council staff, but there was not a routine review of these by other officials who participate in the activities of the National Security Council itself.
Now, surely the Attorney General should have the opportunity to be consulted, and you've said that here today. You've also mentioned the Secretary of State. What about the Vice President, the Secretary of Defense? They too, of course, are members, statutory members of the National Security Council, and would have important input.
I believe that all of the statutory members of the National Security Council, as well as the statutory advisors, the Director of Central Intelligence and the Chairman of the Joint Chiefs of Staff, should participate in the review of covert actions. I also believe that the appointed members of the National Security Council, which would include the Secretary of the Treasury, the Attorney General, and the Chief of Staff of the White House, who normally attend National Security Council meetings, should also be consulted.
So basically what you're saying is that when the administration contemplates these kinds of activities, that all the wise men should be consulted. Because that's an important part of the process, is it not?
I believe it is, and I think that the whole idea of having a National Security Council was to have a single body which could provide the kind of advice that a president needs on these kinds of issues, and that certainly covert action findings and covert action projects are the kind of thing that are contemplated as the ideal subject matter for National Security Council deliberations.
And as Attorney General, you also believe that findings should be reduced to writing as well?
Yes, sir, without question.
Let me turn our attention to the issue of congressional notification. Hard to define, but obviously an important part of the process. The National Security Act, as you well know, requires prior notification to the intelligence committees of the House and Senate for all covert activities. Where there is no prior authorization or prior consultation or notification, the committees must be informed in a timely fashion. Now, there's no statutory definition of timely fashion, and it may well be impossible to legislate one, but we have to have a better sense of what it is that represents timely notice. What, in your view, as Attorney General, should constitute timely notice?
Well, Senator, I think that in the normal situation, timely notice, if there has not been prior notification, would seem to me to be something in the neighborhood of 48 hours. And I believe that there are currently discussions going on between representatives of the National Security Council staff and representatives of the standing committees on intelligence developing some kind of a procedure such as that.
48 hours might not be enough time in my own view, but certainly 11 months is too long. So there has to be notification in a more timely manner. And as I understand your testimony, you were consulted in terms of the January finding, and it was your view that this was going to be a short-lived operation, that notification would follow promptly. And then you really were kind of cut out of the process. Is that not the case?
That is correct. As I believe I stated in my opening statement, it was apparent that I was not among those who had a need to know, and I certainly accept that. I would think, however, in regard to timely, and going back to what you mentioned about timely matters, there may be occasions when, as you point out, 48 hours is too short a period of time. There may be exigent circumstances in very rare cases where more time is necessary for some peculiar condition, which might include some jeopardy or something like that. But I think that that as far as that time, the timeliness, certainly a way to prevent it from going to something like 11 months is that the National Security Council itself should periodically review covert actions, particularly those which have initially a short time frame but which do drag on. And I think that would be another way to have periodic, on a quarterly basis or a 60-day basis, a regular review of covert actions, particularly if there is any circumstance where Congress has not been notified, to be sure that there still is validity, number one, to the action itself, and number two, to the delay in notification of Congress.
What we need to do is to construct a process where decisions can be made in confidence and yet not in a vacuum. It seems to me we have to find a way in which the wise heads within the administration can be fully consulted, and at the same time the administration and the Congress can move forward together. Clearly that's essential if we're going to have coherent policy on the one hand and succeed on the other.
I agree with you entirely, Senator, and I know that that is the desire of President Reagan, and he has specifically requested Mr. Carlucci to develop that kind of a process so that that relationship will result from an effective understanding between the two branches as to how they can best work together for a constructive policy, constructive process that will produce the best results in terms of a policy that will be supported by both the executive and the congressional branch.
Well, let us pursue those matters. We would welcome your advice and counsel, and I thank you for your testimony, and I yield back the balance of my time.
Mr. Foley?
Attorney General, the day is growing late, so I'm not going to take my full time. In fact, I was going to put some questions to you that were the questions, in fact, that Senator Tribble examined, and I think they are important questions, and I want to compliment you on the answers. And I hope that this will be the effort of the President to establish a regular review of covert actions and to establish some understanding of what timely notice is meant to be. I think this is a very constructive addition to the hearings. Thank you.
Mr. Hyde.
Thank you very much, Mr. Chairman. Good afternoon, General. I just want to put a plug in for flexibility when it comes to timely notice. 48 hours is relatively meaningless. I would say one should measure timely notice by the nature of the event rather than the ticking of the clock. For example, in Iran, we had about 6 of our people over there who found their way into the Canadian embassy, and it took 3 months to get them out. Some very fine work by the Canadians and our CIA. And the Canadians insisted that no notice be given to anybody because their citizens' lives were at stake, and one must respect that. And one doesn't want to be violating the law by respecting the wishes of a third country. So
I am not concerned with the phrase timely notice. I think that's about all one should say, and the event should determine whether it's timely or not, in my humble opinion. Let me comment about some benign criticism that the President had the bad taste to appoint a friend to be Attorney General. One must smile at that, because of the ultimate appointment of a friend was by the revered John F. Kennedy, who put his brother in office. And as one passes the hallowed halls of the Justice Department, past the portrait of Ramsey Clark and others, I think we're fortunate to have Edwin Meese in there, and the fact that the President put someone in whom he's known, in whom he has confidence and trust, it seems to me is an asset, not a liability. I too, however, perhaps contrary to Mr. Bolton, for whom my admiration is boundless, don't think badly of the independent counsel concept. When Griffin Bell was Attorney General and Hamilton Jordan had some problems which happily were resolved in his favor, but I felt it perhaps inappropriate that Griffin Bell deal with that, and I think that situation is true members of the Reagan administration. So I have no problem with independent counsels. Perhaps there's some way to structure the law so there's some more accountability, perhaps to a panel of the court, but I have no problem with that. But I notice we in Congress distance ourselves from our own alleged peccadillos, the ethical problems that members of the House and Senate have. We aren't enamored of the idea of an independent counsel looking into our problems. We keep it in the club, so to speak. And, you know, as one who may be the beneficiary of that club someday, God forbid, I can understand the attachment to that notice. But it seems to me a little, I detect a little of the sound of tin when people complain about lack of zeal for the concept of independent counsel when they themselves remove themselves physically and spiritually and politically from the same concept. Now, my friend from Maine, who's not here, yes, he is here. In fact, I'd say my dear friend from Maine, now that he's here.
What would you say if I were not here?
My very dear friend. I wouldn't want to overdo it, but nonetheless, he talked about the hat trick. Only he had a different hat trick. He said, "Fool the Ayatollah, fool Congress, and help the Contras." That was his hat trick. My version of that hat trick was use the assets of tyranny to support the cause of freedom and maybe get some hostages out. That's a real hat trick, assuming it's legal and assuming it works. I'm not yet convinced, having listened to the dialogue between yourself and members of this committee, that there was a diversion. I don't know. The constructive trust idea is interesting. Judge Heflin read a definition from Black's Law Dictionary that I suppose is acceptable. But as I understand it, General Secord bought the weapons from the CIA, paid up front whatever they charged, whatever they wanted. They didn't release the weapons till he paid for them. Then he in turn sold them to Ghobaniphar. Now, he also marked them up for handling charges, insurance, transportation, and whatever. He set the final price, the ultimate price, to Ghobaniphar, who then dealt with the Iranians. Now, I'm not altogether convinced that those proceeds necessarily belong to the Treasury, since Secord bought them from the CIA and paid whatever they wanted in front. I don't know. I think there's an argument there. I suspect, without knowing, that some of those millions are being held in another constructive trust, perhaps for some Iranians who were willing to pay those prices in the expectation that there would be some bakshish, I believe the term is. I don't know, but I wouldn't rule that out as the phrase goes around here.
Mr. Hyde, I think that you will remember that I was speaking only hypothetically and did not come to any conclusions along that line for the reasons you've suggested.
I understand. I understand. I think it's a fascinating legal problem, and we've all rushed to judgment on it, and I've not seen a real analysis yet. But I'm sure that will happen in another place, perhaps at another time. Mr. Attorney General, in an earlier Congress, where many members of this committee served, I might add, I'm speaking of April 23rd, 1980, it seemed to me we had a clearer understanding of the value of secrecy where hostages' lives were involved. There were 2 resolutions of inquiry in the House demanding that the Carter administration tell Congress everything they knew and had done, documents, information about relations with the Shah, any arrangements made to take care of the Shah now that he had left Iran, abdicated, and the other resolution was for all of the details of our relationship with Iran. And those 2 resolutions were debated on the floor of the House, and one of the people engaging in the debate, who is also a member of this committee, his ideas prevailed, I might add. He said to accuse the White House, and this may be deja vu again, Mr. General, to accuse the White House and the State Department of ineptitude is indeed like shooting fish in a barrel. But what does it profit us? It is our government, it is the only government we have, and if we continue to publicly display our lack of confidence in our government, we continue to provide grist for a Soviet miscalculation. Mr. Speaker, the stakes are extremely high. It's not simply springing 50 hostages. The Soviets are poised on the borders, and if we continue to show division to the international community on the home front, if we continue to divert our attention from the incredible breaches of decency that have occurred by the Iranian government and talk about division and ineptitude and lack of support on the home front, we encourage the Soviet Union and the militants in Iran to say, look, they are falling all over themselves. The longer we hold on, the more they will continue to snipe at their government. I think the stakes are too high to put our dirty linen, and indeed it may be dirty linen, out on the line for the world to see. Therefore, I support the motion to table. And I might point out both of these resolutions were tabled by overwhelming votes, 342 to 57, 314 to 90. And every member on this committee that was in the House of Representatives on that date, save one, voted to table those resolutions, recognizing the need for the lives of the hostages being in jeopardy, the need for protecting them. So, as I say, what goes around comes around. Maybe we'll come back to those times when there was more sensitivity to the lives of hostages, thus permitting some secrecy. Now, leaks have been mentioned by my friend from Wyoming. That's a very sensitive subject up here, because there is a myth that we don't leak. It all happens down the street somewhere. The truth is, of course, everybody leaks. The executive, more leaks from the executive because there's more people connected with the executive. You talk to the State Department and all of the agencies. I guess per capita, we might leak more up here. I don't know of any scientist that maybe Norman Ornstein could go into that, taking time out from whatever it is he's doing. But yesterday's New York Times had a fascinating little squib on leaking, a poll on leaking. I don't have the page, but it's a column called Briefing, and it talks about leaking, defines it, and points out that there was a poll in a magazine called American Politics that circulated to what it calls Washington insiders, members of Congress, government officials, lawyers, lobbyists, and diplomats. Of 780 readers who filled out a questionnaire in the June issue, 28% admitted to having engaged in leaking. Now, I won't tell you how many were Democrats or Republicans, because we are, if nothing, we are nonpartisan in this committee. But I will say this, philosophically, 36% of the leakers said they were liberals, 29% moderates, I guess that's a euphemism for progressive, and 23% conservatives.
So we have 65% of the leakers admit they're moderates or liberals and 23% conservative. I don't know what that adds to our store of information here, but I kind of like that statistic. Thank you, General.
Thank you, Mr. Hyde.
Chair recognizes Senator McClure.
Thank you very much, Mr. Chairman. Mr. Attorney General, I know it's late, and I know you're anxious to get this session completed, and I suspect you're only slightly more anxious than we are. But there are 2 or 3 questions that I think might be helpful to add to the record at this point, just to kind of round out the testimony that you've given. I noticed in particular on page 13 of your opening statement, I'll just read from it. I think you will remember that you had said that you had discussed the matter of the fact-gathering inquiry with FBI Director William Webster, who concurred that it would be inappropriate to utilize FBI investigators. I wonder if you would tell us why you and he thought it would be inappropriate at that stage to use FBI investigators.
Senator McClure, the reason was that this was essentially a policy fact-finding responsibility and putting together facts that had occurred within the executive branch. It was not an investigation, either criminal or civil in the normal sense, and both Director Webster and I were mindful that previous presidents had been severely criticized for using the FBI for normal administrative purposes for the benefit or policy purposes for the benefit of the administration rather than for the purpose for which funds are appropriated, namely for primarily criminal investigations.
I know some have been very critical of you for the fact that you had not launched this investigation as a criminal investigation at an earlier time. And you have rather extensively answered that question in several different ways today. But I think it's one of the more puzzling and perplexing to a number of people as to why, if you had these hints of wrongdoing, why didn't you seal the records and lock up the doors and exclude the personnel and be worried about shredding documents and so on? It's also been suggested here, I think by earlier witnesses and alluded to today, that Poindexter, McFarland, and North have all expressed some resentment of the fact that they were kind of being left on their own, that they were not being supported by the President as they believed they ought to be. I think that is a fair characterization of at least a portion of their testimony. And if that is the case, what would they have done at that time if, instead of asking them what the facts were, you'd started reading them their Miranda rights? Would you have been more likely to get information or less?
Senator, I think there's no question in my mind that we would have gotten less information if we had proceeded in that manner, plus the fact, as you've implied in your question, there was absolutely no basis to commence a criminal investigation at that time.
Well, I do believe there are a great many people who are wondering about that and have suggested at time to time, indeed, as has been suggested here today, that perhaps you should have moved more vigorously, and I can understand the basis for that concern. But I can also believe that at least at the outset, until you knew what the facts were, or had some glimmering notion of what the facts were, you wanted to get information. That's been one of our problems with this committee over the entire period that we've been charged with the responsibility of getting the facts out to the American public. Is there's parallel criminal investigation and possible criminal action against individuals, and we've had to be very careful as we try to separate the two. The American public is equally perplexed about why didn't we get at it back in January? Why did we wait until so late to get at our investigation and our hearings? And I think there is at least a parallel in your activities and ours, certainly of a different character and a different time. But I want to ask you some questions that I asked of Mr. Cooper when he was testifying, and I will refer to his testimony. It shows in the transcript of the testimony before this committee on June 25, 1987. You're being handed a copy of that transcript. I asked this question: Mr. Cooper, I believe you testified this morning that during the ride back to the office after your luncheon meeting, where you were informed about the diversion memo that the legal significance was still not clear to me. I believe you added it is still not clear to you today. Is that a fair summary of your statement? And he answered, I think that is a fair summary of my statement. How would you regard that question and that answer?
I think what Mr. Cooper was saying, and I would certainly concur with it, is that the legal significance in terms of possible criminal culpability is still under investigation by the independent counsel and will not be clear until that investigation is complete.
And further down the same page, I asked him, would it be fair to say that then and now you are not certain in your own mind with respect to possible violations of law that may be indicated by that memo? And he responded affirmatively. And would I understand that you agree with that?
Yes, I would, Senator, and I think that was implicit in my answer to Mr. Hyde's comment on that a few minutes ago.
And on the next page, he responded again that the so-called diversion issues are not issues that I've arrived at any judgments on. Would you concur in that statement?
Yes, Senator. The judgments, I think, have to be made on the basis of all the facts as a result of an extensive criminal investigation which is ongoing.
And the next question related to the Boland amendments, and he gave a similar answer. Would you agree with that?
Yes, sir.
On page 272, at line 6234, I ask, you have testified that you've come to the conclusion in your mind that at least a good case can be made that the proceeds of that sale, the net proceeds of that sale, are monies that belong to the U.S. government. Is that correct? And he answered, yes, sir. And I went on to say, you were somewhat less than totally dogmatic about that statement, and he responded to say, it is my view, it is my view. I then said, you have indicated that it took you some time to come to that point in your discussion or in your thinking about that question. And I go on and discuss for some time in some detail there in the next several questions about whether or not it was absolutely clear as a legal question that indeed the proceeds of that sale are property of the federal government of the United States. Mr. Meese, you have been an active attorney in a variety of different incarnations over the last several years. Is there any conceivable legal theory under which Mr. Secord could claim that the proceeds of the sale belong to him and not to the federal government?
Well, Senator, without knowing all the facts, it's hard to say, but I think at least hypothetically you can conjure up theories under which that would be possible. I might say that on that particular Monday, we had to do a considerable, Monday the 24th of November, we had to do a considerable amount of checking ourselves with the Army as to the cost of the weapons that were involved, with the CIA as to the process of the transfer and other things, before we were able to arrive at a conclusion that the constructive trust theory that we've heard so much about might even apply. So that there are a lot of factual and legal matters that would go into any determination such as that.
Just as a matter of criminal law, there has to be a union of act and intent. A person must violate a law and he must intend to violate it, or he must have a guilty mind at the time that he performs the act in order to have the requisite basis for a criminal prosecution. Is that not correct?
That is correct, Senator, and one other aspect of it is, of course, that the law must be in such a condition that a person is given fair warning of what the crime is that he might possibly be accused of.
I think that certainly latter is certainly true with respect to the Boland Amendment, because there's a great deal of disagreement among members of Congress as what is meant by that. Not to say that Congress is the best place to go to find out what the law is. Often is not, and I also recognize there are differences of opinion. But I mention that with respect to the proceeds of sale because some people have immediately assumed that if, as a matter of fact, it's determined that that money belongs to the federal government, there must have been a crime in misappropriating it. That would seem to me, at least, that if the parties that were involved in that had any basis upon which they could make a claim, and they honestly believed that basis of that claim, that they couldn't be found guilty of a crime.
Well, Senator, there's certainly intent to defraud is a necessary requirement of theft, and so there are certainly definite possibilities as to potential defenses that could be exercised.
And I mention that only because I don't want this panel, nor people listening to this panel, to jump to conclusions on the basis of what it is we're talking about here. I think there are a lot of questions that we're not going to answer. It isn't our charge to answer, and we cannot answer them. We're not here to determine guilt or innocence. I'm not sure even that the earlier discussion about who is lying or who isn't lying is relevant to the purposes of this panel. Our determination is try to look at process, try to determine what did happen, and there's going to be some ambiguity left when we finish. And as in every trial, a jury is going to be left to make up its mind. The jury in this case is made up of the Congress trying to determine what laws are, the administration as to what process should be, and the American public as to who is or is not telling the truth or is telling the truth. And finally, Mr. Meese, there's been some talk, and you used the term just a few minutes ago, and it really troubles me. And that is, in response to a question that was asked, you'd been cut out of the action after a certain point. And you had responded by saying you understood that determinations are made on the basis of need to know. I understand the need for compartmentalization. I understand the reasons for it in terms of security. But I cannot understand why there would be a determination of need to know or compartmentalization where it came to members of the National Security Council. I think one of the very essential requirements, one of the reasons there is a Security Council, is to get the variety of opinion, and following the old adage that two heads are better than one, that somehow in the process you better have a number of responsible officials look at matters of this kind. And the statute structures who is on the National Security Council. And I can't conceive of the circumstances in which any member of the National Security Council should or could be excluded from the right to know on the basis of need to know. It just seems to me that that's, by definition, impossible. Would you care to comment?
Senator, I agree with you. There may be some unusual circumstances, just as I mentioned, there are occasionally exigent circumstances that require what many might think is the timely notification of Congress, but I think those are very rare, and I generally agree with you that the course that you suggest, that all the members of the National Security Council be fully acquainted with particularly any covert actions or other matters, that is the better practice, and I think it's one that I think you'll find that will be followed in the future.
One of my very bright and able staff people suggested to me when I was talking about what we might ask of you this afternoon, said, well, everything has really focused on 4 days. Nobody's much concerned about what the Attorney General did before the 21st of November, and nobody seems to care very much what he did after the 25th of November. So let's look at those 4 days. If we'll just divide up those 4 days among all of the members of the committee, then each one can get down to the minutes and seconds of the day or night, which I thought was not a bad suggestion. Then he went on to suggest that I could take the period from 1:30 to 6:30 on Sunday morning when you were asleep, and I could just yield back all of my time. And so I will, Mr. Chairman.
The hearing will stand in recess for 10 minutes. The hearing will please come to order. Chairman Hamilton.
Mr. Brooks.
Thank you, Mr. Chairman. And Attorney General, as you no doubt will recall, I've had some problems in the past with your legal position on certain issues, particularly with regard to your suggestion that the President is not required to enforce laws or portions of laws which he believes to be unconstitutional. You will recall that the President and the Justice Department took the position that a certain portion of the Competition and Contracting Act, signed into law by the President in 1984, was unconstitutional. Your Justice Department directed the OMB to issue a bulletin, OMB Bulletin 85-8, that ordered the executive agencies to ignore that portion of the Act. And when questioned about it before the House Judiciary Committee, you took the position that the President can refuse to enforce a statute that he thinks is in conflict with the Constitution. At that point, the House Judiciary Committee voted to cut off all funds for the Attorney General's personal office. And with that action, you remember that, and with that action and two rulings by a federal judge ordering the administration to implement the Competition and Contracting Act in full, the OMB order to ignore portions of the Act was finally withdrawn. Now, in his opinion, Judge Ackerman stated, quote, "Such a position by the executive branch, I find, flatly violates the express instruction of the Constitution that the President shall take care that the laws be faithfully executed." Now, in addition, I'm troubled by your position that the President can delay indefinitely reporting to the Congress when a covert activity is undertaken. In the case of the January 17, 1986 finding, you apparently expressed your opinion that there was no time limit in which the President should report this to Congress. I believe that you testified that you thought the activity was going to take 30 or 60 days and would be over. In fact, it went on for over 10 months, during which time Congress was never told, and I gather you never revisited the question. Now, while I'm not saying that the legal opinion was indefensible, I do think that along with your position on the constitutionality issues, it reflects a little bit of a hostile attitude toward Congress and makes it a little more difficult for us to work together. Now, in addition to questioning some of your legal conclusions, I do find it troublesome that the investigative techniques used in this particular situation, when you called ahead to alert the people that you were sending investigators over to go through the files, and you failed to seal those files for several days instead of doing it that afternoon. And you failed to ask the President and Reagan and Casey, I believe, and Schultz, a lot of what would seem to be obvious, pertinent questions when you interviewed a number of key players and then failed to make notes of the discussions in many cases. You obviously recognized the significance of this whole episode when you recommended to the President, with some courage I might add, that the investigation be undertaken in the first place, but it seems to me that a more tightly structured format for carrying it out would have benefited you and the President, everybody involved, because it would have removed some of the doubt and uncertainty that now surrounds the investigation itself. Now, General, I want to give you and your associates at the Justice Department credit, and I've done so on national television, for recognizing the significance of the diversion memo that was found. It may have been mostly luck that one remaining diversion memo was found, you know. You told them about a day in advance. North was shocked when you showed up with it. He thought he'd got them all, and it was hardly the really product of a highly skilled investigative technique, but fortunately it was found, and you recognized it when you got it. It's 44 in our document list, a long document laying out the whole scenario of what was to be done. But what really worries me is what you didn't find, because there were so many opportunities after you notified them, opportunities for them to shred and to alter and to change and to haul off in various manners. And you wonder what documents might have been lost that might have shed some real additional light on this. So I will say, Mr. General, that you also have some credit for realizing that the President did need to move quickly to disclose the facts. Now, you were a little slow about providing them sometime, and you played a few games with that, but basically you understood the problem and did have the courage and I believe the judgment to encourage the President to do that and to make some changes in those operations at the White House. Now, I've got a couple of questions for you. Were you ever asked by the President or his Chief of Staff or National Security Advisor or anyone else for legal advice as to what extent the National Security Council staff could be used in operational activities such as covert activities?
No, sir, I was not.
Have you been asked for any such advice since November of '86?
I don't believe that I have, no, sir.
Would you think about it a minute? You feel sure that they have not asked about it, inquired about it since then?
I don't believe that any specific advice has been sought on that subject. I believe I have voiced my own opinion in a variety of circles that NSC staff members should not be involved in operational activities. Whether those conversations included members of the White House staff, I can't recall. But I don't think I've had a direct request for my opinions on the subject.
But it was your opinion that you decided since the November of '86 that NSC staff should not be involved in operational activities?
Yes, sir, and I believe that would have been my opinion even before November of 1986.
If they'd asked you.
Right.
Do you believe that the National Security Staff was getting involved in activities which should have been undertaken by other agencies of the government?
No, sir, I do not.
You don't believe that the CIA or the Defense Department or the State Department might well have been acting in those capacities if they had not taken over those activities, sir?
I may have misunderstood your question. I thought you asked the question whether I felt that NSC staff members should be involved in activities.
No, whether they were involved in activities which should have been taken up by the CIA or the State Department or the Defense Department.
Well, again, Mr. Brooks, that requires a judgment on a great deal of the evidence that's been produced before this committee, which I have not been privy to personally, but I think I certainly feel that there is a high degree of possibility that that is true based upon what I know of what you've heard here.
Well, now, General, Colonel North and Admiral Poindexter both have asserted that the Boland Amendment doesn't apply to the NSC staff. And you indicated yesterday that you believe they are wrong and that it does. Is that right?
No, I believe yesterday I was asked questions about other provisions of the Intelligence Act, the Hughes-Ryan Amendment, and other things. On the Boland Amendment itself, you'd have to define which of the several Boland amendments, there were 5 of them, we're talking about. But I then could give you an answer as to whether it would be my view that a particular version of the Boland Amendment would or would not apply to the NSC staff. The only thing I can tell you is that this is something on which we have never been asked for an opinion. I think perhaps that's the answer that you recall. I was asked whether I'd ever been asked for an opinion on the Boland Amendment applying to the NSC staff, and I said no, we had not either been asked or rendered such an opinion.
In addition to this comment, I think North and Poindexter have asserted that their operation to support the Contras wasn't affected by Boland because it was not run with appropriated funds. Do you believe that executive branch officials are constitutionally permitted to organize and conduct American foreign policy initiatives funded by private citizens and foreign governments?
I think there's certainly circumstances under which they are. As a matter of fact, I believe that there were particular provisions in some of the Boland amendments that allowed third country contributions for just such purposes.
Well, General, I want to point out that the Constitution, in my reading of it, vests the power over the purse in Congress so it can control the executive branch in some conduct of both domestic and foreign policy. And Charles I, a former King of England, was beheaded because he attempted to bypass Parliament to raise money to support his own programs. And I think that maybe that incident was on the constitutional framers' minds when they were thinking about this problem in Philadelphia 200 years ago. And I think that to do this, to allow them to raise money privately from private sources, would thwart our whole constitutional system. And I also wonder if that doesn't bring about one of the reasons why we have $8 million that's still over there in Switzerland, and that you have frozen those funds, I understand.
That's correct.
But does that mean we're going to have a chance at getting them?
I certainly hope so.
Well, I hope that we can. I want to thank you and yield back the balance of my time.
I thank you very much, Congressman. Senator Nunn.
Thank you, Mr. Chairman. Attorney General Meese, I also want to recognize you for having had the sensitivity, you and your assistants, to understand the importance of the diversion memo and for also encouraging the public disclosure thereof, as tough as that was at that time. So I do commend you and your assistants for that. Senator McClure asked a little while ago about the Miranda rules and why you didn't read those rules, and you indicated it was not at that stage in your mind a criminal investigation. And I understand that, depending on the definition of when that would have been a thought in your mind. But it's my understanding that your inquiry, and this is the 4 days in November, 21 through 25 that I'm referring to, that your inquiry was basically an information-seeking inquiry. Is that right?
Yes, sir, it was, Senator Nunn.
And it was under the direction of the President of the United States?
It was at the request of the President of the United States,
and
yes.
What generally did he ask you? What was the scope of what he asked you to find?
He asked me to provide a factual overview of the Iranian initiative and to determine who had, what had occurred, and to resolve, to the extent possible, the differing recollections as to a series of events that had occurred during the implementation of that initiative.
So he was primarily asking you to seek information and report back to him with that information?
Yes, sir, and to the National Security Council.
And to the National Security Council. Now, Attorney General Meese, when you talked to Admiral Poindexter on Monday, November 24th, you said it was a brief conversation of 10 minutes, and he essentially confirmed what you already knew.
Yes, sir.
And that is that he knew of the diversion of funds to the Contras.
Yes, sir.
Admiral Poindexter has testified that he told you he was generally aware of the diversion. And then I think you testified yesterday that Poindexter told you, and quoting from that testimony, this is quoting you as to what Admiral Poindexter told you, quote, "Ali has given me enough hints about this, the diversion, so that I generally knew, but I did nothing to follow up or stop it, or words to that effect," end quote.
That is correct.
Is that correct? Did you ask Admiral Poindexter who approved the diversion?
I did not ask him in so many words. I did ask him whether anyone else, whether he had ever told about this to anyone else in the White House, and he said no.
Did you ask him specifically whether he had told the President of the United States?
I didn't ask him specifically whether he told the President. I asked if he had told anyone else in the White House or discussed it with anyone else in the White House, and he said no.
So you never asked him whether he had told the President?
No, I assumed
directly?
No, because that was included in the answer that I had received in the question I asked.
Did you ask him if he had approved the diversion?
Not in that many words, but I did ask him what he knew of it, and he told me, in essence, that he had allowed it to go forward.
So you took that as tacit approval?
I believe that he told me that that was the extent of his involvement, and that I took that as tacit approval, the fact that he allowed it to go forward.
But I believe you testified that you did not believe he had authority to approve that.
That is correct.
Did you ask him if he thought he had authority?
No, sir, I did not.
So you never discussed that with him? Did you ask him when he learned of the diversion?
I don't believe I asked him precisely when nor did he tell me precisely when he had learned. He indicated, as you quoted, that Colonel North had given him hints over a period of time.
Did you ask him why he did not tell the President of the United States about the diversion?
No, sir, I did not.
And he had just said he didn't tell anyone in the White House other than the named individuals. Did you ask him if Colonel North had discussed this or had approval from anyone other than him, that is, anyone other than Admiral Poindexter?
No, I did not, because in our conversation with Colonel North, he had indicated that Admiral Poindexter was the only one in the White House who knew about it.
Well, what about outside the White House?
And the only one he had indicated outside the White House in the government, or who had been in the government, was Mr. McFarland.
Did you ask him whether anyone outside the White House in the government other than Mr. McFarland knew about the diversion?
He told me that. He said that there were only three persons in the United States who knew, the United States government, who knew this, and those were himself, Mr. McFarland, and Mr. Poindexter.
Did you ask him about who knew it outside the United States government?
No, sir. He told me those were the people that knew it.
But he said in the government. Okay. Did you ask him about the people who were not in the government?
No, sir.
That didn't occur to you to ask him?
Did not occur to me.
Did you ever have any conversation with Admiral Poindexter or ask him any question about whether Colonel North and Director Casey had discussed this issue?
No, sir, I did not ask Admiral Poindexter, because Colonel North had told me that, again, just who in the government knew about it, and I asked Admiral Poindexter only whether he had told anyone in the White House.
So you never asked Admiral Poindexter if he had told or discussed this with Director Casey?
No, sir, I did not.
Did you ask Admiral Poindexter under what authority he had approved this diversion by Colonel North?
No, sir, I did not. I don't know whether you were present earlier, Mr. Nunn, or Senator Nunn, but at that time I testified why this was so brief and why I didn't go into a more extensive questioning, and that was that I was literally on my way to talk with the President, and my main purpose was to verify what I had been told by Colonel North the previous day, and particularly as to whether anyone in the White House knew about it and what the knowledge was on the part of Admiral Poindexter.
I did, I heard that. Did you ask Admiral Poindexter anything about the money, where it went?
No, sir, I did not.
And how much it was?
No, sir.
Did you ask him anything about whether the Contras got the money?
No, sir, I did not.
I understand the rush of events that day, but it does seem to me that there were almost no direct questions asked by you to Admiral Poindexter.
Well, that's correct. I mentioned already the time frame, and also the fact that we had had a detailed account of this whole thing by Colonel North the previous day.
But you were trying to determine, as you said, from the President, your directive was to see how you resolve various conflicts, and it seems to me you gave very short treatment to whether or not the two key players in this may themselves have disagreed.
Well, the purpose was to resolve the conflicts and to get a coherent story when we started out on the Iranian initiative. As I testified earlier, we had a totally different situation in regard to the discovery of the diversion of funds, and there the primary objective was to verify what in fact had happened, get an account of all of the essential facts, and then determine what the next steps would be. So the mission considerably changed from Friday noon when it started until roughly Sunday evening when we had a great deal more information.
I believe yesterday you testified that when you told the President you had found the diversion memo, quoting you from yesterday's testimony, quote, "The President was quite surprised and indicated he had not known anything of this," and I believe Don Reagan said at that time, or at least indicated that he was surprised, end quote. Is that right?
That's correct. That's correct.
And when you said that the President said he had not known anything of this, what did the word "this" mean to you? Was that the diversion memo?
Indicated that he did not know anything about the diversion scheme. I talked to him about the diversion scheme.
Did you ask him that question?
Not precisely, no.
Did he volunteer that?
No, sir. Well, he volunteered. He said, you know, this is a surprise to me or a shock to me or something like that.
Try to tell us how that came about.
I can't recall the exact words, but it was clear from his reaction.
His reaction to what? What had you told him?
I had told him about finding the memo and having the conversations with Colonel North and, in essence, the whole diversion scheme. Now, that was told to him in brief initially, and then in more detail when we got together in the afternoon, as I recall.
And so the first thing he said to you was he didn't know anything about it.
Well, no, he indicated that to me by his surprise and shock at what I had told him, and in the course of that, indicated he knew nothing about it.
And when he said that, you took that to mean the whole diversion scheme,
Yes,
not
sir.
simply the memo.
Yes, sir.
Did the President ask you at that stage who had carried out this diversion?
I told him, and I think much of this was probably told in the afternoon rather than the morning.
The afternoon would have been after you had discussed this with Admiral Poindexter.
Yes, sir. And I told him then what the scheme was, the sale of weapons, the profits, and then the profits being diverted. Mentioned the Colonel North, and I believe I told him about the bank accounts and that sort of thing.
Did he ask you about the money and how much there was?
I don't remember whether he asked or whether I told him or gave him an estimate of what we thought it might be.
Did he ask you whether the money went to the Contras?
I think I told him that the money did go to that we had been told the money did go to the Contras.
Did he ask you who authorized the decision?
I believe I told him, particularly in the afternoon, what Admiral Poindexter told me, namely that he knew about it but had not stopped it, allowed it to go forward.
Did the President ask you whether Admiral Poindexter thought he had authority to approve that diversion of funds?
I don't believe that he did, no, sir.
Did he ask you anything about whether Colonel North felt he had the authority to carry that out?
I don't think the question of authority ever came up because it was clear to both the President and myself that nobody had that authority.
It was clear in what way? Did you discuss it? Did you have a discussion with the President that no one had that authority?
I don't know whether we said it in that many words, but there was certainly no question in either of our minds that no one had that authority.
Did you say anything to the effect, golly gee, I wish they had consulted with me or anything like that? Or how did they think they could possibly have the authority to do that? Did he express any sense of outrage?
I think he expressed real concern that this had happened because, and a lot of this was obviously in both of our minds, that this was a major blow, that it cast a cloud upon both the Iranian initiative and on the assistance to the freedom fighters in Nicaragua.
It sounds as if it was more in the terms of you reading each other's feelings rather than express words. Is that a fair?
Well, I think on the part of all of us, Mr. Reagan, the President, and myself, we both had a generally similar reaction, yes.
Did the President ask you whether he should fire someone at that stage?
I think at that point he said, this is now in the afternoon of Monday, I think the question came up, and I don't know whether he raised it or whether Don Reagan raised it, about whether Admiral Poindexter should be relieved of duty, and the President said that was one of the things he wanted to think about overnight because he wanted to consider several things that ought to be done.
Did you talk about relieving Colonel North, or did the President say?
I don't think that came up until the following morning.
And who brought that up?
It was either, I think it was Mr. Reagan, but I'm not positive. I think it came up in the whole general discussion of the different things that ought to be done.
Did the President concur in the termination of Admiral Poindexter and Colonel North, or was it his reaction to this in terms of outrage? In other words, were they terminated based on your recommendation or based on the President's own feeling?
Well, it was ultimately the President's decision. I think it was primarily, or to a great extent, Mr. Reagan, as the Chief of Staff of the White House, who probably made the significant recommendations in that regard.
I wanted to ask you one other line of questioning here. You said in your opening statement, Mr. Attorney General, quote, and this relates to the hostages and so forth, sensitivity to the operation, quote, "We were all acutely aware that if word of the initiative got out, however innocently or inadvertently, it would likely be fatal to the hostages and others helping in their release," end quote. I don't want to go through this whole thing with you. I don't know how much you know about the interview that Reverend Pat Robertson had with President Reagan in 1985. Do you know about that?
No, sir, I don't.
Well, that probably answers the question, but read it to you very briefly. This was a TV interview, and Reverend Robertson has twice in interviews with the Los Angeles Times said that Colonel North told him he was relating and working with the Iranians to free hostages. Colonel North, in testimony, denied that. But getting directly to the question, I'm not trying to get you in that dispute, but Reverend Robertson on television asked President Reagan back on September 20th, 1985, quoting from that interview, "Word reached us that a member of the White House staff was dispatched on Sunday to Iran to seek the release of the remaining 6, and actually was 7 at that time. Is any word on that that might give hope to us?" And President Reagan, I won't read his whole reply. He skirted the issue and handled it, I think, rather skillfully. But the question I have to you is, did anyone say to you that this was a serious leak?
No, sir. I don't remember ever hearing about that before your reference to it now.
This is very puzzling to me because here everyone was compartmentalizing, or at least that was the effort, keeping this very secret. Your testimony and many others was that one of the reasons that you didn't let this get out to Congress or to the other people in administration was the sensitivity, the lives involved. And here the President of the United States has asked a question indicating some very sensitive information is in the hands of the interviewer, and no one knows about it. Nobody investigates it. Admiral Poindexter was never notified. You as Attorney General weren't notified. No one did anything about it. Does somebody monitor what the President says and what he's asked on television?
Normally there are people who are watching those things. I cannot respond to you as to why this occurred.
But you don't have any knowledge of it?
No, sir.
Thank you, Mr. Attorney General. Thank you, Mr. Chairman.
Mr. Corder.
Mr. Attorney General, good afternoon.
Good afternoon.
Yesterday, there was an individual on this panel that suggested that your office and you personally did not cooperate fully with this committee by supplying all relevant documents or information, and I just want to give you a chance to answer that and clear the air. I'm just wondering whether any request in writing or otherwise from this committee, from the chairman, the ranking members of the committee, or the council have gone unresponded by you or your office.
Mr. Corder, not to the best of my knowledge, and we have tried very hard to provide all the information that has been requested. And I might say that this has involved a great deal of time and effort, which we felt was appropriate in view of the President's desire that we cooperate fully with the committee.
Mr. Attorney General, I well recognize there's been a great deal of conversation, a great deal of comments with regard to your investigation. I'm well aware of the fact that if we had you stay here another 24 or 36 hours, we would have been asking you, or had the time to ask you about the investigation for a longer period of time than you were given to perform the investigation or the factual inquiry. I'm also well aware of the fact that hindsight's 20/20, that I can hear the criticisms now of your performance if, for example, you immediately impounded and sealed off and walled off the National Security Council and Oliver North's office, that if no documents were removed or altered or destroyed there, then people would criticize you for not doing the same for the State Department, the Defense Department, the Vice President's office, the White House, etc., that there's no limit to the imagination that we can come up with regard to criticism of that 72 hours that you had to conduct an investigation. But nevertheless, it seems to me that this was, and you must have sensed, you have very good political sensitivity, we all know that, you must have sensed the enormity of the importance of the task that was given to you by the President of the United States way back in November of last year, that business could not be conducted as normal, that there was a great deal of writing on the investigation that you had to conduct in a 72-hour period. And I'm just wondering, you know, based on reflection, whether you would have done anything different. I personally have been critical. Maybe I feel somewhat better about the investigation now after hearing you personally, but I still have the feeling that perhaps additional notes should have been taken, some tougher questions asked. Maybe I don't understand it because I'm not sure what the presidential request was. I know that I saw the movie, I suppose you did too, Murder on the Orient Express, and Investigator Perot walks in the room where the murder was and said, "Touch nothing," and we all expect that's the type of investigation you were to conduct. Can you articulate to a little bit greater degree the type of charge that you felt you were under, your responsibility? Was it a full investigation? Was this something to report to the President so he could inform the American people? Or precisely what was the President's recommendation and charge to you?
Yes, Mr. Corder, let me just start from the end of your statement there. It was not a Hercule Poirot investigation or an investigation at all, really. It was not to assist the President in getting to the bottom of some deep mystery and reporting to the American people. It was, in essence, to correlate information from various people in the administration, all of whom were assumed, as we would in any everyday situation, to be acting in good faith and to be fully cooperative with the President, to look at what people recalled of some events that had taken place up to nearly 2 years before, and then to put that together into a coherent outline so that what the President did talk about with the American people, what he knew himself, and what people testified to before Congress would be accurate and would relate to the different recollections that different people had of what had occurred. It was something quite different than an investigation. That's why I've been rather careful in my depiction of it. It was more akin to having someone develop a coherent piece of testimony to be presented to a legislative hearing.
Oliver North testified when he was here for 6 or 7 days about the fact that his activities with respect to Central America and the democratic resistance there was, I'm not sure whether he said common knowledge, but he indicated that a lot of people knew about it in the administration. It was really not a surprise. When George Shultz came up to him during a retirement dinner, he put his arm around him or came up to him and said, "I know what you're doing and you're doing a great job." When Elliot Abrams wanted to get the bodies of 2 Americans that were killed in the Hassenfuss flight back to the United States, he knew enough to call up Oliver North. Can you confirm that? Was it common knowledge? Was Oliver North's workings and support and coordination of the resistance in Central America, was that common knowledge in the cabinet and in the administration?
Mr. Corder, I would say there was probably general knowledge that he was working in the general field of Central America. I know that he certainly seemed to participate in a lot of activities related to the support of the freedom fighters there. As to how deeply he was involved or what his duties are, I didn't have any specific knowledge of that. He was doing a whole group of things. He was the head of what I believe was called the political military section of the NSC staff, and that encompassed a lot of things such as the Central American operations. It was obvious that he was involved, at least by November, in the Iranian initiative. I knew that he had been involved in efforts to locate the hostages. So there were a number of things he was doing that had to do with that particular aspect of the National Security Council staff.
If someone had asked you the question a few months ago before all this was revealed, that asked you the question whether Oliver North, as far as part of his responsibility, was working in conjunction with private efforts to help the democratic resistance, you would have said yes, you were aware of that?
I think I probably would have said yes, I'm generally aware of that, or it's entirely probable. I wouldn't have had probably any specific information that he was doing that.
You indicated prior in your testimony that had you been asked, you would have recommended against the use of the residuals or the diversion of money from one operation to the other operation. And I'm just wondering, whether you would have made that negative recommendation to the President based on policy grounds or legal grounds?
I think I would have made the recommendation on both grounds.
You indicated also that although you can speculate and someone could argue about the fact that the profits for this weapon sale was possibly a constructive trust arrangement and therefore, in one sense, the property of the United States. I don't read it that way. I'm not in favor of the diversion, and I would not have indicated to the President my support had he called me up. But nevertheless, it seems to me that the United States government did bargain for the sale of weapons to get a certain sum of money, that the United States government does not sell weapons for profit. That was not the motive here. The motive was clearly either hostages or some sort of a rapprochement with Iran or a combination of both. Since number one, the motive of the sale was not a profit, and number two, the United States government got every penny it bargained for, it seems to me that money would have to fall in one of two other categories, and I'd like your opinion. Number one, third country or second country money, or number two, private money. And I'm just wondering whether you'd like to comment on that.
Well, Mr. Corder, I think arguments can be made as to both of those conclusions. I think an argument can also be made, and perhaps even some would consider the better argument, that under an agency or constructive trust theory, it is the money does become property of the United States, because when someone acts as an agent for a principal, whatever profits may accrue, even if unintended, may belong to the principal, so that I think there are a number of legal theories that are applicable here. One of the things that I have indicated earlier is that since this is a matter which will be ultimately the basis for certain conclusions of the independent counsel, I have deliberately tried not to make an absolute conclusion on this matter. We will have an opportunity to cooperate with the independent counsel as to the civil aspects of this at an appropriate time.
I'm familiar with the laws of principal and agents, and it seems to me that an argument could be made that if you do have that type of a legal arrangement, an agency or an implied agency, the agent has to do what the principal wants. And I'm just wondering whether your familiarity with this case now, maybe you can't guess, but I'm fairly familiar with it. It seems to me that if Albert Hakim was called up and said to use the money for something against the United States or against the country of Iran or individual businessmen that he wanted in Iran, he wouldn't have cut the checks. So it seems to me that that theory of a principal and agency does fall down because there was a certain degree of discretion in General Secord and certainly quite a large degree of discretion in Albert Hakim. You don't have to comment on that unless you'd like to. If you'd like to, you can.
I think I'll pass that opportunity.
I thought you
Thank
would.
you.
There's another area, and this is basically my final area. Maybe I can get through before my 15 minutes are up. It does bother me a great deal, and it's something that perhaps is being sacrificed, not wittingly by yourself or wittingly by the administration, but it's the idea of executive privilege. And it's something that our founding fathers wrote about. It's in the Federalist Papers. George Washington performed it. We have elite attorneys in the United States that are concerned about its erosion. It's there for a particular important reason. You indicated in your opening statement that there was, and I quote you, an unprecedented willing disclosure of perhaps millions of pages of sensitive government documents. In other words, in providing these government documents to this committee. And I'm just wondering whether aren't we creating a problem for future presidents with respect to this. Is those people that recommended this full disclosure, the presidential notes, the classified documents given to this committee and other investigators, were they more concerned about protecting this president rather than doing a favor for future presidents, and did not, in one sense, the idea and the privilege and the right of executive privilege be sacrificed on the altar of short-term political gain? And before you answer that question, I might note that one of the distinguished attorneys on these two panels, and someone that I've gotten to know personally and I respect a great deal professionally, Arthur Lyman, wrote, and I'd recommend it to everybody, a remarkable study done by him in 1954 entitled Limited Government, that's Limited Government and Unlimited Investigation. He indicated, and I will read on page 10 of that, theorists, and I quote, thus held that Congress could ask for executive papers and that the President should comply with the request except when disclosure would be detrimental to the best interests of the country. They found no solution to the problem of how to ensure a nonpartisan interpretation of detrimental to the best of interests. And further on in that report, on page 108 on that study of Arthur Lyman, he indicated the following: the other important way of checking aggrandizing congressional committees is for the President to refuse them access to information on the grounds that disclosure would be detrimental to the public interest. President Washington set the precedent for such a refusal in 1796 by declining to lay before the House of Representatives papers relating to the negotiations for a treaty with England. Such refusals are in the shadowland of constitutional law because of the lack of delineation between the powers of Congress and the presidency. I'll skip down, and he concludes as follows: if a committee can convince the public that the reason for the President's refusal is fear of exposure and not public interest, it will eventually have its way. The committee always has its way because the pressure placed on administration not to be publicly criticized for lack of disclosure, for hiding something, for not being candid, not being open, not being in favor of sunshine and full disclosure. And I'm just wondering whether you sense that this investigation, the recommendations made to the President with regard to the release of classified information, and other prior investigations are eroding executive privilege, and whether that's something that's important to try to keep so we can pass on to future executives, or do you think it's worthwhile to sacrifice that on, as I say, the altar of political gain?
Mr. Corder, I share your concern about this whole matter of executive privilege. I am aware of Mr. Lyman's learned paper on the subject, and I think it is a consideration that has to be taken into account. This is, of course, one of those issues in which there's a great deal of balancing has to go into the decisions that are made. In this case, I think the President did two things, and many of us who talked with him about it, some more closely than I on this particular issue, people in the White House counsel's office and so on, assisted him in making two decisions. One is he did not want to, as you suggest, sacrifice the principle of executive privilege, particularly as far as future presidents are concerned. At the same time, he determined that it was important so that the American people would have confidence in the institutions of government, and particularly the executive branch, that there be full disclosure in this particular matter, and very carefully, I think, limited the waiver of executive privilege to this particular issue, and made it clear that he did not view this as a precedent for future presidents or even for himself in similar situations as to other issues. Yeah, I share your concern that this is a very delicate area of the law that where a president has a real responsibility to preserve the institution of the presidency and the attendant privileges of the executive.
Yeah, my concern is that it's not really up to the President, this President, to say that it's not going to be a precedent. A precedent is a precedent because of what happens, not because someone says it's not. And I am concerned about it. I hope this committee is as well. And finally, my time is up. I'd like you to comment. It goes very quickly, believe me. I think it was the Secretary of State George Shultz indicated that he had a recommendation, and that would be that intelligence gathering agencies do not participate in policy recommendations. Do you share that?
I think that I would share the view that intelligence gathering agencies should not participate in policy decisions. I think their technical information is necessary to the decision makers, but I agree that they should not participate in the decision-making process per se.
How about recommendations?
I think recommendations would be appropriate from intelligence agencies because they're the ones that have the technical details to know what should be contained in the recommendation.
I thank you very much. Thank you, Mr. Chairman.
I yield 30 seconds to the Vice Chairman of the Senate Select Committee.
I just want to, on behalf of the Senate Council, thank Mr. Corder for reading Mr. Lyman's junior exposition at Harvard. He advises me he was 21 when he wrote it, that this is the first time anyone probably read it, including the professor he wrote it for.
He has matured in the last 33 years.
Mr. Stokes.
Thank you, Mr. Chairman. Mr. Attorney General, listening to your testimony over the last 2 days, it's obvious to me that Director Casey was a man for whom you had tremendous respect. He was a man whom you knew very well, you worked very closely with, and obviously from your testimony, he was a man of great integrity. Knowing everything that you now know about this case, including conversations you had with Mr. North about it and your interviews with him, do you believe that Director Casey devised a so-called fall guy plan under which Colonel North was to be the fall guy and the one, so to speak, to take the hit? Do you believe that?
Again, Mr. Stokes, I condition my answer only on the fact that I have not heard the testimony that you and the members of the committee have. But that, to me, would be uncharacteristic of Mr. Casey, based upon my knowledge of him.
And I would ask you also, with reference to Director Casey, if you can conceive of him knowing his relationship to the President of the United States, knowing the role he has played in the President's campaigns, and his affection for the President, his high regard for him, if you can see him encouraging Colonel North to divert these funds from Iran without the President's approval.
It would be hard for me to imagine that occurring based upon what I know of Mr. Casey, including what I believe would be his appreciation of the tremendous dangers of doing that to policies that he thought were very important, as well as to the legal and ethical aspects of it.
Mr. Attorney General, yesterday you told us that if you had been asked, that you would advise strongly against the use of excess proceeds from the Iranian arms sales for the Contras. Would you have objected on legal grounds?
Yes, sir, I would have objected on legal grounds, policy grounds, and also practical grounds.
Now, Exhibit 3, which you have there on page 3, lists your telephone calls for Wednesday, November 26, 1986. The first one listed is a 7 a.m. call from Director Casey, which, if I read my copy of it here correctly, was completed at around 8 a.m. It appears that you must have talked for about an hour. You have that, I think it's on page 3 of Exhibit 3.
No, what this means is that Mr. Casey called me at 7 o'clock, but I didn't get back to him until 8 o'clock in the morning. In other words, it was completed at 8 o'clock.
Well, completed means you got back to him at 8 o'clock.
I got back to him at 8 o'clock, right. It wasn't an hour conversation.
All right. How long did you talk on that occasion?
I have no idea. I have no recollection of the call at all.
You have no recollection of the subject matter of the call either?
No, sir.
Mr. Attorney General, this morning, in response to Senator Rudman's questions, you said that you were not aware of the operational role of the DEA agents in locating and extricating the hostages in Lebanon. You recall that?
Yes, sir.
Now, also, when you testified before the House Judiciary Committee, you testified that you were not aware of a plan to use private money to bribe people in foreign countries. You recall that testimony?
I believe the testimony was that I was not aware of a plan to use private funds to ransom people in foreign countries. I believe it was the word ransom.
All right, we'll accept that. I want now to direct your attention to Exhibit 2, which is an NSC memorandum drafted by Oliver North sometime around May or June 1985 that reads in part, once contact has been established and a meeting arranged, the two DEA officers would depart for Cyprus via a European city where they would deposit $200,000 and establish an account for the $2 million, $500,000 of which will be available immediately in U.S. dollars, cash for use in Lebanon. The memo goes on then to explain how the bribes will be paid and transportation for the hostages arranged. The next page explains the DEA officers will rent a safe house, and as soon as the hostages are released, the remaining $1.5 million made available by the donor will be released. The financing of the operation is described as follows. Travel arrangements and operation costs are currently being financed from funds from private sources. Mr. Attorney General, this memorandum from which I've just read was provided to us from your files. So my question is it still your position that you did not know of the operational activities of these DEA agents or of the fact that this operation was financed from private money?
Mr. Stokes, I'm a little bit constrained, as I mentioned earlier, about doing too much talking about this because there are still activities going on in which this information may be relevant. Let me only say this, that the statement that I made earlier, not knowing about operational activities of DEA agents would still stand, and that nothing that I know in this memo that DEA agents would do would be operational. It would be intelligence and support activities. It would not be operational activities within my definition of operational activities.
Well, DEA agents do not become involved in intelligence activities in other countries, do they?
Oh, yes. They become involved in intelligence activities relating to narcotics, certainly.
Yeah, but in non-narcotic matters?
Only in exceptional circumstances such as this. They do not get involved in normal espionage, counterintelligence, foreign espionage, or the type of things that would be done by the Central Intelligence Agency. This was an unusual situation in which the permission was sought to use assets of the DEA in an attempt to assist in obtaining the release of hostages. And since this was a major priority of the administration, it was the judgment of both the administrator of the DEA and myself that assistance should be provided within the general parameters that DEA agents would not be involved in operational activities.
All right. Is it proper to finance the expenses of U.S. government agents with private funds?
Actually, I'm not sure, and it would depend on the circumstances, and I'm not sure of all the circumstances that are involved here. As a general rule, our DEA agents are financed usually by directly by appropriated funds, although many of the activities that our DEA agents are involved in are ultimately financed by the funds of the drug traffickers themselves, because we usually confiscate we confiscate funds. Again, we're getting into some very classified areas, but for the most part, private funds are not used in their finances.
Let's turn for a moment to Exhibit 3, Mr. Attorney General. Your telephone log reflects 3 telephone calls from Ross Perot, the private donor of the funds used to pay off these foreigners. My question is, did Mr. Perot tell you that he had donated this money for this purpose?
I don't believe I ever have had, I don't recall any conversations with Mr. Perot on that subject or anything relating to that matter. I was talking with Mr. Perot on another matter which is of considerable difference and which is also a classified matter.
Was the President of the United States briefed about this operation that we're talking about?
I believe he was by NSC staff members. I can't tell you for sure.
You're not sure?
We're talking now about the activities that included some DEA support and assistance in attempting to obtain the release of hostages?
That is correct.
I believe that he was.
You think it was by some NSC personnel?
That's my understanding.
All right. At no time did you brief him on that?
I did not brief him. It may have been discussed with me or in my presence with him, but I can't recall it.
Directing your attention to Exhibit 4, which is a letter from the President to Ross Perot on January 11th, I think it is, 1986. in which the President says he's been briefed on Mr. Perot's efforts and thanking him for his discreet assistance in this regard. Do you know the purpose for which the President sent this letter?
I had not seen this letter until it was shown to me or referred to in preparation for these hearings. I don't know the purpose or the details of the letter. I can speculate, but I have no personal knowledge.
Did you want to speculate?
No.
Did you say no?
I said no. Thank you for the opportunity.
Mr. Attorney General, you appeared before the House Intelligence Committee on December 19, 1986, at which time I asked you some questions about discussions at the White House concerning immunity or pardon for Poindexter North. You recall that?
Yes, sir.
That testimony has not yet been declassified, so I won't refer to it. I'll just ask you the questions again that we talked about at that time. On December 16, 1986, were you involved in discussions at the White House concerning immunity for North or Poindexter, or both? And will you tell us what was said and by whom?
It's hard to answer these questions again without having the opportunity to look at my testimony before the committee at that time.
We have it here if you'd like.
I would like to see it if I may. All right, yes.
Sure. Okay. Question is, can you tell us what was said and by whom at that time?
As I recall, that there was consideration being given at the White House to develop a way in which the information that Admiral Poindexter and Colonel North had might be brought to the attention of the American people, primarily to eliminate any doubts that might be extant about the President's knowledge or participation in the diversion. And at that time, it was particularly about immunity, although I don't recall pardon being considered, but if it was only considered in the context of pardon or immunity as being used to accomplish the same result. And as I mentioned earlier, at that time I was asked to read a statement that had been prepared, I believe, by White House counsel. I read the statement, made some suggestions that would be a more correct statement of the law regarding immunity. I indicated also that anything that was done along that line should be coordinated with the independent counsel. And I'm not positive, I don't think the independent counsel had been appointed at that time. I think it was appointed a day later or so. Also, I will participate in general discussion as to the way immunity worked, the difference between transactional immunity and use immunity, and so on.
Can you tell us, Mr. Attorney General, who else was present at that meeting?
I believe that it included Mr. Wallison, who was the White House counsel at that time. I believe Mr. Reagan, who was then the White House Chief of Staff. I believe at least part of the time the President was present when the discussion was being held or was being held in his office. There may have been others.
Can you recall on this occasion or any subsequent occasion where you have given the President any advice with reference to a pardon involving either Colonel North or Admiral Poindexter?
I don't believe I have ever discussed, I can't recall at least, discussing that with the President, nor recall him asking me about a pardon as such. As I say, the only possible reference that might have been to a pardon had to do with essentially the immunity aspects that were being discussed on the 16th of December.
Okay. In another area, Mr. Attorney General, I want to be certain and understand your statement of yesterday concerning Exhibit 69, a December 17th memorandum written by Mr. Charles Cooper to you. You were asked whether you agree with the conclusions of this memorandum, and you said that you did with a caveat. And I didn't quite understand what you meant by caveat, and my question is, what was that caveat?
The caveat was that the conclusion that is found on page 18 of the memorandum, which states, for the foregoing reason, and then they give some conclusions, is modified by the initial assumptions that said, this memorandum responds to your request for a summary of the legal authorities, because the exact details of the transfers have apparently not completely transpired. This memorandum will provide a general framework for analysis with reference only to the basic facts that have already emerged. In other words, this is not meant to be a definitive memorandum on a specific set of facts, but a general memorandum using as assumptions the known facts about the covert arms transfers.
All right, and then just one other question with reference to that same conclusion that you've referred to. The sentence reads as follows: an oral authorization by the President would have sufficed to allow CIA participation under the Hughes-Ryan Amendment. I suppose they're making reference there to an oral finding. So my question would be, is it your view that the President can make oral findings that need not be reduced to writing?
He can make oral findings because the law only requires that he find that something is in the national security interests of the United States. So obviously the letter of the law permits an oral finding. It is not something that I would recommend or have ever recommended to the President, because I believe that a memorialization of his finding is absolutely necessary in order to provide a record.
Thank you, Mr. Attorney General.
Thank you, Mr. Stokes.
Thank you.
Thank you. Senator Hatch.
Thank you, Mr. Chairman. Mr. Attorney General, I'm impressed by the fact that when you first learned of the diversion of funds, you and the President reacted immediately, it seems to me, with a plan to go public with the news. And as I listen to your testimony, it appears to me that the President's initial and consistent response throughout has been to tell the American people what happened. Is that correct?
Yes, sir, it is.
In early November, apparently the President was of the view that the press should not be given too much or too many specifics about the Iranian initiatives. Is it accurate to say that he was motivated by a hope that more hostages would be freed and that premature disclosure of specific details might jeopardize that possibility as well as jeopardize the Second Channel Iranians and place both them and the hostages at serious risk?
Yes, sir, that was his concern at the time.
Now, as I understand it, the original deal proposed by the Israelis in early January 1986 was for the Israelis to sell the arms to Iran. What the Israelis wanted from us was an assurance that we would replenish their supplies. Now, when were you told of this original plan?
I was told of that plan that I specifically recall on the 7th of January, 1986.
Okay. Whose idea was it to change the plan and to have us sell the arms directly to Iran under the National Security Act? For instance, in his testimony, Admiral Poindexter suggested that you were the person who suggested that change. Could you tell us the genesis of that change?
To the best of my recollection, it came as a result of a conversation in which I believe Director Casey, Mr. Sporkin, then the General Counsel of the Central Intelligence Agency, myself, Admiral Poindexter, possibly Secretary Weinberger, there may have been others participating. And at that time, I remember being presented with or in the discussion, a variety of alternatives were presented. The plan suggested by the Israelis that you referred to, the idea of using an international arms merchant, and the idea of using the CIA directly involved in the arms transfer. I believe it was probably, I don't know to what extent it came from Mr. Sporkin or could have come from Director Casey, but the fact that the National Security Act provided specific authorization for the CIA to carry out a mission such as this, I think gave to all of us who are participating, at least the lawyers participating, the feeling that that would be a way of carrying out the mission that was more consistent with the language of the National Security Act.
Okay. Whose idea was it to not tell Congress about the initiative?
My recollection is that that was in the plan originally suggested by either Admiral Poindexter or Director Casey, or suggested by the two of them, and that either it was Admiral Poindexter or Director Casey who had mentioned that on the 7th of January, 1986.
Okay, as you read the statute, and I'm speaking specifically about the Hughes-Ryan Amendment to the National Security Act, did you find a constitutional basis for the provision that allowed the President to withhold prior notice to Congress in special cases?
Yes, sir, I did. Both the language of the Act, which says that whatever was being enacted there was consistent with the constitutional duties and responsibilities of the President, and secondly, with subdivision B of Section 501, which has to do with if prior notification is not provided, then timely notification should be provided.
That's the way I read it also. Based on your understanding of the Constitution, General Meese, do you feel it would be an unconstitutional intrusion into the President's responsibility to carry out the country's foreign policy if he were required in every case to give prior notice to the Congress of every action?
Yes, sir, I believe that that could be an unconstitutional limitation on the President's authority.
As you know, General Meese, Congress has the power of the purse, and the President is, to quote Chief Justice John Marshall, quote, the sole organ of foreign relations, unquote. John Jay's 64th Federalist paper explains why the framers gave the President a leading role. He stated this. He said that, quote, perfect secrecy and immediate dispatch are sometimes requisite. There are times where the most useful intelligence may be obtained if the persons possessing it can be relieved from the apprehensions of discovery. There are countless many who would rely on the secrecy of the President, but who would not confide in that of the Senate, unquote. Now, that was John Jay in the Federalist Papers. Now, I think that quote is particularly applicable here, but it is also clear that the Congress is not required to appropriate the funds exactly as the President wants them appropriated. So there has to be a balance. And as Henry Kissinger commented in an article I just read yesterday, an op-ed piece, sometimes we dwell too much on the checks and not enough on the balances that are contemplated in the Constitution. So looking back on the Iran-Contra events, what can we learn about the proper constitutional balance between the executive and the legislative branches of government in foreign affairs?
Well, Senator, I think, as you've suggested, there has to be a certain flexibility in what the President is able to do and the reporting requirements to the extent that they are valid on what he is doing, so that he has the ability to carry out foreign policy and national security policy, particularly in those very sensitive areas where the lives of Americans overseas are at stake. At the same time, I think the power of the purse is one that does belong to the Congress, as you point out, and the best way of achieving a balance, as you mentioned, is to have procedures worked out, such as some of those we discussed earlier, where a President in normal situations will confide in the Congress and obtain their support for his activities, but at the same time have the flexibility in unusual, rare occasions where such consultation or such notification has to be delayed in order to achieve some other national interest.
Well, finally, I'd like to read something that Attorney General Robert Jackson, who later became a justice on the United States Supreme Court, said back in 1940 about the power of the federal prosecutor. He said, quote, if the prosecutor is obliged to choose his cases, it follows that he can choose his defendants. Therein is the most dangerous power of the prosecutor, that he will pick people that he thinks he should get rather than pick cases that need to be prosecuted. With the law books filled with a great assortment of crimes, a prosecutor stands a fair chance of finding at least a technical violation of some act on the part of almost anyone. In such a case, it is not a question of discovering the commission of a crime and then looking for the man who has committed it. It is a question of picking the man and then searching the law books or putting investigators to work to pin some offense on him. It is in this realm in which the prosecutor picks some person whom he dislikes or desires to embarrass, or selects some group of unpopular persons and then looks for an offense, that the greatest danger of abuse of prosecuting power lies. It is here that law enforcement becomes personal, and the real crime becomes that of being unpopular with the predominant or governing group, being attached to the wrong political views, or being personally obnoxious to or in the way of the prosecutor himself," unquote. I think that's a pretty interesting quote. I think it applied then in 1940 on April 1st, and it applies today, and it certainly applies in this instance. In a sense, that quote seems to me to apply to our inquiry here and, of course, to the independent counsel. Now, as the nation's chief law enforcement officer, do you have any comment on what Mr. Justice Jackson, then Mr. Attorney General Jackson, had to say?
Yes, Senator, I certainly concur with the sentiments that he expressed. I have a very high regard for Mr. Jackson in general, but particularly in view of what he says there. And the power of the prosecutor and the necessity of using that power in a very legitimate and proper way to see that justice is done rather than to vent personal prejudices or personal interests is something about which I talk to each training class of entering assistant U.S. attorneys and new lawyers that come to the Department of Justice.
Well, I commend you for doing that. I think that it applies here. I think it does point out maybe some of the difficulties that independent counsels face, because with all the expense, all the months gone by, all the hundreds of thousands of documents, all the people on the payroll, some might feel that they just have to prosecute somebody. And in this particular case, I have to admit there are things that were wrong. There are things that can be criticized. There are things that certainly were errors in judgment. But it struck me very interestingly how difficult it is, unless you just go to what really are catch-all provisions of the law, to find out where the law has been violated here. Now, your efforts and those of your team of lawyers have been scrutinized throughout this process, and they've been attacked with the benefit of perfect hindsight. When I look back on your work in the very short time that you had really to gather the facts, and when I compare the vast resources that this committee has and the independent counsel has and the hours that have been put in and spent by this committee investigating the same facts, we've spent more time in public testimony with a single witness than you had to complete that whole investigation back then. Really, your initial inquiry. Now, when I look at all that, I'm impressed with how much you were able to accomplish with your team of lawyers from the Justice Department, and how well your initial findings have really stood up. Because as you have said, the basic findings you found then are the basic findings that propelled this investigation forward, and which we found after about 8 months, 7 or 8 months, with hundreds of thousands of documents, countless investigative and analytical hours being put in, and of course the benefit of perfect hindsight. So I just want to say this. I want to thank you for your testimony. I think you've stood up well. You've made a good witness, and I think you've made it pretty clear that it's a tough position to be Attorney General of the United States, and I think the American people probably appreciate that more than ever at this particular time. Thank you, sir.
Thank you, Senator.
I used about half my time, so I turned back the rest of the committee.
Thank you very much. Mr. Attorney General, apparently my hope that we would be out of here by 6:30 will not be fulfilled. We have approximately 2 hours remaining if all members decide to use their time. My question to you, sir, would you like to have a recess at this moment, or shall we just plug along?
Mr. Chairman, I would prefer just to continue. I'll be happy to stay here as long as the committee wishes.
Fine, sir. Thank you.
Mr. Aspen.
Thank you, Mr. Chairman. Mr. Attorney General, let me just go back over one thing, and I'm kind of intrigued by a question that Mr. Stokes raised about Mr. North being the fall guy. And I was looking at your testimony, at the transcript of your press conference,
the time you announced the diversion and laid it out. And as you have said, there's a lot of points at which you put in a lot of qualifiers and other things saying we didn't know and we weren't sure. But on the part about who knew and what they knew, you were pretty firm at that point. And I'd like to just read the relevant passages. Here you are saying, here's the question. General Meese, who in the NSC was aware that this extra amount of money was being transferred to the so-called Contras or under their control? Did Admiral Poindexter specifically know? Who else knew? And did the CIA know? Was CIA Director Casey aware of this? Your answer was the only person in the United States government that knew precisely about this. The only person was Lieutenant Colonel North. Admiral Poindexter did know that something of this nature was occurring, but that he did not look into it further. And what, if I could follow up, sir, what about CIA Director Casey? CIA Director Casey, Secretary of State Schultz, Secretary of Defense Caspar Weinberger, myself, and other members of the NSC, none of us knew. When you say that Poindexter knew, do you mean he approved of it? No, Admiral Poindexter knew generally that something of this nature was happening. He did not know the details. Did he try to stop it, though? I don't know precisely when he learned it. He knew of it sometime during the last year. But did he try to stop it, sir? He did not try to stop it. That's pretty definitive and pretty categorical. There's no, well, we think at this point, or we have some impression at this point. And I take it from your subsequent testimony that this definitive opinion about what Admiral Poindexter knew or did not know, and your testimony yesterday mainly, came from that brief meeting you had in his office. Is that correct?
That's correct. What I was relating there in the passage that you quoted was, first of all, what Lieutenant Colonel North had told me about his own knowledge, and secondly, what Admiral Poindexter had told me about his participation.
But you went with a flat statement, and you did not ask Admiral Poindexter the flat question, I take it, is what you're telling us. Your testimony yesterday said that you got from the conversation that he knew something about it, but you didn't press him, saying, what did you know, how much did you know, etc.
I got from him what he told me, which was all that he told me at that time that he knew about it, namely that Colonel North had given him hints about what was going on so that he had a general knowledge and that he didn't follow up on that or do anything to stop it.
I'm just kind of surprised that you went with such a flat statement at the press conference, given the kind of sketchy information that you had at that time.
Well, I felt it was important to tell all that we knew at that time, and so I related, I think almost verbatim, what Admiral Poindexter had told me about his participation, and I related again almost verbatim what Colonel North had told me about his participation.
But without
any qualifiers. Without any qualifiers, because that I did remember exactly what they had told me. And I might say also that there were qualifiers before and after that about our general state of knowledge, which certainly applied to that. And furthermore, what I was doing was talking about what people had said they had done. I was not attaching any evaluative content to it as to whether they were guilty of crimes, whether it was proper or not proper.
I understand. Did you ever follow up with Admiral Poindexter any other questions about it? I mean, when he resigned, you talked to him on the morning of the 25th and told him that it was time to resign.
I talked to him very briefly on the morning of the 25th, and I did not go into anything further of a substantive nature at that time.
According to your testimony of Poindexter, you told him that now was the time to resign.
I told him that I was sure that his resignation was going to be requested, and that that it was the time. He had talked to me about that the previous day.
Did you relay your feelings about the case of Colonel North? I mean, Admiral Poindexter testified or said that you at that time said that Colonel North said that Colonel North was not guilty of anything at that point. Do you remember that?
I don't recall specifically that, but I certainly may have said that because at that point we had made no evaluation of any criminal activity.
But the diversion then, in your mind, at that point was not a criminal activity?
We had not at that point established for sure, well, at no time did we ever establish for sure that it was a criminal activity.
No, but so at that point you did not believe that the diversion was a criminal activity, is that correct?
I didn't know that it was certainly for sure. And as a matter of fact, we were at that time in the process of examining to see whether there were any applicable laws. And that was going on late Monday night, and then it was further going on Tuesday.
Why would Admiral Poindexter get the word from you that he should resign? Why
It
would that?
was basically because the afternoon before, when I was talking with him, he said to me, I knew when this started to come out, I said, I knew when I heard from Colonel North that if this came out, I would probably have to resign. And he said, I trust you more than anybody else in this whole thing.
To make that call?
Well, in general, just trusted me for advice generally in the whole thing. And so I felt that the next morning that it was only fair that he hear from me what the probable consequences would be.
Why did you think that it was important for him to resign at that moment?
Well, I think for several reasons. One is that there was no question in the Chief of Staff's mind of the White House that he would have to resign, and he ultimately had the primary responsibility to the President. And also, in my mind, I didn't see how he could continue in view of this unauthorized activity having taken place under his watch, where he knew of it, and just as he testified here, and as the President said that day, he took the responsibility for it. He was unfortunately responsible. I have a very high regard for Admiral Poindexter as well as Colonel North, both as individuals and for the fine job they did for the administration. And this whole matter, at that time particularly and since, has been a matter of great sorrow to me.
Let me lay out a theory. If I was a real cynic like Quarter, and not like I am, but like Quarter is, if I was a cynic like Quarter, I might put together the facts as I see them and come to the conclusion that I don't know whether you personally or Mr. Casey, somehow somebody was operating a Plan A and Plan B. Plan A was, we cannot tell a lie, Ollie did it. Plan B was, we cannot tell a lie, John Poindexter did it. And let me lay out the evidence for that. First of all is the nature of the investigation that you conducted and your very definitive statements here at the press conference. Second is the evidence of that is that John Poindexter did not reveal right away that he in fact had authorized the diversion and had not told the President. We questioned, the committee was very puzzled why John Poindexter didn't say that right away and avoid an awful lot of speculation over these months in the paper as to whether the President knew or didn't know. He didn't come forward right away. And I think it was because you all were operating Plan A. It is consistent with North's testimony before this committee that he was willing to take the political fall, but not the legal fall. It's consistent with a North testimony of a conversation that he had with Bill Casey, where North said that he would be willing to be the fall guy if this ever came out, and Casey remarked to him, well, you're probably not big enough. We would have to go probably higher to Poindexter. It certainly is consistent with the fact that Poindexter was allowed to resign and North was fired. And it's consistent with the fact that you told Poindexter that it was now the time to resign. I think you were operating under Plan A. And if Plan A did not succeed, and looks like Plan B is, my question to you was, what was Plan C?
All of the imagination that you put into this is incorrect. There was no Plan A and no Plan B, and I have no idea what Plan C might be conjured up in your imagination.
So you're not going to confess? No? I have no more questions, Mr. Chairman.
Senator Sarbanes.
Thank you very much, Mr. Chairman. General, I want to direct your attention to your opening statement. And on page 2 of that statement, you say that the administration has thoroughly cooperated with the independent counsel and will continue to do so. And you then state as the concluding sentence, it is imperative both in fairness to the independent counsel and to those individuals who have been involved in the Iran-Contra matter that his efforts not be prejudged or impeded. And I take it by that you would mean that any assertions, whether the independent counsel should or should not prosecute, are really not appropriate. He should be allowed to do his job without receiving a counsel from outside as to what decision he should reach. Is that the import of that sentence?
Yes, Senator.
Now, did I understand you earlier to say in response to Congressman Aspin that you continue to have a very high regard for Admiral Poindexter and Colonel North? That you said you had a high regard. You continue to do so?
I have a high regard for both of those gentlemen, yes, sir.
In light of some of the testimony that they gave to you, which subsequently proved not to be correct or accurate?
Senator, I think you have to look at an individual on the basis of all the things you know about them. And I know about Colonel North that he has an exemplary war record of heroism, that he worked very hard for the President and for things that he believed in for this country, that he has continually exhibited in the time that I knew his work at the White House while I was there, a high degree of enthusiasm and at great personal sacrifice in terms of time with his family and other things. I know that Admiral Poindexter is one of the finest men I've met, a man who has sacrificed a promotion, assignment in the Navy, which would have, had he accepted it, gotten him away from the White House at a time, and he might well be the next Chief of Naval Operations or a future Chief of Naval Operations. He sacrificed those opportunities to do what he thought was a task where he could better serve this President. I think when you look at a person's record, and some things have come out here that would tend to detract from those reputations, but in both cases I think you have to look at the entire history and experience and background of the individuals, and I can say that I still have high regard for both of them.
Recognizing the things you've commented about, do you think they leveled with you in full in the course of the factual inquiry which you were conducting?
This is a difficult question for me to answer for the reasons I stated to the Chairman and others earlier, that I don't have the benefit of much of the testimony that has been given before this committee. And I also don't think that it is my place, quite frankly, to sit in judgment upon them.
When you met with Admiral Poindexter, I must tell you, I still find it a puzzlement as to why you never interviewed him, in effect, over the course of your investigation beginning, your inquiry beginning on the 21st of November. I mean, you had an extended discussion with Colonel North, Secretary Schultz, with former National Security Advisor McFarland, but not with Admiral Poindexter. And while you've addressed that matter a number of times in your testimony, it still is a puzzlement to me how you could carry out this inquiry without a proper session with Admiral Poindexter, who after all was the National Security Advisor and in the significant person in the chain of command.
Well, Senator, the reason was that we were planning, when we started out this whole matter, to interview Admiral Poindexter. The order of people that we took was primarily to get at those things that I had no knowledge whatsoever about, which were the incidents that took place during 1985. During 1985, Admiral Poindexter, to the best of our knowledge, had very little to do with that, because with the Iranian initiative, because most of those activities, according to what we had been told, were undertaken by Mr. McFarland, and later on we learned by Colonel North. But there's no doubt that had the diversion situation not been discovered, that we would have had an extensive interview with Admiral Poindexter as well.
Well, why didn't the discovery of the diversion memo make it even more essential to have such a session with Admiral Poindexter?
Because we looked at the people who were most knowledgeable, and that was Colonel North. We got a complete outline from him as to what had occurred. The point at which Admiral Poindexter came into that was not in how the whole transaction went forward, but how much he knew, what he knew, and those were the questions that I asked him.
Well, now, Colonel North, in your interview, did not assert that he was doing the diversion on his own, did he?
I don't believe that he asserted that he was doing it on his own. He told me that Admiral Poindexter knew about it.
So Admiral Poindexter, who was next in command above Colonel North, became a key player in that matter, did he not?
Yes, and that's why I talked with him.
Well, but only in passing, as I understand.
No, it wasn't in passing. It was for a very specific purpose, to find out what he knew, who he had told, and what his involvement was in this whole matter.
Now, that was on Monday?
Yes, sir.
You had one meeting with Admiral Poindexter
Yes.
on Monday, the 21st?
Right.
And then on Tuesday morning, you summoned him to your office in order to tell him he was to resign?
I had heard from Mr. Reagan that it was his feeling that Poindexter would have to resign that day, and that he was going to recommend this to the President. I felt, for the reasons I mentioned, I believe, to Mr. Aspen, that just on the basis of the confidence that Admiral Poindexter had in me, that I wanted to tell him that because of our conversation the previous day.
When you went to the President to say that you thought this job ought to be done, I take it that's how it originated, is that correct?
We're now talking about Friday, the 21st of November.
Yes.
At that time, I told him that I felt that someone should put together a coherent account of all of the things that had transpired in regard to the Iranian initiative, so that there would be a factual overview on which we could depend for testimony and for public statements.
But you went to the President with that idea?
Yes, sir.
Did you ever ask the President what he knew about the various matters in the course of carrying out your inquiry?
No, I did not. At that stage, no.
Well, did you at any stage before the press conference on the 25th of November?
No, I didn't. Well, yes, I talked to him about this, and I learned that he knew nothing about this diversion, which was the main subject of the press conference on the 25th.
Well, now, you said just a few minutes ago that another part of it that you were looking at was what occurred in 1985.
Right.
Which, as I understand, was one reason you placed such an importance on McFarland's testimony rather than Poindexter's, since he was the National Security Advisor at that time.
Yes.
Now, I take it that related to the November shipment, amongst other things?
There were two shipments in 1985, one of TOW missiles, 508 missiles, I believe, in, I think, August or September, and then the Hawk missiles that were shipped in November of '85.
Now, did you ask the President about his knowledge on either of those matters?
No, sir, I did not. I'm sure we would have gotten into that later on, but as was already testified to today, as soon as we learned about the diversion, that changed entirely the focus of what we were discovering and what would be presented to the American people.
Now, you didn't ask Admiral Poindexter about it either?
No, sir.
Although the testimony here is subsequently revealed that with respect to the November shipment, the President signed a finding, and Admiral Poindexter tore it up, which would have been highly relevant information for your inquiry, would it not?
Yes, sir.
Now, when did you find out that there had been a shipment to Iran in November of 1985?
I believe I found it out in November of 1986.
And when you found it out, did you find out it had been a shipment of arms?
Well, initially, I think the information I got was that it was first known to be a shipment of oil drilling parts, but that later it was discovered that it was a shipment of arms.
Now, when you interviewed Mr. McFarland, he told you it was a shipment of oil drilling parts. Is that right?
I think by that time, I think he told me that he had been told by Mr. Rabin that it was a shipment of oil drilling parts.
You testified yesterday at some length about being told that they were interrupted at the Geneva summit about this matter, that a phone call was placed to the Prime Minister of a friendly country to intervene for the shipment to go through. Did it strike you as strange that that kind of high-level intervention should have been necessary in order to move a shipment of oil drilling parts?
Well, Senator, we were told either by Mr. McFarland or Colonel North, or perhaps both, that the representative of Israel had indicated that this was a very important shipment that had to do with a project in which the United States was interested, namely the Iranian initiative, or the Iranian relationship that was going on at that time.
It did not strike you as strange that you would be intervening with the prime minister of a country to move through oil drilling equipment?
At that time, I knew that these were arms. Mr. McFarland had indicated he had been told by Mr. Rabin that it was oil drilling equipment. All I knew is that he considered it important enough and a significant enough shipment that he felt that it was proper for him to intervene.
You did not ask Mr. McFarland that question?
I don't recall asking him that question per se, no.
Well, I find it very difficult because Judge Sophia in his deposition, and in fact when he called Cooper in your department about the fact that this was about the statement that was to appear in Casey's testimony, that no one in the United States government knew that the November shipment was Hawks as opposed to oil drilling equipment. And he responded that the claim was impossible in light of what he knew to have been the conversation between the Secretary of State and McFarland in November of 1985. And then he went on to say, yes, and I also thought it was untenable as a matter of logic that the CIA would not have reacted in the way that Casey's testimony indicated. That is, with a warning that they would not do this again. And generally the whole thing smelled to me like the kind of thing you see in a trial, and I've presided over hundreds. This is Judge Sophia's deposition. In a narcotics case, for example, where they refer to the drugs as shirts or something like that. You always have some kind of phrase that you use to describe what you're selling when you don't want to talk about it directly. Question, and here it was oil drilling equipment. Answer, right, oil drilling bits. Now, did you have the same suspicion?
Well, Senator, I don't think I had the same suspicion in the same sense because I knew what was involved there. It was a matter of my finding out what people recalled, what their recollection was. As I was going through this, it was not a matter of cross-examining people at that stage or even trying to resolve conflicting accounts, but trying to find out what people did remember so that we could put these different pieces together. I think that obviously Mr. Silver, at this stage, as I would, with all the information that's now available, might have a very different view.
Let me ask you a couple of follow-up questions on testimony that was given in the course of the day. At one point, when it was the question was put to you why, when you met with Director Casey on Saturday night, the 22nd of November, you did not raise with him the diversion, which you had found out about midday of that day through the discovery of the diversion memo by Mr. Reynolds. And you responded, amongst other things, and said, well, the committee would be criticizing me now had I told Casey for tipping him off. And it just prompts me to put the question to you. Was one of the reasons for not telling Casey that Saturday night to guard against such a danger?
No, thank you. No, Senator. I had no idea at that time of any such danger, so to speak. It was just, as I mentioned earlier, the natural lawyer's instinct, I think, that you don't tell somebody about something, even someone as close as a friend as Mr. Casey, until you know all the details when you're in the process of finding facts.
Were you aware of the close relationship apparently between Director Casey and Colonel North?
No, I was not. Not until I heard testimony here.
Now, in response to Senator Mitchell earlier today, I think you indicated the view that the documents that Colonel North destroyed on Sunday night, late Sunday night, early Monday morning, from 11 p.m. to 4 a.m., were irrelevant.
I didn't say that they were irrelevant. I said they may have been irrelevant. I have no idea.
It's not, a reasonable person could certainly proceed on the view that North, having had an interview with you at some length on Sunday afternoon, and then going to his office at 11 o'clock that night and engaged in extensive shredding until 4 in the morning, the pertinent documents might well have been shredded. That's not an unreasonable view to take, would you say?
It's not an unreasonable view after the fact, learning those things. Although I think one of the things that we did know at that time is that we had been through the documents, our people had been through the documents, and they had in fact discovered this particular document that led to the discovery of the diversion.
Of course, the diversion was an alarm bell amongst other reasons because the covert operation with respect to Iran was being done pursuant to a presidential finding, which you had been involved in preparing, as I understand it. In fact, I think the legal analysis came from you for the January 17 finding. Is that correct?
Well, no, I concurred in the legal analysis that was presented by General Counsel Sporkin.
Well, I think General Counsel Sporkin gave us some testimony that indicates he was relying upon you. I mean, each of you may have been relying on the other in that instance. But in any event, that finding did not authorize taking the money from the transfer of arms to Iran and using them for the Contras. That's very clear, is it not?
That's correct.
And is that the basis on which you became alarmed about that situation?
I became alarmed on the basis that it was that when I learned about the diversion of funds, that was certainly a far cry from what the President had authorized on the 7th of January and in the finding of the 17th of January 1986, and a far cry from anything I had ever heard authorized by him.
And finally, would you take the view that establishing a covert operation of the sort that North, Secord, and Hakeem had set up outside of the channels of accountability is a totally unacceptable way to proceed?
Yes, sir.
Thank you, Mr. Chairman.
Mr. Boland.
Thank you, Mr. Chairman. Mr. Attorney General, slowly but imperceptibly we're coming to the end of this day. You've testified that on November 21st of 1986, President Reagan instructed you to ascertain all the facts concerning the Iran arms transactions. Since you were aware that this initiative was, in your words, rigidly compartmentalized, at what point in your investigative process did you plan to ask the President what he knew so that you could both assure yourself that you had a full account of what had transpired and check the accuracy of other information that you had received?
It would have been after I had put together the information obtained from the other individuals who were involved.
When you informed the President of the diversion on November 24th, did he indicate to you what instructions, if any, he might have issued concerning the provision of military support to the Contras during the period between October 1st of 1984 and October 18th of 1986?
No, sir, I don't believe that came up in the conversation.
Mr. McFarland has testified that he brought the Israeli proposal to ship TOW missiles to Iran to President Reagan's attention in July of 1985, the TOW missiles, but that the President needed a few days to consider the proposal before he approved it. Is it your testimony that during the time he was considering the Israeli proposal, he did not ask you for your legal or personal advice on it?
That is correct. I might also say there was probably a good reason for that. I think I was in either Well, I was not asked for my advice at any time, but he probably, even if he had wanted to, he couldn't because I was in Europe during most of that time.
I'm interested in what was said between you, the President, the Vice President, and Donald Reagan before Admiral Poindexter joined you in the Oval Office on November 25th of 1986. What kind of a briefing did you provide for that group, absent Poindexter?
On the 25th of November 1986, this was at 9 o'clock in the morning. I believe, you recalled, I believe the Vice President was there. I know Mr. Reagan was there, and I know the President and I were there. I think at that time, I don't believe I provided much of a briefing in as much as I had told the President and the Vice President the previous evening what I had found out. It was more a matter of discussing the action steps to be taken, which included the appointment of a special review board, the termination of Admiral Poindexter and Lieutenant Colonel North as members of the White House staff, or the NSC staff, the convening of the National Security Council members to advise them, the convening of a meeting with the congressional leadership, and the holding of a news conference to announce this to the American people. Those were the things we talked about on that morning.
And did you indicate to that group what Poindexter's knowledge was of the diversion?
I believe I had talked to them about that the previous day, or at least I certainly had with the President, and I believe at least in summary form with the Vice President.
As I understand your testimony, in the meetings, you had several meetings, and these would be between January 7th and the 17th of 1986. You attended with the President on the Iranian initiative. Mr. Reagan was insistent that no deals were to be made with any group holding hostages. Secretary Shultz has testified that information available to him caused him to conclude that Iran had absolute control over the hostages. To your knowledge, was that information made available to the President?
I have no knowledge that it was. At all times that, and I was only in one meeting with the President on this subject in January of 1986, but at other meetings, even as late as November of 1986, when this matter was discussed as to the Iranian influence or the extent of their control, I believe we were advised by Admiral Poindexter, it may have been others, that while the Iranians had influence over those who were holding the hostages, they did not have control over them.
You testified that your reading of the applicable law led you to conclude that a, quote, short delay of notification to Congress of the Iran arms sales was authorized. How do you believe that the duration of that short delay was to be defined? How would you define the short delay?
Well, I would define the delay really not in terms of time, but in terms of the reason for the delay. And the reason for the delay was the jeopardy to the hostages and also potentially to people in Iran if this should come out, but particularly to the hostages. And it was established by the President that the delay would only be so long as the hostages continued to be held and that the notification would take place just as soon as the hostages were released and in United States control.
In his testimony, Admiral Poindexter made clear his belief that had the President known about the diversion, he would have approved it. Do your discussion of the diversion with the President on November 24th and 25th, 1986, support or rebut the Admiral's contention?
I believe that the President, had he been notified about it, would not have approved it.
On November 25th of 1986, the administration concluded that a criminal investigation of this matter was warranted. The committees have evidence indicating that there was no FBI search of White House files until November 28th. What was the reason for that delay from 25th to the 28th?
I have no knowledge of any reason for that delay. I do know, however, that the White House files had already been secured as of the 25th, I believe. At least I gave the orders on that day to do it concurrent with the commencement of the criminal investigation.
And
What is your view of the legal standing of a covert action finding that seeks to ratify already conducted covert operations?
In my opinion, it does not have any effect because the law provides that the President make a finding that something is in the national interest or the national security interest, depending on the particular statute, and I think that clearly implies that the finding be made prior to the commencement of the covert action.
And let me ask as a final question, did Reynolds and Richardson and Cooper and you have a nice meal at the Old Ebbitt on the 22nd? Incidentally,
Mr.
it's open
Boland,
until I think midnight tonight, so we'll be able to go and get out here early enough. Thank you
Mr.
very
Boland,
much, Mr. Attorney General.
Let me only say, Mr. Boland, that the meal was a lot better until they told me about the discovery of the memo, and also that the Old Ebbitt has gotten a good deal of publicity out of these hearings, from what I understand.
Thank you very much.
Mr. DeWine.
Thank you very much, Mr. Chairman. Mr. Attorney General, thank you for your time. We're getting close. We're almost there. Maybe we can all go eat at the Old Ebbitt in a minute. You served as White House counselor to the President. I don't know if that's the official title, but you were very, very close to the President of the United States from the time he was sworn in January of 1981 until the time that you were sworn in as our Attorney General. Is that correct?
Yes, sir.
And during that time, you became very familiar with how the White House works.
Yes, sir.
And of course, you're very familiar with how Ronald Reagan works as well, and you know him very well.
Yes, sir.
You know that when President Reagan has all the facts, that he handles the situation very well. That in fact, when he has the facts, he is a strong and decisive leader. Is that correct?
Yes, sir.
You also know that no president, no matter who he is, can function unless he has all the facts.
That's correct.
Now, from your testimony, you described that night when the President, I believe it was on the 19th of November, the President had that press conference. You described driving home and having your car radio on and listened to part of the press conference, and then you got home and went in the house, and I believe you told us that your wife had the press conference on TV, and so you watched the rest of it that time.
Yes, sir.
Is that correct? After watching that, and based upon the testimony that you have already given to us, you knew there was a problem, did you not?
Yes, sir.
You knew that obviously the President of the United States did not have all the facts that night.
It certainly appeared that way from the press conference.
It was clear there was a problem. It was clear that Admiral Poindexter and Donald Reagan, for some reason, were not getting the essential facts to the President of the United States. Isn't that true?
Well, I don't know who was responsible, but I did know that the President did not appear to be in possession of a lot of facts that I felt he should have known at the time.
You've been very kind for these 2 days, and I know you don't want to criticize anybody. I'm not going to in any way try to twist your arm to do that, but they were the critical advisors to the President during that time. You're talking about the Chief of Staff, Donald Reagan, you're talking about the National Security Advisor. Isn't that true?
Well, they were obviously principal advisors to the President. There are a lot of things that go into briefings for press conferences. All
right, I'll let you.
I wouldn't try to pin it on any one person. I think that it was a situation that concerned me rather than any individuals.
As a consequence of the President not having all the facts, frankly, the American people were confused. And that was tragic, was it not? Because this President, when he has all the facts, is not detached and evasive. He's engaged and forceful, isn't he?
Yes, sir, he is. And what was particularly of concern to me was this was an issue of major proportions and major public interest, and also an issue which people for political purposes could severely damage the administration. So it had a lot of reasons why it was important to get accurate facts out to the public immediately.
Now, after you realized that some of the President's closest advisors were, for any number of reasons, apparently ill-serving him, you took it upon yourself at that time to go to the President and ask him for specific authority to discover the facts, did you not? And I believe what you said was either I can do it or somebody else can do it, but somebody's got to get the facts out.
Well, I didn't feel that anybody was ill-serving him in that sense when I went to him on Friday. I was rather concerned that because of the way this whole thing had occurred, that different people had different recollections. That seemed pretty clear to me, and that it was necessary to get a total factual overview.
All right, so when you went to him and then you got that authorization, now, over the course of the next few days, you discovered, according to my notes at least, the following. Number one, a diversion of funds to the Contras from the sale of arms to Iran. Two, that 3 people in the U.S. government, North, Poindexter, and McFarland, knew about the diversion. 3, that the United States government officials were assisting the Contras with diverted funds. And finally, number 4, that the President of the United States, Ronald Reagan, did not authorize nor did he know of that diversion. Would you agree that those were 4 essential facts that in a very, very brief period of time, relatively brief period of time, you were able to find out?
Yes, sir, that's correct.
What did you do with that essential information once you had it?
I presented that information to the President.
And what did the President then do?
The President,
first thing he did?
Well, the President determined that this should be made public. The President also determined that he wanted to take steps to make sure that it did not reoccur. He also wanted to be sure that the people who had been responsible for this were removed from the White House staff, and that the Congress and others in the administration were notified, as well as the American public.
That ultimately resulted then in a press conference, several people leaving the administration, and then finally the Tower Commission. Is that correct?
Yes, sir. All of that was planned essentially on the morning of the 25th of November and then implemented immediately thereafter.
What did you do then, and what did the President do about any possible violations of law?
Well, as already mentioned, I had told him that I would be convening a criminal investigation, or would probably convene a criminal investigation, and as soon as I received information from our criminal division that there was reason to, we did that on the afternoon of the 25th, and then based upon information provided to me by the criminal division that there were adequate legal and factual predicates, I requested the appointment of an independent counsel during the week of the 1st of December. The actual request went forward on the 4th, although I had announced publicly on the 2nd that we would be doing so.
And finally, the Congress, in its proper role, passed the resolution which created this committee, or these 2 committees, actually. How did the President react to that resolution and the fact that this committee has been established, that the Senate committee has been established and the House committee?
The President ordered all members of the executive branch to cooperate fully with the committees.
Mr. Attorney General, I'm not going to take all of my time. Let me just say in closing that those 6 days, and that's stretching it because it's actually portions, by my calculations, portions of 5 days, had to be unbelievably eventful for you. I don't know how you got everything done that you testified that you did. I'm sure you did, but it had to be an unbelievably stressful period of time. You got a lot done. But it was also an extraordinarily important time for this country. You've been criticized, and you're going to continue to be criticized, I'm sure, for moving too slow. Some people have criticized you for moving too fast. Some people said you didn't have the right players in. My first reaction, frankly, after I heard it, was a little critical myself. I would echo what several of my colleagues have said, that it would seem that maybe if you'd got that last day, got Poindexter and North in there and got them in a room with the President, we could have got all the facts out and we would have avoided some of this. But I listened to this morning to your explanation of that, and it seems to me to be a logical explanation. But hindsight, I guess, also could say, and I'm sure that you would agree at this point, that if you had it to do over again, you would have sealed those offices. And again, that's looking back, and we see that the shredding occurred and it did in fact take place. But it seems to me, and this is from one former prosecutor to another former prosecutor, the bottom line is this: you got the job done. You got the facts, the essential facts, to the President of the United States. Your investigation, fact-finding mission, whatever you want to call it, may not have been perfect, it may not even have been pretty, but it was a win. You got the job done, you did what you had to do. Conclusion, let me just say that in this Congressman's opinion, you did not get between the President and the American people. You did not allow others to come between you and the President. You didn't leave the game when the score was against you. And that is this man's opinion. You had, Mr. Attorney General, the good judgment to play to our strength. While others took him out, you had the foresight to put Ronald Reagan back in the game. Thank you for your testimony. Thank you very much, Mr. Chairman.
Thank you, Mr. DeWine.
Mr. Jenkins.
Thank you, Mr. Chairman. Mr. Attorney General, I only have a couple of questions because I think every question has already been asked. I guess the thing that concerns me more than anything else is how important decisions are made by the National Security Council. I understand that Security Council can't make a decision if you don't know about some action that is being taken. But at the time that you rightly decided to get the facts straight on the 21st, I guess it was, Friday, November the 21st, you were just concerned about the 1985 shipments and the discrepancies in the statements that had been made about the 85 shipments. Is that correct?
Well, we were interested in putting together the facts about the entire Iranian initiative, including the incidents that had taken place in 1985, but that was the primary area in which there was much less apparent knowledge and documentation.
And when you called Mr. Admiral Poindexter 9:20 in the morning to set up a meeting with the President, you went with Admiral Poindexter and took Mr. Reagan with you to see the President?
Yes, sir.
And according to the, I guess it is your schedule, you must have spent 45 minutes maybe with the President at that time.
I believe we spent, this is on the 21st, I believe we spent about 20 to 25 minutes with him.
Well, what did you tell the President that the real problem was of the 85?
I told the President that it appeared that different people had different recollections of what had occurred, or partial information as to what had occurred, and that no one seemed to have a complete account of what had happened, and as a result, there seemed to be differences of opinion as to what actually had occurred.
And of course, I would assume at that time you informed him that you didn't know anything about the 1985 shipments yourself, individually.
I'm not sure whether that came up specifically, but certainly I did not, other than what I had heard, of course, on in the preceding few days.
Well, in trying to help you, and the President didn't say, I signed a finding for the 1985 shipments?
So that was the kind of thing that I would be developing in the course of this fact-finding inquiry, would be things like findings or anything else that occurred.
But it would appear to me that it would have been normal for the President to volunteer that he had signed a finding back in 85.
I don't think we went into any of those kinds of details of the particular transactions.
Admiral Poindexter, who had the finding in his possession did not volunteer any information at that time?
No, sir, he did not.
Looking back on it, does that seem unusual to you?
Yes, sir, it does.
I think that type of lack of being forthcoming is the same thing that bothers the committee. For what little time I have, I want to turn to Exhibit 47, which is which are the notes of the interview of Colonel North. And I know that inferences can be drawn that are sometimes the inferences are wrong. And I want to ask you about a couple of statements that Colonel North gave you during this interview. First of all, did Colonel North keep insisting to you that this was entirely an Israeli operation?
I believe he indicated to me that it was an Israeli proposal initially, but that the United States agreed to participate in it and to replenish the weapons and otherwise participate in it, and in effect adopted this or adopted a participation in it.
But he did he state to you that that it was his idea to continue the operation, or was he saying that it was entirely in Israel? I mean, it appears to me from looking at the notes and from your press statement that you made subsequent to this, that you were contending at the press conference that this was an Israeli operation and that we had some knowledge of it.
Well, everything that no, I think there was no question about United States participation. But in 1985, it was primarily the relationship, the transactions between that took place were between Israel and Iran, and the United States' role was in replenishing arms for Israel. But there was no question in my mind that at least after the fact, we had condoned the shipments, and there was some confusion, some differences of information we'd received as exactly what had happened. The things we did know was that the original idea came from the Israelis, or we had been told that the actual weapons shipments in 1985 had been Israeli shipments. The United States had participated later by replenishing the weapons to Israel.
All right, sir. Turn, if you will, turn to page 13 so that you might explain this portion of the notes. If you're on page 13, North believes about the center of the page. North believes that R.R. authorized it himself because M. McFarland, I'm assuming, wouldn't go off on his own. Then down below, North went to talk with R.R., with Reagan, strategic relation, and with Ronald Reagan, it always came back to the hostages, drawn to the linkage. Terrible mistake to say that Ronald Reagan wanted the strategic relationship because Ronald Reagan wanted the hostages. Now, what was he telling you at that point?
I think he was saying that in his contacts with the president's main focus was on freeing the hostages.
And at that point when he made that statement, I'm assuming that the next part is your statement, right. That Reagan, R.R. talked about both, not agree that arms add hostages. Now, what did you mean by that?
Well, I told him that in my contacts, the meeting I had attended, he talked about both, and now this was about both the strategic relationship and the hostages. If it was just the relationship, I didn't think he would agree to the arms, and I'm not sure what add hostages means.
But Colonel North was insisting that the president's primary concern was getting the hostages released. Is that right?
That was his comment, and I felt that that was incorrect because I had heard the President talk in January of 1986, and I'd heard the President talk again on both the 10th of November 1986 when he met with with members of the National Security Council, and again on I believe the 13th of November 1986 when he had talked with people in the congressional delegation.
So you were simply trying to straighten out Colonel Norris.
I apparently made that comment in the course of the discussion. Yes.
Yes. We'll now turn to page 19 and see if you can clarify. Well, turn to page 18 first at the bottom of the page. Question, what else like the Nicaraguan angle? Answer, nothing. And then on the top of the next page, if this doesn't come out, only other is the November Hawks deal. Think someone ought to step up and say this was authorized in November. What does that mean? Someone ought to step up.
I think what it means, and I don't have a specific recollection, but from the notes I would conclude that he said that he thought that somebody ought to come up and say that the November Hawks shipment was in fact authorized by the President.
Which it was.
It was certainly in the signing of the finding after the fact. Whether the President had authorized it before or not, I think this may be one of the things that the President indicated he can't remember exactly when it was authorized.
Well, what does that sentence, if this doesn't come out, the only other thing is the November Hawks deal? If what does
Again, I don't have a recollection, but it looks to me like you might conclude that he was suggesting that the diversion of funds not be made public or not come out.
Well, that's the part that that's the way I read it too.
Right.
Was he asking that you keep this quiet?
I would conclude that. I don't recall that part of the conversation, but I certainly think that would be a fair conclusion here.
No one responded to him on the proposition to keep that quiet?
I don't remember what was said at that time. I know in my own mind that was not a reasonable proposition. I did say, it looks like from this again, and I'm drawing conclusions here based on notes, that I have to share it with the President and see if he was aware of it.
To see if he was aware of the diversion?
Of the diversion, right.
Well, that is the same conclusion that I came to in reading those notes.
Yes.
And I simply wanted to know if that was a proper inference to be drawn, that there was a desire to button this thing up. Is that right?
Right.
Thank you, Mr. Attorney General. Thank you, Mr. Chairman.
Mr. Rodino. Mr. Rodino has 20 minutes reserved.
Thank you very much, Mr. Chairman, Mr. Attorney General. We're back again. Hopefully the witching hour will sound and we will all go home. Mr. Attorney General, yesterday we had an exchange. I asked you questions relative to your conducting a fact-finding inquiry without using the criminal division, and in answer to my question, you stated that you did not feel that it was necessary at that time, and you also interjected, I believe, that you had had a discussion with Director Webster, who somehow or other you seem to suggest that Director Webster had agreed with you and that there was no need for criminal division. Am I correct in recalling that?
Actually, I believe the discussion was in the presence of Director Webster, that it was not a criminal matter, and more specifically, as far as he was concerned, that it was not appropriate for the FBI to come into it.
Well, let me just refer you, Mr. Attorney General, that the record indicates both from your deposition testimony as well as from Director Webster's testimony before the Senate Select Committee on Intelligence that your discussion with Director Webster on November 21st, 1986, and I want to be clear on this, and I refer you to your own testimony, was merely a casual one that occurred on the way out of another meeting. As a matter of fact, I will read part of the deposition, which is yours. What exactly did you tell Director Webster? And your answer: I told, well, I can't recall the exact conversation, but I indicated the President had asked me to do a factual review of the matters pertaining to the Iran initiative, and because there were different people who had different bits of information, and that we wanted to try to put it together into a coherent version of the whole thing. Question: do you explain to him the discrepancies in Casey's testimony? Answer: I don't think I went into specific details about it, other than what I mentioned, that different people had remembered different parts of it. Do you know whether or not he was aware that Mr. Casey was testifying that day? I don't know whether he was or not. Now, turning to Director Webster's testimony before the Select Committee, there were various questions put to him, and the chairman, I think, stated, let me turn your attention now to your conversation with Attorney General Meese on November 21st, 1986, when he informed you of his prospective inquiry. And goes on to say, did Mr. Meese explain to you in any kind of detail why he was conducting this inquiry? Mr. Webster: well, it was a very casual conversation. It was not an agenda item. And he recalls that it was Friday, November 21st, and then in answer to Senator Specter's question, asking again about the conversation, he states, and he said what? This is Senator Specter, and you said, and Director Webster said, as best I can recall, he said, no, I don't think so. I don't think there's any need for it. There's nothing criminal about this that I can see. Do you? And I said, well, no, not on the basis of what I know now. And we agreed, and that was the end of the conversation. I merely point this out, Attorney General, because I'm sure you didn't want the committee to believe that you had had a full conversation with Director Webster as to whether or not he was going to offer an opinion as to whether this was to be a criminal investigation.
That's correct. He was relying upon what I had told him, but as I mentioned...
Which was the result of a casual conversation without any specific details. I just want to get the record straight, and of course the deposition, your own deposition, is here, and Director Webster's is public testimony.
Right,
so
and well, let me just say, I think there is some interesting testimony that Director Webster has given, in which he says that...
When are you referring to?
I'm referring now
to what date?
To his confirmation testimony.
On what date was that?
It was the 8th of April of this year.
Well,
at which time he said essentially what I've said here, that neither of us saw this as a criminal inquiry. The purpose was to try to get the facts straight so that the government could be speaking with one accurate voice, and so on.
Well, Mr. Attorney General, just so that we keep the record clear, I'm referring to a conversation that occurred on the 21st.
No.
And
we're both referring to the same conversation. I'm telling that his testimony about that conversation clarifies or elaborates on what you've said there.
Well, we'll have to leave that to the record.
All right.
We also talked yesterday, and I want to make certain that the record is clear here again, on Schultz's notes on the Contra connection. And yesterday, you seemed to dispute that the committee had any evidence on that point. I just want to make clear, Mr. Attorney General, that and I send to you if you don't have, that there is, first of all, that the committee last week had received testimony from the Secretary of State. It was sworn testimony that he did tell the Attorney General on November 22nd at his interview that he was worried about a possible connection between the Iran arms matter and the Contras. And then in the notes of his special assistant, the special assistant of Secretary of State Charlie Hill, who was present at the Attorney General's November 22nd interview of Secretary Schultz's record, that the Secretary of State told the Attorney General that day, and these are Mr. Hill's words, quote, "Another angle worries me, could get mixed up with help for freedom fighters in Nicaragua. One thing may be overlapping with another, may be a connection." And that is the conversation that took place, which is being reflected by Mr. Hill. I thought that I'd want to keep that record straight.
Well, yes, Mr. Chairman, or Mr. Rodino, I usually see you in the role as chairman. Mr. Rodino, in this particular case, I think the point that I misunderstood at the time was the implication that he saw some connection, some actual connection between the two matters, the Iranian initiative and the freedom fighters in Nicaragua. On the contrary, this appears that people might put a political connection between the two things. As he said, our enemies on the Hill would love to wrap the two together, rather than any actual connection.
Well, let me read you further in the testimony by Mr. Secretary of State in answer to Mr. Belnick, who said and this is on page 115 of the testimony that was given that day, Mr. Belnick, the notes of your interview with the Attorney General reflect, among other things, your expressing the concern to him on that Saturday that this Iran matter, or fear that this Iran matter, would somehow get wrapped into aid to the Nicaraguan resistance. What was the basis for that fear that you expressed on Saturday the 22nd? Secretary Schultz, because somebody had pointed out to me that the, I think it is, the Southern Air Transport was used in the Central American situation and also in terms of the flights of arms, and so I said, well, my gosh, if this gets connected, then we are going to have a problem with our policy in Central America.
But obviously that was not said to me. That was said to the committee here.
That was said to the committee here, yes.
But at no time in my conversation with Secretary Schultz did he ever raise the issue of Southern Air Transport.
Well, you don't believe that Mr. Hill's reflection of the Secretary's notes reflecting what the Secretary said at that meeting with you, the interview, that doesn't suggest another angle worries me, could get mixed up with help for freedom fighters in Nicaragua, one thing may be overlapping with another, may be a connection.
That refers to a political connection that enemies of the administration would love to wrap together, as he says here. It certainly does not suggest anything relating to Southern Air Transport or an actual connection.
Attorney General, moving on to a matter that the House Judiciary Committee was concerned with. As you will recall, the House Judiciary Committee on October 17th sent you a request that you apply for an independent counsel, and this was after the Hassenfuss crash, and you received a letter which was signed by a number of members. I was not one of the signatories, and you made reference to the fact that I hadn't signed it, but it did reflect what 17 members, a majority of the committee, a majority of the majority. And the officials named in that letter were Oliver North, John Poindexter, and William Casey. And this is Exhibit 13, if you want to see that letter, just to call it to your attention. That's the letter, Exhibit 13, and I don't think there's any need to go into that letter. It's a lengthy letter. And then the C-13, which crashed, was linked to Southern Air Transport, and that's reflected in Exhibit, I think it's Exhibit 12. And what I want to call to your attention is that on or about October 30th, 1986, you received a call from Admiral Poindexter to delay the investigation because Southern Air Transport was involved in the Iran arms sales. And John Poindexter made that request to delay that investigation. I'm a little puzzled because Poindexter was named in that letter and possibly a subject of any investigation that you might conduct. And I understand that there was a delay, and of course some reasons were recited. My question is this something that would be done under ordinary circumstances? An individual is named in a letter, could be the subject of a possible investigation, and yet a request is made to you and you delay the investigation for a period of days. You did resume it later on.
Well, he was not a subject of the investigation at that time. Indeed,
No, he was a subject of the letter,
right,
which was written to you, which could have, if there had been any basis, which could have led to an application for independent counsel. That was the request.
Possibly. I mean, that was the request. But at that time, we had looked into the letter, and the letter contained no real evidence. And at that time, we had requested from Mr. Conyers any evidence they might have that would enable us to even conduct the initial investigation.
Well, had you, Mr. Attorney General, I'm not clear on this, had you delayed the investigation, ordered the delay of the investigation before you received that? Because I'm not aware of that exchange between you and Chairman Conyers.
It was an exchange between the head of our Legislative Affairs Office and Mr. Conyers saying that we would request that whatever information they have that might be helpful be provided to us. But beyond that, at my knowledge at that time, and in fact the fact was that Admiral Poindexter was not the subject of any investigation.
Well, what you're saying is that you requested that Mr. Conyers and the committee furnish you with whatever information it might be. But the request was to the Attorney General, the Department of Justice, to inquire into this matter. Wasn't it your responsibility to do so?
Well, and indeed our people did, but and they were inquiring into the matter, but anytime we get something like this, we want to know what the basis is, and I think it was the feeling of our people who were looking into it that there was inadequate basis in the letter that was received.
Was that the reason for your ordering the...
No, that had nothing to do with it. What I'm saying is that there was no active investigation in which Admiral Poindexter was a subject at the time that he called me.
Mr. Attorney General, on November the 21st, you met with the President, Don Reagan, and Admiral Poindexter at 11:30 in the morning. And you were directed by the President at that time to conduct a fact-finding inquiry. Get to the bottom of this. Admiral Poindexter has testified that later that day, after being advised by you that the Justice Department was going to be coming to the NSC offices, he destroyed the December 19th, 1985 findings signed by the President and some other documents. Frankly, of course, I don't understand why the Admiral destroyed that document. Of course, and the reason why I asked that is because you had been with the President and Don Reagan, and you talked about fact-finding, and undoubtedly the President told you to get at the bottom of this and to conduct this fact-finding. Yet we've got Admiral Poindexter going right back and destroying this document, this very significant document. Any reason for that?
I don't understand it either.
Well, Admiral Poindexter did, in testifying before the committee, said that he took it upon himself because he considered that it might be politically embarrassing to the President, that these matters would then be revealed and it would be shown that the President might have been doing something contrary to often stated policies that he'd been against. And my question, since he said he wanted to save him from political embarrassment, was there any discussion that day when you were talking with the President about anything that might come up which might be embarrassing?
There certainly was no discussion about anything coming up that would be politically embarrassing. The only thing the President said that might even be related was, if you find anything wrong at all, we want to be sure to get it out.
And yet Admiral Poindexter, who had this very significant document, notwithstanding all of this, does go back and destroys a very significant document. And of course, you and I don't know the reason for it. Is that correct?
I don't know the reason. You've listened to his testimony, and presumably he gave reasons
Well,
here.
he stated that it was to spare the President any political embarrassment, so he made that decision. And of course, that's what we have to stand by and stand on. Let me ask you one other question, Mr. Attorney General, concerning concerning some of the letters that were sent out. Now, you learned of the diversion memorandum on November the 22nd. On November 24th, according to your testimony, you asked Cooper to do a preliminary review of possible criminal issues, and then on November 25th, you began a criminal inquiry. I want to ask, why were letters not sent to the White House, the CIA, and other agencies asking them then to segregate and preserve relevant documents? Why weren't they sent until November the 28th, 6 days later, actually? And that November the 28th, I might tell you, happens to be a Friday, which certainly would give any person who is interested in knowing that these requests were going to be made, give them an opportunity to destroy those documents. Why the delay?
Well, Mr. Rodino, first of all, as far as the White House documents, the NSC documents, a request for those to be sealed and preserved was sent on the 25th as soon as the criminal investigation was started, and telephonic direction was sent then. And I don't know any reason for the delay other than that in the normal process of this getting started. I think the 27th was Thanksgiving holiday. The criminal division started on the 25th. It was the 26th by the time they probably got their investigative plan going, and I imagine that's the reason why an additional day was involved.
I think, to be fair to you, I'm going to point out that I think those letters, some of those letters have been prepared, but somebody just goofed and didn't send them out for a couple of days.
Well, that I can't tell you, because I don't know anything about the preparation or the dispatch of those letters.
Well, let me ask you a final question. Mr. Attorney General, you talked a while ago about Poindexter, and we've heard that you felt it was unnecessary to ask him anything further because you'd heard all that you needed to know, apparently. And I'm wondering, however, and I'm going to refer you to your exhibit number 42. I'm wondering, however, in looking at exhibit number 42, which is a list of the interviews that you were going to conduct, and you have Mr. McFarland, Mr. Schultz, Mr. North, Mr. McMahon, Mr. Sporkin, CIA Associate Deputy Director for Operations, Mr. Thompson, Secretary Weinberger, Vice President, Deputy General Counsel CIA of Operation, and then another CIA. But there's no mention of Admiral Poindexter, and there's no mention of Director Casey.
No, and there's also no mention of Don Regan, no mention of the President on there. But I think that these are people that undoubtedly would have been talked to as well.
Well, I don't have any further questions, Mr. Attorney General. Just let me say in closing that I recognize that a good many of us, of course, have been puzzled by the manner in which this whole matter has been handled. And of course, you've come before us and you've explained, and some of us, of course, will still have questions. And I wonder whether or not, considering the fact that the President's credibility, as the polls indicate, has been damaged, why some of those key questions weren't really asked, in order that maybe this matter might have been disposed of way back then, right after November the 25th, after you had conducted your inquiry, if those key questions had been asked. And I think that, regrettably, the issue that's going to remain in the minds of many is just that. Why weren't key questions asked?
Well, Mr. Rodino, the key questions were asked, and as I've testified here innumerable times, the questions were asked: who knew about this? The answers were given by by Colonel North, that the three people who knew about it were Mr. McFarland, himself, and Mr. Poindexter. The question was asked of Admiral Poindexter, did he know about it? He said yes, which confirmed what Mr. North had told us, Colonel North had told us. We asked the Admiral Poindexter whether he told anyone else in the White House. He said no. All of the things that were the key questions, as you call them, were all answered in the course of our weekend fact-finding inquiry, and all of those answers have stood right down to today.
Well, thank you much.
Thank you.
Mr. McCullum is recognized. He has 30 minutes reserved.
Well, Mr. Chairman, thank you. I certainly hope I don't use the 30 minutes. I know, Mr. Attorney General, you should be aware that you are setting the record, and I hope it is the final record, as a matter of fact, for the lateness of the hour with which our hearings have been conducted in public session. We appreciate very much your enduring this with us. I want to just clarify a couple of things since you and I last talked earlier yesterday. One of the points that was just raised with you regarding your meeting with Secretary Schultz on the morning of the 22nd concerned the whole issue of what Secretary Schultz might have conveyed to you about the idea of a connection, putting the sort of the bug in your ear between the Iranian initiative and the Contra thing. And you very adequately, I think, explained that the Southern Air Transport subject never really came up in that. I think Mr. Sofair later discussed it with Mr. Cooper at some length a couple of nights later. But I think there's another point, because sometimes we pound on these days, the 21st, the 22nd, the 23rd, the 4 or 5 days you were involved in this. This was Saturday the 22nd. This was the day that you found the diversion memo. And it was just a few hours after this meeting with Secretary Schultz where he might have made that comment that you didn't draw a connection from but could have. Just a few hours later, you learned of the diversion memo because Mr. Reynolds had found it. So frankly, I don't know if you see it the way I do. Even if you missed something Secretary Schultz was trying to give you, it really wasn't material to this whole thing in the end. You found out about the diversion and the connection anyway, right?
That's correct, but I think and I agree with you that what Secretary Schultz was telling me had nothing to do with any actual connection between the two, but rather that our enemies, as he called them, or as at least Mr. Hill's notes call them, on the Hill, those who were opposed to administration policy, might try to take two unrelated subjects and use them, what had happened in the two, to hurt us. In other words, the Iranian initiative, Secretary Schultz viewed as a very bad thing, as we all know from his testimony, and he felt that there might be some spillover from that of the natural, what he viewed as the natural antagonism on the Hill for that might hurt us in what he was trying to achieve, which was assistance to the freedom fighters.
So he wasn't conveying to you an impression of the connection for the purposes of any suspicious activity. It's an entirely different thrust. And even, as I said, even had it been otherwise and the bell gone off, it didn't matter. It was only 6 hours before you found out about the diversion or something like that. Anyway, let me relate one other thing that came up in your questioning with Mr. Rodino. And I'd like you to refer back to this, and this is the testimony of Mr. Webster in his confirmation hearings. You had that a minute ago. Could you pull that back out again, please, Mr. General? I think that this issue is interesting. There's no question that your discussion with Mr. Webster about this subject was a fairly short period of time, but I don't think we ought to let the record go without having it very clear as to precisely what Mr. Webster was thinking about in connection with this, whether it was over a minute or two or whatever in your discussion. If you have that in front of you now, if you turn to these pages in here, I have in front of me, starting, I believe, on page 39, if you could turn to page 40, you mentioned on page 40 of that where Judge Webster said neither of us saw this as a criminal inquiry, down around line 16. I'd like for you to read for us and for anyone else who's observing and listening to this, line 25 on page 40 through line 13 on page 41. Do you see what I'm talking about? It says you
Yes,
can
sir.
always. Would you read what Judge Webster said to the Intelligence Committee reviewing his confirmation on this subject, just that paragraph?
He said you can always look back and ask, in light of what transpired, could the FBI agents have done a better job of conducting such an inquiry or looking for materials? I don't think we're in a position yet to know really the answers to that question. There is also the downside of sending FBI agents into the White House when there is no known criminal activity to investigate. So you can say, sure, maybe we knew better how to ask the questions, or maybe we knew better how to do something else, but it was not a criminal inquiry. The Attorney General took his own group of experienced attorneys from the Department of Justice, and I am just not able to say that in hindsight we could have done a better job than they did.
Thank you very much for reading that, Mr. Meese. I would like to ask unanimous consent, Mr. Chairman, to introduce into our record the pages from that testimony that were covered by myself and Mr. Rodino and the Attorney General, pages 39 through 43 that I have here. It was the testimony of April 8, 1987.
Will the gentleman yield?
I'd be glad to.
I hadn't made that request, and I asked the same unanimous consent request.
Without objection, so ordered.
Thank you. Now let me turn to an entirely unrelated matter. Yesterday, you testified before us at some length, and I was a little surprised this morning to learn from reading the Washington Post that you testified, according to them yesterday, that in your opinion, the National Security Council was covered by the Boland Amendment. I didn't hear that yesterday. I wondered if you could tell us, did you testify to that? Is that your opinion?
I don't believe that I did, and that's not my opinion. I don't believe that I testified on that subject at all.
Well,
I believe I testified that we had never been asked for an opinion as to whether or not the National Security Council staff was covered by the Boland Amendment.
Do you have one, an opinion?
I have, well, again, it goes back to which Boland Amendment. There are 5 of them. If you're referring to the period, and again, I'd have to look at the actual language, let me just say that we have not rendered a formal opinion on it.
I understand.
And so it would be important to know which of the Boland amendments we're talking about, because the language is very important. I gave an analysis of some language yesterday in another act in which it was the opinion of the Justice Department in a memorandum that I referred to that the National Security Council staff would be included under that particular provision.
Well, that was something else.
It's my understanding that the Boland Amendment has different language which perhaps would not apply to the National Security Council staff.
Well, I think we can, I don't have all of those sites in front of me, but the more current ones, 84 and 85 and 86 would be what we would be most interested in. Do you have an opinion that you can give us about any one of those? Did one of them was clearly not covering, in your opinion?
Well,
the National Security Council?
just so that it's understood that I am not giving a definitive legal opinion.
Understood.
But that I believe there is a proper view that can be taken of the fiscal year 1986 Boland Amendment, which says that funds available to the Central Intelligence Agency, the Department of Defense, or any other agency or entity of the United States involved in intelligence activities and so on may be obligated only as provided in certain sections of a classified schedule. The phrase entity of the United States involved in intelligence activities, in my opinion, the better view of that would be that would not include the National Security Council staff, inasmuch as the agencies involved in intelligence activities has a generally accepted definition in the intelligence community, and is even defined in statute and in executive orders as such agencies as the Central Intelligence Agency, the National Security Agency, the Defense Intelligence Agency, the offices within the Department of Defense for the collection of certain items, the Bureau of Intelligence and Research of the Department of State, intelligence elements of the Army, Navy, Air Force, and Marine Corps, and of the Federal Bureau of Investigation, the Department of the Treasury, and the Department of Energy, and also intelligence elements of the Drug Enforcement Administration. So that I think there is a generally accepted view of what are entities involved in intelligence activities. Now, that's as opposed to what I read yesterday, a separate statute which talks about intelligence activities and intelligence-related activities. I think that under the definition that's contained in the Boland Amendment, a proper view could be formed that the National Security Council staff would not be included within that definition. It is an issue, though, on which reasonable minds might differ.
Well, I appreciate your clarifying it, and the fiscal year 1986, the year for which you made that comment to us just then, of your own opinion and interpretation, is the most pertinent year. That is the year when all of this activity took place that Colonel North and Admiral Poindexter and everybody else has been criticized for. So I think that is extremely important, at least to have on the record your own opinion, granted you didn't do it formally.
I appreciate your correcting the newspaper account, because it's very clear that I did not say that the Boland Amendment applies to the National Security Council staff. That may be included tomorrow in the corrections page of the Washington Post.
I hope it's at least on the corrections page, if not somewhere else. I hope they're still here. I think one night I brought something up and a reporter said he wasn't still here, but I think they probably will be for that one. Let me ask you about another matter. I think that it's important that these hearings wind up on a positive note of things that this committee can recommend in the way of changes, in the way of new policy, in the way of new legislation, if it's appropriate, to try to further the cause of keeping the type of things from happening that we find in this instance did with regard to the Iran-Contra initiative. And the whole of one area, the Iranian initiative itself, deals with hostages, deals with terrorists who took those hostages, deals with the testimony we've had over a period of days about the fact that there was this matter of the hostages pressing on the mind of the President and on everybody's concern here. And there's been a lot of discussion about there not being any real alternatives being offered other than the arms for hostage deal, which none of us, certainly in hindsight, nobody, I think, really thought was such a hot idea. But apparently rescuing the hostages wasn't feasible for one reason or another, according to testimony we've had. And it brings me to something that I think is much more down your alley than the abstract or the foreign policy discussions, though you certainly have a background to do that. And that's the issue of terrorism in the law and terrorism in general. I don't know if you've read it or not, but when Admiral Poindexter was testifying, he said that on the way back from Europe, I believe, in May of last year, the President had read the book by Benjamin Netanyahu, Terrorism, How the West Can Win. I don't know if you've read that book. Have you read this book? Do you know what I'm talking about?
Yes, sir. I have the book, and I have read at least parts of it.
Well, this gentleman, if anybody doesn't know that, and maybe the public does not, is a current Israeli representative to the United Nations. He's a rather famous figure, formerly here in Washington with us. And it's a highly sensitive book. I think a very good discussion in it. At one point in there, he defines it. Terrorism is the deliberate and systematic murder, maiming, and menacing of the innocent to inspire fear for political ends. Now, that is a definition from the Jonathan Institute, named after his brother, that was founded over in Israel, and it comes from 1979, I believe. The reason I raise it with you is that I remember, because of my hat on the Judiciary Committee, that we've been trying for some time, and you've been trying to come up with some new laws dealing with terrorism. And defining terrorism has been pretty tough. Are you supportive of some law changes in this area that would get us into a better position, in this country at least, to deal with terrorism, to redefine that?
Yes, Mr. McCullum, we are. We have achieved some new laws that have been helpful. There are others, I believe, that that could be enacted, which would further the cause against terrorism. I'm very much impressed with the recommendations and the suggestions that Ambassador Netanyahu makes in his book. He's a friend of mine, a man that I respect greatly, particularly for his knowledge of terrorism, and he and I have participated in a number of seminars and panels together.
Well, I think this committee would be very appreciative if before we adjourn or even afterwards, you could participate in any kind of suggestions or have your department do that to us on any way that we could recommend. We cannot enact legislation, but we can recommend it, and we're going to be deliberating that. And if you wouldn't mind sending it up here, I think all of us would appreciate it. I have another book I'd like to recommend that people read. It's called The War Against the Terrorist, How to Win It, by Gail Rivers. And this particular book is a book that is written by a fellow who was engaged in anti-terrorist activities. And he explains in that book, and I'm certainly not going to do a book review, but he explains in that book about how we've got real problems in conducting anti-terrorist activities because we don't take the steps that others have taken in the past to get tough in preemptive ways in dealing with terrorists. And that's a lot about the same type of thing Netanyahu suggests in his book. Well, the point of that is that I'm disturbed by something I want to call to your attention. It is an provision in an executive order we've been chatting about for some time. It's Executive Order 12333. That's been brought up here in this hearing series a number of times, in fact, earlier today with you. Under a section of that, 2.11, there is the language that reads, prohibition on assassination. No person employed by or acting on behalf of the United States government shall engage in or conspire to engage in assassination. Well, on the surface of that, that sounds like something everybody would support, and it's in that executive order. I am concerned about its application, though, because of the very nature of terrorism and whether it's not a problem for us. And I don't expect a definitive opinion out of you this evening, but I want to ask a question or two. In your judgment, Mr. Attorney General, does that executive order prohibition, do you have a copy of that? Are you familiar with that?
Yes, I do. I have it, and I'm familiar with it.
Does that apply in wartime to our military?
I believe that it would apply in the sense of, and again, I would have to look at the entire context, and I don't view this as a legal opinion.
I understand. I wouldn't hold you to that.
I would expect that it would apply in general in a wartime situation as well as otherwise. I would also say that an act of war properly declared by the Congress would not be considered assassination. In other words, the killing of a person, an enemy, would not be viewed as assassination and come within the prohibition here.
But it does apply to military personnel by it's a very broad definition, doesn't it? I mean, it would include the defense intelligence agents and the military personnel, at least in peacetime, would it not?
In my opinion, it would, yes. But in my opinion, that an act against a hostile power would not come within the definition of assassination in a legal sense.
All right, let's talk for a minute about something more specific that bothers me about it than that, because I do think that we have a war on terrorism, and it's always a question legally, how do you, a war, if we declare it, it's pretty well defined, but a war on terrorism is like the war on drugs is kind of a logo. It doesn't have a real good legal definition. If you're talking about a preemptive effort against terrorists, you're talking not just about something like with a country. You're talking, if you listen to Netanyahu's definition, not about another country, but probably about individuals out there, as we've seen in the Middle East, who take our hostages or do things. Does the language in this executive order prohibit the President from sending in or prohibit our military or anyone else from going in a preemptive manner against a terrorist, known terrorist group, and, if you will, eliminating them? If it's not another government.
Well, Mr. McCullum, it certainly has not prohibited or prevented the President from taking appropriate action against terrorists in regard to the Libyan action that was taken, for example. And to the best of my knowledge, this has never been a hindrance to taking appropriate action against actual terrorists. If there were a problem with it, then we would discuss perhaps amendment of the executive order.
And the President can do that without our intervention, I know, if he has to. But one last thing on the thing that really bothers me about it is it's come to my attention, and I would appreciate it if you check into it in your own way and so forth, that there are some in our government offices who have been very restrained about even giving assistance to other governments in certain areas because of the fear that this is would be violated by the activities of the other governments who are fighting terrorism. Again, all I can do is ask that you look into it. It is on its face something we'd all support in general, but when it comes to how broadly it's interpreted in terms of fighting terrorism, it could present problems as I see it. And if you have any more thoughts about it, please give them to us.
Well, Mr. McCollum, I think that the prohibition against assassination is a very important part of our general application of human rights policies and of maintaining a high moral ground, even in the battle against terrorism. I do not believe that it has been a hindrance to our country in taking proper and appropriate actions. And indeed, it I think, squares with the concepts in Ambassador Netanyahu's book, where he talks about inflicting violence upon, in effect, civilians, innocent people. I think that appropriate measures can be taken to apprehend or to cope with terrorists without in any way running afoul of this particular provision in the executive order.
Well, Mr. Attorney General, I respect that. As a lawyer and as somebody who's wrestled with this, I would have to agree morally in many ways that's true. I have a question of where the moral line is drawn with the war on terrorism in my own mind. I'm not advocating assassination, but I'm wondering if we are not overly interpreting that or having some of our people do it more broadly than it should be out of fear of violating it. That's really my concern. Let me raise one other subject with you, one last subject, and that's the question of leaks. We have discussed leaks for a long time in this hearing, and I have looked at, and several of us have looked at, the laws regarding the crimes that are on the books now for somebody who discloses or releases sensitive information. My understanding that Mr. Casey, some years ago, sent up to the Hill some proposed revisions in the law that would close down some loopholes and would indeed make it a much tougher thing to defend against if somebody leaked sensitive and classified information, if especially they were officials or employees of the federal government. Several of us, I'm going to introduce a bill tomorrow, several of us have gotten together on an idea that's not perfect by any means. And I'm hopeful that whether it's that or some other legislative version, that our committee will recommend some legislation to batten down the hatches, so to speak, on this whole issue of leaks. Do they concern you in general within the administration as much as they seem to concern other people that have been before us?
Well, Mr. McCollum, I am very much concerned about the unauthorized disclosure of classified information, which you refer to in generic terms as leaks. I think we have a serious problem. I think there are a number of things that ought to happen. First of all, I think we have far too much classified information. I've talked about that for the entire 7 years I've been in Washington. Too many things are classified. As a result, nobody pays much attention to classified information in some circles. I'm not saying that that's true of the committee, certainly, or the intelligence committees. But it to me is a very bothersome thing that we have so much classified information, or that so much information is classified. Secondly, I think too many people have access to classified information, and if there were less of it, we wouldn't need as many people given access to it. And thirdly, I think the things that really ought to be classified, those things that seriously would affect the vital national interests of the United States, if they were revealed, should have a very high degree of protection and a very high degree of penalty for those who permit or participate in unauthorized disclosures. So I think the kinds of steps that you're suggesting, along with those that I've mentioned here, would be very important and very valuable as far as taking what really needs to be secret and making sure that that is a limited quantity of material and that it is properly protected. I agree with you entirely.
Well, the bill I'm going to introduce tomorrow is certainly not perfect, and I hope, and in fact I invite any of my colleagues to join in co-sponsoring it, but it's going to need to be perfected. We're going to need to do a lot. It's just a working product for discussion. we would appreciate it, I would appreciate it if you'd not only comment on it, but get your staff to help us work on it to make sure that we do a good job in whatever we recommend in the end, assuming that we do. Would you be willing to do that?
I'd be happy to do that.
When I got done talking with you yesterday, I got all kinds of calls in my office about fly specking. People want to know what in the world that was. I really didn't realize how long ago it had been since lawyers gave legal opinions, title opinions on real property and house clothes. They all give insurance. You know, you get title insurance, you buy a home now. But that old archaic word, now I guess archaic, in the law profession dealt with looking at the minutiae. You know, some lawyer found in the title opinion that the period wasn't there, or the Mr. was left off and it wasn't carried on to the next deed, then he could, if he wanted to, raise all kinds of problems for people. But in reality, those things were easily cleared up, and you just had to go back into court or file another paper or whatever and get rid of it. And I meant it then, and I mean it now. It seems to me, despite all of these hours you spent till after 8 o'clock tonight with us today and all day yesterday, and while you've done a good job, I think, of helping us in many ways, when it's all said and done, there's been very little other than fly specking in the way of criticism that has been found, or fault that's been found, with you and what your staff did in working on the, whatever you call it, fact-finding or investigation over those 4 or 5 days of November 20th through the 25th. And while we may all look back in 40/40 hindsight, I think it's a lot like Judge Webster said when you read from what he was testifying before the Intelligence Committee in his confirmation hearings. We just simply might do it differently, but it's unlikely we would have done it very differently. And you did one darn good job as far as this member is concerned, and I think I speak for most of the panel. We appreciate very much your coming up here. Thank you very much.
Thank you, Mr. McCollum.
Thank you, Mr. Chairman.
Thank you very much, Congressman. Mr. Attorney General, originally I had intended to yield the balance of my time to Mr. Thomas McGough, Committee Counsel. I have asked him to submit to you questions which I felt would clear the air and give you an opportunity to take a cloud which is presently, I believe, resting over your head. However, I've decided to, after listening to some of your responses, to ask a few questions myself. So I'll just ask Mr. McGough to submit to you questions for your response in writing. But if you may, Mr. McGough, can you just describe the questions or the nature of the question to the Attorney General?
Well, Mr. General Meese, we were going to explore just for a few minutes the allegations that had been made about interference or an attempt to deflect or stall criminal investigations in the Southern District of Florida that have been reported in the press, and we were going to go through a few of those. But if we have any additional questions on that, I'll submit them to you. And,
I understand that that matter has been thoroughly cleared up by the depositions that have been received from the attorneys, and that it is proved conclusively that any such allegations are absolutely false. I understand that there is depositions to that effect, and if you wish to make them public, I would certainly encourage that.
Thank you, Mr. Chairman.
Thank you. Mr. Attorney General, I must say that I was a bit surprised and quite distressed with your response to questions asked by Mr. McCollum. As the Chief Law Enforcement Officer of the United States, are you suggesting, or is it your opinion, that once the 1986 Boland Amendment was passed, setting forth certain activities that are forbidden to the CIA, the NSA, and others, that the NSC could have assumed these forbidden functions without violating the law?
Well, Mr. Chairman, the question was directed to me as to whether the Boland Amendment applied to the NSC staff. I indicated that this was an issue on which we had not rendered an opinion in the Justice Department. I also indicated that if you look at the language, it is possible to make a strong case for the fact that the Boland Amendment does not apply to the NSC staff. Whether it would be wise for the NSC staff to pursue things which were forbidden as you call it, to the CIA and other entities of government is a question of policy rather than of law. But if the Boland Amendment does not apply to the NSC staff, then they would not be included within the prohibitions.
Are you telling us that the staff of the National Security Council can carry out functions that are forbidden to the CIA without evading the laws of the lands of the United States?
If the law doesn't apply to them, then they can without violating the law, obviously. That's a tautology. And when I say the law doesn't apply to them, the law by its language does not include them.
But if an agent of the CIA carried it out, that would have been a violation of the law.
Because the law applies to the CIA by its very terms. But the law, by its terms, only applies to the CIA, I believe the Defense Department, and entities of the government involved in intelligence activities. Normally, under the list that I read to you, that is not normally deemed to include the National Security Council staff.
Even if they carried out intelligence activities, covert activities?
Well, it would depend again on the circumstances. It's a hypothetical question. But by the language there, I think a good case can be made that Congress, in its enactment of that law, did not include the National Security Council staff within the purview of the agencies that are listed in that section as involved in the prohibition.
Did not Mr. McFarland, when he was the director of the agency, communicate by letter with Mr. Hamilton, chairman of the Intelligence Committee, to the effect that the Boland Amendment did apply to the National Security Council?
Well, again, I don't know, because I don't know the letter. I don't know which Boland Amendment. Remember, we're talking about 5 different Boland Amendments.
Then, in other words, from what you're telling me, employees of the Department of Agriculture could have done the same thing without evading the law.
I think that it's entirely possible that as the...
To carry out covert activities?
That as the law is written here, where it says funds available to the Central Intelligence Agency, the Department of Defense, or any other agency or entity of the United States involved in intelligence activities may be obligated and expended only as authorized in specific sections. Now, as I read that, as I said earlier, a strong case can be made, I think, that that does not apply to the Agriculture Department, that it doesn't apply to Health and Human Services, and a number of other entities which are not involved in intelligence activities.
But if some agent of the Department of Agriculture involved himself with the approval of the President in some covert activity, would that law apply to him?
By its language, it does not appear to.
Then the Boland Amendment can be evaded very easily.
I don't think it would be an evasion if the law itself doesn't apply to a particular entity. It certainly would not be an evasion.
Yes.
Just like to state, I know that's been the subject of a lot of discussion and debate, and I don't want to attempt to debate it with the Attorney General. I merely want to state that there is another point of view.
Yes, sir, and I acknowledged that earlier.
Answered, which is that the Boland Amendment proscribed certain activities by persons in 2 categories. The first is those identified by name of agency, and there are 2, and the other is by activity, those engaged in intelligence activities. I believe the point the Chairman is making, to which I subscribe, but which I recognize is not everyone agrees to, is that if an official of the United States is in fact engaged in intelligence activities, then that person is covered by the Act regardless of which agency he happens to be working for or whose payroll he is on. Now, I'm not asking you to agree or disagree with that, but I personally feel any other interpretation of the law, such as the one you have made, would not be accepted by any court because it would render the law meaningless. And I believe it's a fundamental principle of construction by the courts that they will not accept a construction which renders a law meaningless, because the definition, the interpretation you provided would mean that all that would have to be done would be to circumvent the law, would be for the President or the Director of the CIA to say to a half a dozen people who are engaged in such activities which the law intended them not to engage in, say, well, you go over and sit in the Agriculture Department, put yourself on the Agriculture Department payroll, continue to do the activities which you're now doing, and you will then not be covered by the law. And I think that it is a matter of interpretation. You've expressed one view. I think it's important that it be clear that there's another point of view on that, which says, essentially, and I repeat myself now, that the coverage is defined not only by name of agency, but by activity. And a person cannot evade it by moving from one agency to another and still engage in the proscribed activity. Thank you, Mr. Chairman.
Be happy to.
Mr. Chairman, I guess this has been my baby, and all through these hearings we've been hearing about it. And we've constantly heard witnesses before this committee testifying to the confusion, the ambiguity of the Boland amendments. There have been, as the Attorney General has said, a few of them. But there are really only two. There are really only two that are important. And that is Boland number 3, Section 8066 of the Department of Defense Appropriation Act for fiscal year 1985. And this is where the full prohibition on support for military activity. Very simple and very clear. And that was in effect from October 1st of 1984 through December 19th of 1985. And let me read it. You've read it, and there's been a reference to it, and let me read it in full. During fiscal year 1985, no funds available to the Central Intelligence Agency, the Department of Defense, or any other agency or entity of the United States involved in intelligence activities may be obligated or expended for the purpose or which would have the effect of supporting, directly or indirectly, military or paramilitary operations in Nicaragua by any nation, group, organization, movement, or individual. That is the effective full prohibition, Boland number 3. Let me go to Boland number 4. Boland number 4 is Section 105 of the Intelligence Authorization Act for 1986. It permitted humanitarian aid, communication support, intelligence sharing, infrastructure expenditure, but no expenditure for lethal equipment. It did permit the exchange of intelligence information, communication equipment, infrastructure support. It was clear from the debate on the floor that it would not permit military equipment. Very clear. And let me now read from executive order. I presume an executive order is the law of the land until it's overturned or until some other law is passed or until it expires. This was signed by the President on December 4th of 1981. Let me read the purpose. The purpose of the National Security Council, which was established by the National Security Act of 1947, is to advise the President with respect to the integration of domestic, foreign, and military policies relating to the national security. The National Security Council, the NSC, shall act as the highest executive branch entity that provides review of, guidance for, and direction to the conduct of all national foreign intelligence, counterintelligence, and special activities and attendant policies and programs. And I take direction to mean more than just a supervision, more than a coordination. I take it to mean a direction and a special activity in which the NSC might very well become involved. And this was a special activity. This covert action was a special activity run completely and almost solely by the National Security Council. Is there any question about that? And incidentally, the National Security Advisor, one of them indicated that the Boland Amendment did apply to the NSC, and so did a former director of the CIA, Admiral Turner. I know there has been opinions on both sides of these questions, But this is very plain English, both the language of the Boland amendments, the two that are important, and also the language of the executive order that was signed by President Reagan on December 4th of 1981. So you can have your opinion on whether or not the NSC is engaged in intelligence activity, but clearly, the purpose as outlined in that executive order clearly indicates that the NSC does engage in intelligence activity and is an entity of intelligence.
Senator Rudman.
Well, Mr. Boland, if I could just say this, I feel like I've kind of gotten in the middle of an internecine warfare here. But let me just say this. It is personally my view that the NSC staff should not be involved in intelligence activities. Direction, coordination, tasking, those kinds of things are a proper role. But I think one of the problems that we've had here that you've been discussing is the NSC staff getting involved in either intelligence or operations, and that's something I would not recommend.
Mr. Attorney General, if the administration was so unhappy with the Boland amendments, why did it not suggest vetoing the bill in which the first Boland amendment was contained, the continuing resolution?
Mr. Boland, I have not indicated, frankly, a policy position one way or the other on the Boland amendments. This is something that I have not been asked my opinion on by anyone in the administration, as I mentioned earlier.
You're the chief law enforcement of the United States.
But I would say one thing.
You interpret the law for the administration that is in power. You interpret the law for the president or any of the departments and agencies that look for an opinion from you, do you not?
Certainly we do. And
we never asked for an opinion on this amendment?
No, sir, I was not.
Or the Intelligence Authorization Act?
I'm not sure about the Intelligence Authorization Act. We've never been asked for an opinion that I know of on the Boland Amendment, on what you read. On the other hand, I do think that it is proper to have the President have the opportunity to veto or approve such a bill, and that's why I think that it should not be attached to an appropriations measure, but rather should be sent as a freestanding bill to the President so he can act on it and not have it as part of a continuing resolution, an appropriations bill, or something else in which he cannot really exercise his free, unfettered judgment. I would certainly think that that would be an excellent suggestion that I would offer to this committee, that measures such as this be sent to the President as freestanding bills so that he can give it his unfettered judgment.
Well, the President took the opportunity to veto a continuing resolution back in 1981, and his reason for that was that there was too much spending in the CR. He could have easily vetoed the Appropriation Act for 1984, in which the Boland Amendment was contained, but he sought not to do so.
Senator Rudman.
Chairman, I don't think we ought to end quite on this note, and the Attorney General, I think, came close to answering a question that I was going to ask, but I think I'll just ask it another way. You know, the whole argument about the Boland Amendment really would make a great bar exam question. But we're not talking about bar exams. And the point I want to make, Mr. Attorney General, I assume you would agree with me from what you said a few moments ago, that other than looking at the strict structure of a particular statute passed by the Congress, that when you look at the intent of the Congress, you have to deal in good faith with that intent. Is that not so?
That's correct, Senator.
And I assume that, you know, so we don't leave here with a story appearing stating something that you don't believe. Your opinion on Boland is your opinion. Probably get 100 lawyers, you might get, 80 opinions. But the point I want to make is that certainly you would not advocate trying to evade or avoid the impact of a law by the kind of means that some have suggested could be carried out, such as putting it in the Department of Agriculture or the DEA or whatever. You certainly, that is not a policy you as the Attorney General would advise, I assume.
Absolutely not. And furthermore, as I said earlier, this is something on which we have not rendered an opinion, and I have not rendered an opinion, and I was answering a specific question, and the real answer is that I did not say yesterday that the Boland Amendment applies to the NSC staff, nor have we rendered an opinion on the subject, and I was asked whether you could make a case that it did not apply. I think you can make a case that it could not apply. As Senator Mitchell says, you can also make a case that it does apply.
That's a whole separate
but this
issue.
This is a whole hypothetical situation, which I think really is, if I may be permitted an observation, is probably wasting the time of this committee at this point.
Well, I would expect so, but I don't think the record ought to indicate that you're advocating subtle avoidance or evasion of the law by reading statutes so closely and so carefully that we find ways to frustrate what is the obvious intent of any amendment, be it Boland or anything else.
I've indicated that that is correct, that is my view. We should not be trying by unusual techniques or tricks to evade the intent of Congress, just as I feel that the President ought to have the opportunity to approve or veto these measures on their own merits and not as a part of a lot of omnibus legislation.
Mr. Attorney General, I have one other matter that has bothered me in listening to your responses. You spoke very eloquently and very charitably about Admiral Poindexter and Colonel North and their military records. You suggested that if the Admiral had not taken the assignment in the National Security Council, he would very likely have been a top candidate for the Chief of Naval Operations. And then you spoke of Colonel North's courageous battle records in Vietnam. I hope that as the Chief Law Enforcement Officer of the United States, you are not suggesting to us that persons with good military records be exempt from laws relating to lying to the Attorney General or lying to the Congress? Should they be exempt?
No, sir. No one should be exempt for any of their acts. What I said earlier, and I think it's important that it not be taken out of context, was explaining why I have respect for these two gentlemen and the fact that you have to take their entire career into account and not just a particular segment of it when making a judgment on a human being.
But your opinion now is that they should not be exempt from the laws of the land.
I don't think that anyone should be exempt from the laws of the land, from the President on down, and I think that's the view of the President as well.
That pleases me, sir. With that note, yes.
I just want to extend my thanks to you, Mr. Attorney General, for your appearance, and to say that I appreciate particularly your willingness to offer some help as we move into what we hope will be a more constructive phase of the committee's operation. And to raise one problem with you, I noted earlier that you said that you wanted to cooperate fully with the committee, and I want to say that I think the cooperation of the administration has been very good, and we've appreciated it. However, we have had some problems in getting documents from the Department of Justice, and we have not had problems in getting documents from other agencies and departments. So I would appreciate very much if you would check carefully on that point. There are still some documents that we have requested that we have not yet received, and that request has been rather long-standing, and I know it's your intention to cooperate and to provide the documents. So if you would check on that for us, we would appreciate it, sir. And we thank you for your appearance over these several hours. Yeah.
Thank you, Mr. Hamilton, Chairman Hamilton, Chairman Inouye. I want to thank both of you, and particularly thank the committee for their courtesy to me in continuing the meeting tonight so that we can conclude these sessions today as far as I'm concerned.
I'd like to join Chairman Hamilton in thanking you for your patience. You have responded to our questions in good grace, and we're most appreciative. It's been a long, long day, and I think the time has come for us to call this to a halt. We thank you again. I'd like to call the session in recess and announce that tomorrow morning we will meet here at 9 a.m. to receive the testimony of Ronald Reagan, former Chief of Staff of the White House.